Welcome to the Ada K Show. I'm your host, Ada K, and I am a criminal justice major. I am also a deaf courtroom commentator, breaking down the gripping courtroom drama while providing full ASL interpretation, making justice accessible to everyone. Grab a cup of Java and let's dive in. And don't forget, comment, like, and subscribe. And if you love this channel, please become a member.
Good morning, everybody. This is June. As you can tell, I am not Ada. Ada is still down today. She will be lurking in the background, so she will pop in every once in a while. Um, so Angela and I are here to hopefully bring you a good stream. And today we have a couple of different things on tap. The first one is yes, we are going to do the Brian Walsh stream court hearing. And then also, when they come into session, we will be doing the Ian Mitcham case. And in between, or at the end, we are also going to be covering the Dustin Duran sentencing hearing today. So we have a full plate, we have a good show, and we hope you all will appreciate and ride with us. Please let me know if I have any sound issue. I have been working on it, and I hope that I've got a lot of that hopefully cleared up more. So, without further ado, we're going to go into the court with Brian Walsh. Uh, and I hope we find you all with a good cup of coffee, tea, or whatever your drink is, and you're all doing very well. So, let me get this going for us.
In the matter of the Commonwealth versus Brian Walsh, Norfolk Indictment 2023-0091, continuation of jury trial. Counsel is present in court. Counsel starting with the Commonwealth. Kindly identify yourselves for the court and the record.
Good morning, Your Honor. Greg Connor for the Commonwealth.
Good morning. Good morning, Your Honor. Ann Yass for the Commonwealth.
Good morning, Your Honor. Tracy Cusick for the Commonwealth.
Good morning, Your Honor. Good morning, everyone. Kelly Porges on behalf of Mr. Walsh.
Good morning, Your Honor. Larry Tippett.
Good morning. We need the defendant.
Your Honor, for the record, the defendant's present in the courtroom.
Thank you, Madam Clerk. All right. At the close of yesterday's day, the defense raised with me
what I have listed as 5 separate issues that it wanted to alert the court to with regard to the expected testimony of Mr. Walsh today. As an initial matter, does the defense still intend to call Mr. Walsh today? You do not? All right. Does that moot every issue that I researched last night?
I apologize.
No, I just want to make sure that the 5 issues that you raised and the issue with regard to the plea are no longer on the table. All right. I will conduct a colloquy with the defendant then now, and my intention is to defense intend to call any other witnesses.
You're not.
All right, then we'll close tomorrow. We'll do the charge conference immediately after the rest of the day. Let me just put in the record, so the record is complete. The Commonwealth previously, and I ruled on this at the side of the bench previously, the Commonwealth previously asked this court to exclude the defendant's plea of guilty. And I guess the only way that would come in at this point is if he were testifying. But I just want to put in, to the extent that I previously disallowed the defendant to go there with any other witness, and I frankly don't recall if I have previously. I want to put in the reason why I excluded. I did file a motion to eliminate to exclude evidence that the defendant pled guilty to misleading the police into Anna Walsh's disappearance and improper
Okay, folks, give me just a moment here, please. Okay, folks, give me just a moment here, please.
innocent of the accused without regard to probable punishment. To inform jurors of a sentencing consequence of their verdicts is to invite a results-oriented verdict and possible deviation from the basic issues of the defendant's guilt or innocence. I also cite to Commonwealth versus Sanchez, 70 Mass Appellate Court, 699-701, 2007. While the defendant here is not seeking to enter evidence of the possible consequences of a guilty verdict on the murder charge, the rationale behind the holding an a juvenile applies with equal force. If the defendant, a defense was permitted to tell the jury that he pled guilty to the two lesser charges, there is a risk, substantial risk, that the jurors will consider the defendant's impending punishment on those charges when determining his guilt on the remaining murder charge. Indeed, the defendant has not offered any other rationale for the entrance of such evidence. And as was stated in Commonwealth versus Ferreira, 373 Mass 116, 124, 1977 case, the jury's function is not to weigh possible verdicts with an eye towards dispensing mercy in certain cases or imposing heavier penalties in others. Rather, the jury's function is solely one of fact-finding with respect to the legal standards regarding innocence or guilt. Accordingly, the defendant is not permitted and has not been permitted to put evidence before the jury of his prior guilty pleas in this matter. Madam Clerk alerted me to also file this morning 321, pause, the Commonwealth supplemental motion to eliminate to exclude witnesses. All right, then we'll close tomorrow. We'll do the charge conference immediately after the rest of the day. Let me just put in the record, so the record is complete. The Commonwealth previously, and I ruled on this at the side of the bench previously, the Commonwealth previously asked this court to exclude the defendant's plea of guilty. And I guess the only way that would come in at this point is if he were testifying. But I just want to put in, to the extent that I previously disallowed the defendant to go there with any other witness, and I frankly don't recall if I have previously, I want to put in the reason why I excluded that testimony now. The Commonwealth did file a motion to eliminate to exclude evidence that the defendant pled guilty to misleading the police into Anna Walsh's disappearance and improper disposal of her body. After consideration, I allowed and still am allowing the Commonwealth's motion for two reasons. First, the defendant has failed to show how such evidence is relevant to the remaining charge of murder. And I specifically acknowledge that I read this morning the defense's motion to admit the evidence of his guilty plea, which has been docketed as 216. That was filed on December 11th, 2025, this morning, I believe. I have read it, but it doesn't do anything more than to set forth the elements of the crimes of murder. Based on defense counsel's opening statement, it appeared that the defendant was going to testify in this trial. And at that time, he could have made reference to his plea if I so allowed him to. But whether or not he is charged or pled guilty to such actions relating to his prior plea of guilty before this court is irrelevant to whether he murdered his wife. Second, the inclusion of the evidence of the defendant's guilty plea on the two charges would risk the introduction of extraneous factors as part of the jury's consideration on the murder charge. As explained by the SJC in Commonwealth versus a juvenile, 396 Mass 108, 112, it's well established that a jury's verdict must be based solely on the evidence in the case without regard to the possible consequences of their decision. And there's a specific instruction in my draft jury instructions that addresses this. Continuing with this case, the role of the jury is to make findings of fact and determine the guilt or innocence of the accused without regard to probable punishment. To to inform jurors of a sentencing consequence of their verdicts is to invite a results-oriented verdict and possible deviation from the basic issues of the defendant's guilt or innocence. I also cite to Commonwealth versus Sanchez, 70 Mass Appellate Court, 699-701, 2007. While the defendant here is not seeking to enter evidence of the possible consequences of a guilty verdict on the murder charge, the rationale behind the holding an a juvenile applies with equal force. If the defendant, a defense was permitted to tell the jury that he pled guilty
You want? In the matter of the Commonwealth versus Brian Walshe, Norfolk indictment 2023-0091, continuation of jury trial. Counsel is present in court. Counsel, starting with the Commonwealth, kindly identify yourselves for the court and the record.
Good morning, Your Honor. Greg Connor for the Commonwealth.
Good morning.
Good morning, Your Honor. Ann Yas for the Commonwealth.
Morning, Your Honor. Tracy Cusick for the Commonwealth.
Good morning, Your Honor. Good morning, everyone. Kelly Porges on behalf of Mr. Walsh.
Morning, Your Honor. Larry Tippett.
Morning, we need the defendant.
Thank you, gentlemen.
Your Honor, for the record, the defendant's present in the courtroom.
Thank you, Madam Clerk.
Thank you.
All right, at the close of yesterday's day, the defense raised with me what I have listed as 5 separate issues that it wanted to alert the court to with regard to the expected testimony of Mr. Walsh today. As an initial matter, does the defense still intend to call Mr. Walsh today?
We do not.
You do not? All right. Does that moot every issue that I researched last night?
I apologize, sir.
No, I just want to make sure that the 5 issues that you raised and the issue with regard to the plea are no longer on the table. All right. I will conduct a colloquy with the defendant then now, and my intention is the defense intend to call any other witnesses.
We are not.
All right, then we'll close tomorrow. We'll do the charge conference immediately after the rest of the day. Let me just put in the record, so the record is complete. The Commonwealth previously, and I ruled on this at the side of the bench previously, the Commonwealth previously asked this court to exclude the defendant's plea of guilty. And I guess the only way that would come in at this point is if he were testifying. But I just want to put in, to the extent that I previously disallowed the defendant to go there with any other witness, and I frankly don't recall if I have previously, I want to put in the reason why I excluded that testimony now. The Commonwealth did file a motion to eliminate to exclude evidence that the defendant pled guilty to misleading the police into Anna Walsh's disappearance and improper disposal of her body. After consideration, I allowed and still am allowing the Commonwealth's motion for 2 reasons. First, the defendant has failed to show how such evidence is relevant to the remaining charge of murder. And I specifically acknowledge that I read this morning the defense's motion to admit the evidence of his guilty plea, which has been docketed as 216. That was filed on December 11th, 2025, this morning, I believe. I have read it, but it doesn't do anything more than to set forth the elements of the crimes of murder. Based on defense counsel's opening statement, it appeared that the defendant was going to testify in this trial. And at that time, he could have made reference to his plea if I so allowed him to. But whether or not he is charged or pled guilty to such actions relating to his prior plea of guilty before this court is irrelevant to whether he murdered his wife. Second, the inclusion of the evidence of the defendant's guilty plea on the two charges would risk the introduction of extraneous factors as part of the jury's consideration on the murder charge. As explained by the SJC in Commonwealth versus A Juvenile, 396 Mass 108, 112, it's well established that a jury's verdict must be based solely on the evidence in the case without regard to the possible consequences of their decision. And there's a specific instruction in my draft jury instructions that addresses this. Continuing with this case, the role of the jury is to make findings of fact and determine the guilt or innocence of the accused without regard to probable punishment. To inform jurors of a sentencing consequence of their verdicts is to invite a results-oriented verdict and possible deviation from the basic issues of the defendant's guilt or innocence. I also cite to Commonwealth versus Sanchez, 70 Mass Appellate Court, 699-701, 2007. While the defendant here is not seeking to enter evidence of the possible consequences of a guilty verdict on the murder charge, the rationale behind the holding in A Juvenile applies with equal force. If the defendant, the defense was permitted to tell the jury that he pled guilty to the two lesser charges, there is a risk, substantial risk, that the jurors will consider the defendant's impending punishment on those charges when determining his guilt on the remaining murder charge. Indeed, the defendant has not offered any other rationale for the entrance of such evidence. And as was stated in Commonwealth versus Ferreira, 373 Mass 116, 124, 1977 case, the jury's function is not to weigh possible verdicts with an eye towards dispensing mercy in certain cases or imposing heavier penalties in others. Rather, the jury's function is solely one of fact-finding with respect to the legal standards regarding innocence or guilt. Accordingly, the defendant is not permitted and has not been permitted to put evidence before the jury of his prior guilty pleas in this matter. And Madam Clerk alerted me to also file this morning 321, pause, the Commonwealth supplemental motion to eliminate to exclude evidence of the November 2025 guilty plea, which I will concede I did not read because I just got it when I stepped on the bench, but I'm not sure it makes a difference in light
I
of
think
my
it's
ruling.
moot at this time, Your Honor. Thank you.
All right, is 216 something you filed earlier? Why does it have this number?
No, that's my error, Judge. That's my error. I corrected it on the original. It should be 318. It's my poor vision.
Okay, so just so the record's clear, when I said a moment ago, I did review what the defendant filed this morning. It's just not 216, it's 318. All right, on the docket. All right, I see that I have two other pleadings up here, which I will address in brief. One of them I was going to address anyway. It's in substance, maybe not exactly as it's presented. Those are items number 319 and 320. Let me talk about 319. I haven't read it either. It's a motion to prevent the Commonwealth from basically, I believe, an Attorney Tipton, you can, or Porges, you can illuminate me greater, but you don't want them saying he promised you something in the opening statement that he didn't deliver.
That's right. And after consulting with the Commonwealth this morning, they have no intention, they told us they have no intention of doing that.
So I have already pulled out some case law on this and where the boundaries are, and I was going to give it to you in the charge conference anyway to make sure that you were aware where the boundaries are. The SJC has spoken on this issue of what's permissible and what isn't. The Commonwealth is allowed to get into it a little bit. I will alert you to those cases, and that's where I intend to draw the line as to what's permissible. I probably have them on my bench right now, but I couldn't tell you where they are. But when we get to the charge conference, I'll give those to you so you both have the benefit of my research on that issue. The other motion, 320, is I expect the defense will renew after I bring in the jury, ask you if you're going to present any evidence, and you will rest. And I'll hear you at the side of the bench with regard to that. So now, I do want to conduct the colloquy with the defendant at this point.
Would you like me sworn, Your Honor?
Hold on a second, because I'm not sure I have my colloquy with me on the bench, despite the fact that I have quite a few binders here. I think the one I need is in my office, so stay tuned. Nobody move.
Welcome to Zoom Government.
I think so.
Enter your participant ID. Please enter the meeting code. The meeting has not started.
Oh, yeah.
Please wait or try again later.
Was
You see the court this afternoon.
Madam Clerk.
Thank you, Judge. Mr. Walsh, if you could stand and raise your right hand, please. Do you solemnly swear or affirm the testimony you shall give in the cause now in hearing should be the truth, and that you shall give all true answers to all questions as put to you by the court in the cause now in hearing, so help you God?
I do.
Thank you.
Excuse me.
You can be seated. I just didn't, was wondering if you were asking me if I wanted him over on the witness stand. I do not. Mr. Walsh, one important decision that all defendants in every criminal trial need to make is whether or not they're going to testify in a particular case. You have an absolute right to testify at this trial, and your right whether or not to testify is solely your decision. This means that you are not required to take your attorney's advice. I'm sure that your attorneys, Attorney Tipton and Attorney Porges, have told you that if you do testify, the Commonwealth has the right to cross-examine you. That is the right to ask you questions. If you do not testify, and you and your attorney request me to do so, during my final instructions to the jury in the law on this case tomorrow, I will tell the jury that you, like all persons charged with a crime, have the right not to testify, and that the jurors may not speculate about your decision not to testify. First, I'm going to ask you some preliminary questions. Sir, in the last 24 hours, have you had any alcohol or alcoholic beverages?
No, I have not.
In the last 24 hours, have you taken any prescription medicines?
I have not.
In the last 24 hours, have you consumed any legal or illegal substances?
I have not.
Is your mind clear here today?
It is
Tell me in your own words, what are we discussing,
whether I'll testify or not in my trial.
right? Have you discussed with your attorneys the decision about whether or not to testify in this trial?
I have.
And have you had enough time to discuss your decision with your attorneys?
Yes, I have.
Have your attorneys discussed with you the pros and cons of testifying and not testifying?
Yes, they have.
And do you understand what your attorneys explained to you about your right to testify?
Yes.
Has anyone threatened you or promised you anything to get you to give up your right to testify on your own behalf?
No.
Have you made a decision about whether you wish to testify at this trial?
Yes, I have.
And what is your decision?
I will not testify.
Does any party wish me to ask any further questions before I make my findings?
No, Your Honor.
No, Your Honor.
I find that the defendant, Brian Walshe, freely, voluntarily, knowingly, and intelligently has waived his right to testify at this criminal trial, and that he's done so with the knowledge of its consequences. I accept his decision. We can bring the jury in.
All rise, jurors entering.
Hear ye, hear ye, hear ye. All persons have anything to do with the Honorable Diane Fernandez, Justice of the Norfolk Superior Court. For your attention, you may be heard. Those here, the Commonwealth of Massachusetts, in this honorable court. Please be seated. Please turn off your cell phones.
Morning, jurors.
Morning.
Jurors, we'll start today with the 4 questions. Jurors, were you able to comply with my order that you not speak to anyone about this case?
Yes.
Were were able to comply with my order that you not do any research about the case?
Yes.
Be able to comply with my order that you not go on any social media or access any news media?
Yes.
And you still all have open minds?
Yes.
With those 4 questions all answered in the affirmative, we're ready to begin today's work. Does the defense wish to call any witnesses in this case?
We do not, Judge.
Defense rests?
Defense rests.
All right. I'll see counsel at the side of the bench.
Good morning, everybody. We have some new people in our viewing area. I'm Ada K. Brown. I'm your host. Unfortunately, a host with COVID. Normally, you will see my face up there. You will hear me. And yeah, you don't want to see this. So I am not doing very well at the moment. Unfortunately, I'm at the phase where I coughed all night long. Game 72, thank you so much for joining us. I appreciate seeing you. Hopefully you'll come back, and you're welcome for the membership. Back to you, June. Oh, and not an O as in I should have, but I want to thank my mods for having the channel this week and taking care of everything. Y'all are so amazing. June and Angela are my rockin' mods. And then I also have several other mods. I don't think they're live with us at the moment. No, they're not. So thank y'all very, very much.
Okay, this is June, one of Ada's mods. And I'm just going to give you a little bit of a rundown for today.
Mod boss. You're my mod boss. Own it, woman.
Okay, I am Ada K's mod boss, but Angela and I work on the same level. And we're going to have a little bit of a time where pre-planning makes good for good decisions. So right after we get done with Brian Walsh's case today, we are going to go live to New Hampshire, where the Dustin Duran sentencing is going to be held. And this case is called the Amber Alert Murder Trial. I'm in the process of getting a little bit of a rundown on that so I can pass that out to y'all. But this is a case that we did cover. So we're going to be finishing up with this case. And then after the Duran case, we will be going over to the Ian Mitcham case this afternoon when the court goes into session. So we still have a full day, so please stay with us and hope you enjoy our stream. And, please remember to send your love and support to Ada.
I think I've referred to the trial as I sort of see it as different chapters of the book. And another chapter of the book has just closed. And that is that all the evidence in the case has now been presented to you. I remind you at this time, jurors, and I reminded you of this at the close of yesterday, the defense has no burden in this case and has no burden to produce any evidence at all. And that's because, as you probably are all very well aware at this point, the burden lies on the Commonwealth to prove its case beyond a reasonable doubt, and it never shifts from the Commonwealth, all right? So what happens next? What happens next is the next chapter we're going to go to as we move towards your deliberations is that really two things that happens interspersed. I'll explain. And the two things that need left to be done is I need to give you my jury charge, my legal instructions to you. Then you need to hear the closing arguments of counsel, right? So the way that happens is I will give you, when we next reconvene, which is going to be tomorrow morning, and I'll tell you why in a minute. I will give you instructions on the law that's specific to the charge that's primed here, the charge that the crime that is charged here, excuse me, murder. Then the lawyers will do their closing arguments. And then I come back and give you additional instructions. I call them more generalized instructions. So those two parts of the trial happen interspersed. A little instruction, argument, more instruction. That's going to happen tomorrow morning. And I try to be as transparent as I can in my cases. The reason for that is I don't just pull these instructions out of the ether, as you might imagine. There are instructions and guide instructions. And there, I get the input from the lawyers of what they're seeking. And that hasn't happened yet because we've moved at a pretty efficient pace. So I need to do that work with the lawyers today, and I will. And that's what we'll be doing today. What you'll be doing today is getting some rest and some sleep so you can be all rested for tomorrow morning. And I remind you, jurors, I'm going to send you off for the day. I remind you, what I just checked in with you. I'm counting on you to be obedient to those rules right to the end, right? Jurors, don't speak to anyone about this case. Don't do any research about this case. Stay off of any social media, news media, and continue to have open minds as we finish these last chapters of this trial. Have a great day.
All rise to the court, please. Jurors, close your notebooks and follow me.
Couple of housekeeping things. Yesterday at the side of the bench, we had a discussion about, during Mr. Mootlu's testimony, in which I asked that a certain document be marked as, I think it was M or N for identification. Madam Clerk, which was it?
N, I believe, with the hammer?
No,
Oh, the other one was N, Your Honor.
N for identification. Has that been done? This is a question to the defense. On cross,
Page 53 of that
I want that
transcript, Your
whole
Honor.
document to be marked for identification. Has that been done?
Okay, I'll get that to the court this morning.
And just so the record is clear, as I understand it, that is a multi-page document of which Mr. Mootlu was asked to review a single page of, but it comprises a record of his police interview. Is that correct?
That's correct, Your Honor.
Are the parties ready to do the charge conference, recognizing that I haven't given you a draft yet because of the way things played out? I did stay last night and draft the jury instructions with the benefit of two things so far that I'd considered, or at least three things. One was what I had marked for identification the other day, which is the first 2 pages of the model homicide instructions. I'd asked each of the parties to mark up, so to speak, those 2 pages of the SJC's model instructions. And so you did at my request, and I had the benefit of that information. I also received yesterday, Madam Clerk, if you could get me while I'm talking, the defendant's request for jury instructions concerning consciousness of guilt, emotional evidence, and bad acts. I had that, I considered that as I was drafting the draft instructions yesterday. And I'll talk to you about that. What I didn't do, and I sort of made a mental, because I ran out of steam, frankly, yesterday. I know that very early in the case, before the case started, that the Commonwealth had filed pleadings with regard to jury instructions. And I made a mental note to go back to those this morning, but I didn't frankly have a chance to do that since the day is unfolding a little differently than I expected at the end of yesterday. So I tell that to you so that you know that if there's something that you wrote in there that's still relevant now, it might still be, that I don't have that fresh in my mind anyway. All right?
Yes, Your Honor.
So, said more bluntly, if there's something in there that I don't go over now that you want to persist with, just.
Your Honor, there is actually, with respect to the consciousness of guilt instruction potentially, I don't know if it would make sense to take a brief break so that I could collect my notes on that topic.
All right. I will take a brief break before we, and what I'm going to intend is this. The draft instructions as I have them right now includes what I tried to do is when I was scratching my head saying to myself, why do they want this instruction in? I put it in anyway, and then I put it in italics so that should be your clue that I'm questioning either why this is in here. For instance, the object of the killing must be a human being that the defense has asked for. Question mark, why are they asking for that? So the italics either means you asked for it, I'm questioning why you want it, be prepared to answer that question. Or in the instance of the instruction, I have instructions drafted right now for, and this is in part 2 of the instructions, impeachment by prior conviction, impeachment by prior inconsistent statement, and impeachment by prior bad act. And in particular, in the prior bad act, I took a swing at attempting to fairly describe the evidence that's been presented to the jury with regard to the defendant's bad acts. I tried to do it neutrally, but there may be other words that you like better. So those are in italics, even though the whole instruction isn't in italics. Who's closing for the defense?
I am.
And who's closing for the Commonwealth? The address of the refuse center, 300 Forest Street, Peabody.
Yes, Your Honor.
The defense now seeking the instruction with regard to the defendant's right not to testify.
Yes, Your Honor.
I'll add it.
Yes, Your Honor.
Sorry, guys.
Again, look for the highlighted language in the consciousness of guilt instruction and see if there's some other language you would prefer that adequately captures trial evidence. All right, let me propose this. I'm going to make those edits and additions based on the information that you just provided. And then I'm going to have Madam Clerk shoot you a copy of the draft instructions. And I know you probably want to be spending your afternoons working on the closing arguments. So I think it would be reasonable, given what I think is relative to other cases, the instructions are pretty straightforward. By that, I mean, there also was a lot of agreement with regard to your submissions as to what you wanted in these instructions. And so it's sort of the second half of the instructions that the special instructions. I will go back and look at what the Commonwealth submitted early on in the case. Should I presume that everything you wrote then you're still pursuing today? ADA Cusick.
Yes, Your Honor. The Commonwealth was seeking a direct and circumstantial evidence instruction, a consciousness of guilt from the MCLE instructions, and an expert witness instruction.
All of those instructions are presently in the charge, in the draft charge. So thank you, because that prevents me from trying to find out where it is.
Yes, Your Honor. It's under general instructions at the back of the pleading, the preliminary request for jury instructions, and we just provided the name of the instruction from MCLE.
All right. I don't know if I probably grabbed it. I'm not a huge consumer of the MCLE instructions. I usually use other sources, but you can see what I came up with, and you can tell me whether you disagree with it. But we talked about the consciousness of guilt instruction, and it does not, I've never given, as far as I recall, a version that put my thumb on the weight of the evidence. So it presently either says you've heard evidence suggesting, what page is it on? Hold on, it's on page 27. Yeah, it's some evidence suggesting. I've never, I don't think to my knowledge or recollection, I've never used anything that was stronger than that. Yes, counsel.
I just wanted to say, I hope you haven't spent any time on this. The object of the killing must be a human being. You mentioned that this morning,
It was just not crossed out of your version, I don't believe.
and it should have been.
It's not an
Oh.
issue.
I know. I said
So-
it should have.
Oh,
So just
no,
can I take it out?
pause. Pause.
I didn't spend any time on that.
Oh, the audacity of that lawyer to chastise the judge in that matter. Oh my God, y'all. If you don't know how bad that was, I'm letting you know. The fact that he talked to her like that, oh my God. I hope you didn't spend any time on this. No, I didn't. That's your job, boo. Oh my God. Y'all, you saw something that shouldn't have happened and normally doesn't happen. June, are you rewinding it for us to watch that little part again? Oh my God. And we do have cameras up in sentencing, so when they enter the courtroom, I'll take over that part of the live. And you guys, this is why you're not seeing me. I look like shite. Okay, I'm alive, just so you know, but you're not going to get my face right now. Oh my God, go ahead, June. That was the best part of this trial, in my humble opinion.
I hope you haven't spent any time on this. The object of the killing must be a human being. You mentioned that this morning,
It was just not crossed out of your version, I don't believe.
and it should have been.
It's not an issue.
I know. I said
So-
it should have been.
So
Don't
just
waste
take it, can I take it out?
Yes.
Thank you. I didn't spend any time on that. There are other things I spent, like about 5 issues that were of interest to me, but I learned quite a bit researching those, so didn't have a chance to look at those issues recently, and it's always good to remind yourself of them.
Good,
Take
Judge.
that
You
out.
could have nailed his butt. You could have nailed his butt.
All right,
Gracious
so let me get
woman
these to
you
you,
are.
and I'm going to suggest, what's it, 9:30? Does 11 o'clock sound reasonable?
Yes, Your Honor.
Gives you an hour and a half to stew on. I'm going to get them to you in about 10 minutes. I don't have much to change here from what I drafted. 10:30?
Sounds good.
10:30 it is. If you need 11, you let me know, but we'll say presumptively 10:30.
Your Honor, could the Commonwealth also request the cases the court referenced about the extent the Commonwealth
I'll
can
get you
mention
those.
opening?
I will get you those. There are parameters. I looked at it about 2 or 3 days ago, maybe over the weekend, something like that. Again, something I hadn't looked at in a while, and it's always good to look at the law, but I'll get it to you.
Thank you, Your Honor.
All rise.
Okay, guys, we're going to pop over to the Dustin Duran trial. Okay, there we go. Let me take down the Walshe thing. There it is. Take it down. Okay, I'm going to give you all a recap. If I start coughing real bad, I'm just going to go mute and I'll come back when the fit is over. The worst seems to be at night. Okay. Dustin Durham, a Marine veteran from Berlin, New Hampshire, was convicted October 2025 of red-rooming Caitlin Nafzinger, the mother of his 2 children. The trial featured emotional testimony from Durham himself, several witnesses, with the jury reaching a guilty verdict in less than 1 day. He was charged with red room of Caitlin Nafzinger February 29th, 2024, and a child abduction triggered an Amber Alert. Guilty on all charges. Jury deliberated for about 2.5 hours. Dustin witness testimony. Dustin himself took the stand in his own defense, claimed the shooting happened during the struggle over a custody of their children, described pulling the trigger as a muscle memory from military training, spoke emotionally about his daughters, calling them the loves of his life. The law enforcement investigators testified about the Amber Alert and Durham's capture at the Applebee's parking lot in Keene, confirmed the children were found safe with him. The forensic and medical experts presented evidence of the fatal gunshot wound to Caitlin Nafzinger, reconstructed the scene to counter Durham's claim of a struggle. The family in custody contest witnesses testified, highlighted ongoing custody dispute and Durham's fear of losing his children. The prosecutors emphasized this motive to show premeditation rather than an accident. The jury deliberation was for less than a day, signaling a strong confidence in the prosecution's case. The conviction brought closure, with the Attorney General stating it delivered accountability for Caitlin, the tragic, senseless death. The central witnesses, Durham himself was the most pivotal witness, but the testimony backfired by reinforcing prosecution arguments. Custody dispute motive, the witnesses tied to the shooting to escalate the custody of intentions. The swift verdict, 2.5 hours short deliberation time, suggests the jury found the witness testimony and the forensic evidence compelling. That is the description of this trial. And as far as the Walshe, I don't think there was anybody left on the floor that they could call other than his mother. And I don't think he's going to put her up on the stand because, in my humblest of opinions, I believe the mother knew something, even if it wasn't the act itself, but the aftermath. And I think that she would have unraveled this case to the point that it would be a minute in deliberations. So I believe, as much as we want the drama and to see them both on the stand, I believe that was the best decision that could have been made. Otherwise, I think it would have been more devastating to them than it not for it to be that she does not testify. Hey, Joe Schmo, my brother from another mother. How you doing, Joe? I should have called you and had you come on my live and help me host it, considering I'm sick. And for y'all who, some of you, I know I shouldn't toot my own horn, but I am. For those who don't know, Saturday I'll be graduating college. I find it interesting what the colleges do for little traditions and ceremonies. And at the beginning of a freshman year, the class goes on a kind of traditional walk thing. And they have just built a few years ago a gorgeous bell tower. And the freshmen walk through it, signifying the start of their journey at San Angelo State University. Well, now they have a new tradition that the seniors walk through it, carrying a candle. I don't know. I'll have it filmed. I'll have a ton of pictures. We will go on that journey. Y'all keep praying for my father. For those of you who don't know, we lost my sister a year ago, November 30th. I lost another sister-in-law as well, December 1st this year. I've had a lot of death in my life. And then my father, who's 91 on the 28th of this month, he is in the hospital, quite ill. It has been a very difficult time. Pray for my father. He's so weak. I'm very concerned. I've never seen him this weak. He survived several different kinds of cancer, including prostate. He has traveled the world as an executive, and he has been to Africa more than 50 times in his life. He's got a ministry. He's got 300 African widows and orphans that he feeds and educates and takes care of, even at his age of 91. And he has probably 50 African pastors that have grown up as children, as orphans, and become pastors. And in Africa, pastor is a very honorable job. And he teaches them how to take care of the African widows and orphans. He's a very active man. At 90, he went out of country twice this year for training. He trains pastors. That's one of the things he does. He does a lot of teaching. So we are used to him, even at the age of 90, being very, very active. His mind is still clear, but he had a blockage in his small intestine that got really severe. And so we're trying to get that cleared without surgery. So thank you guys for your prayers and support. We appreciate it. June, what you got, boo? I can't talk anymore for a few minutes. My throat's about ready to start screaming. Thank God for coffee.
Which is on the secret list.
Right now, it looks like they're just waiting for Dustin Duran, the defendant, to come in. So,
Is that your dog?
yeah, something's going on outside, and he's in his protective mode.
Oh,
not
poor
normally like that.
baby.
Max. Yeah, that's the guy that's staring at y'all in the picture. Okay.
That one right there. Oh, okay. Well, go ahead. Let's go ahead and mute and get ready.
We're going to trial.
Hearing. By the way, he used to be military, and he claimed that she threatened him, pulled him up. I don't remember, something along the lines of that. She claimed that she caused him to pull the gun, and out of muscle memory, he shot her. He blamed it on the training of the military. Oh, sorry. Didn't mean to do that.
Yes, he is a former United States Marine.
What a disgrace to his service. I know there's some Marines and military people who have PTSD and they do things. I'm not referring to that, but for him, this was not that. And what a disgrace. I mean, I don't understand how you can go from being a soldier who is defending his country and all of us to someone who's red rimming their wife. I just don't get it. There has to be a mental snap somewhere. Your thoughts, June? June, any thoughts on that, or your dog barking too much to respond? If so, I get it.
No. A lot of them, when they do stuff or they go off, they will automatically blame their military service or whatever happened to them. And that is disgraceful because this guy here brings a lot of fear onto the military people that actually has PTSD or other disabilities from their service, and makes people afraid of them. So in essence, we pay for his crime also.
Well, I apologize, and I will say that I don't group people in that category. But yes, you're right. It does. It puts a stain on the military, and I feel bad for that. I really do. And if he was an honorable man, he would not bring the military training or military into this defense because it has no place here. I think that's the one thing that frustrated me. The fact that he unalived his wife and took the kids and bolted, and had an Amber Alert. But the worst part to me is the stain it puts on the military. It's like doesn't have any place in this trial. I know military people are just like anybody else, but it just to me brings it a whole nother level as a military brat. I guess for you as someone who served our country, and thank you so much for your service, and you know I never say that lightly. I'm sure that angers you all the more. Any response?
It actually doesn't just affect the veterans or the active military, but it also affects their families because
Yeah.
it involves the family unit. Like
Mm-hmm.
we have another bot that her husband is a retired military person. She has family in the military, and they see somebody like him, you know, they're already painted as having issues when they really don't have issues.
Yeah. Oh, June, you got an echo, and I gotta wonder in the FX soundboard thing that you downloaded. Do you have your computer mic selected or your headphone mic? While I
I have
answer
my
Joe
headphone.
Schmo's question. Okay,
I
it's
have my
echoing.
headphone mic.
Ada Cable Media. Did the defense team originally plan expert witnesses before the last minute change? No. I don't think that. No. Did they promise anything in the opening? No. I don't recall them promising in the opening. I just think that the defense put all the witnesses in the basket up, and there was nobody left but his mother. And it's kind of been his mother has been investigated as a participant even after the fact. Um, but he's not going to put her up on the stand because she may have information, which I believe she does. Oh, I found a hard candy. Sorry. I believe that, the all of the tools and everything that they found, carpet pieces and stuff were placed in dumpsters, and the dumpster closest to his mom, right at or near her apartment complex, is where he dumped the was it the hacksaw and what other else, the slippers with blood and hair on them. All of that was found at the dumpsters near his mother's apartment, and I firmly believe that if they put her up on the stand, it's going to incriminate her, and he's not going to risk it. And I don't think it would save her either. In all honesty, I mean, save him. It will not save him at all. There's nothing that they can do, I believe, at this point that's going to help their case. I think that their case is pretty nailed. I think the worst, June, I know what I think, but I'm going to ask you and Angela. Angela, you can chime in anytime. I think that the email, text message, I mean, the searches are the most damning evidence. What do y'all think? If you were on that jury panel.
Yes, I would agree.
I completely agree, 100%.
Okay, outside of the searches, what do you think is the next damning evidence?
It's a cross between the videos of buying cleaning, all that cleaning supply, especially that, I can't remember what it was called, but that big box of something.
The baking soda.
Yeah. And the video of him dumping the bodies in those dumpsters.
To think that we're watching these videos knowing that those bags contain the remains of this woman that will never be found again. Kind of gave me chills when I saw it for the first time. The reality that her body is in those bags.
I think the camera footage of him dumping the stuff at his mom's and all of that they pulled out of the dumpsters, I think that's going to play a big part with the jurors too.
Okay. Amongst the mods right now, how long do you think they're going to deliberate?
Less than 3 hours.
Bingo, that's what I thought. June?
Same here. Unless they get tripped up on some of the forensics, but I would say no more than 4 hours, 3 to 4 hours.
I kind of want to, I really would love to get in the psyche of all this. Maybe I ought to go from my criminal degree all the way to PhD and then go back and get a psychology degree or dual master. I don't know. I just want to get in the minds. I want to know why. I want to know what makes them do what they do. I think there was a show somewhere on YouTube where they sat down with these people who were on life sentencing or death row. And they asked them these questions, and I found it so intriguing. I just want to get in their minds and figure out what causes somebody to be a part of the military, to be an upstanding person, to then turn around and do such a thing. Hey, Joe, are you there? Can you comment yes in chat if you're there? I have a very important question for you. Very important. Hopefully you're still there. I'm waiting for him to say yes. Okay, I see you're in chat. Joe, wiggling my earring, my imaginary earring. My little Joe genie needs to pop up. But y'all don't know. Every time I play with my earring, Joe pops up. Good idea, by the way, June. I'll try and reach out later. He's not responding. I'm going to sneeze, y'all. I'm going to mute. That's okay. I know how to get hold of him. I'll be right back. June, you got the floor.
And we were giving heck to the long sidebars in the Walshe case. I'm wondering what's holding up his sentencing. So, did I misspell the word sentencing? Doesn't look right. Okay, so Ada had a very, very good point about how people like, especially in the civilian community that has never had any dealings with the military, how they like to tie everything in to the military, you know. which just distressed a lot of people.
Well, I think like we had a firefighter here in Kerrville who was drinking and driving, and his truck, just the street behind me and the house behind me. He was drinking and driving and lost control of his vehicle and ran it into a house, killing a 6-year-old girl. She did not die instantly. She died in the hospital from just, they had to take her off of life support days later. And for him to use the fact that the stress of being a firefighter and watching all the death was too much, and he started drinking. Bullshit. I don't agree with that. I think that is the worst thing anybody can do, is use an honorable profession as a defense, or use something they, like him, it was military trigger memory, or police officer, or anybody using, it just boils my blood, June. It just does. Mm. I'm going to call mom and check on dad.
Okay. As we are patiently waiting for the sentencing hearing to begin, what are some of your thoughts on people using, whether civilians or military, but people trying to use mental conditions to get out of being held accountable for their own actions? You know, I understand there is a mental health issue in the country. I, do carry a degree in psychology, and are they using it more as an excuse, or are there's actually, you know, not an excuse? Well, what I remember is less than, I think it was 20% that uses it as an excuse, um, is truly, mentally challenged in lines of issues, in lines of issues. I'm sorry, my attention got distracted for a moment. What's your thoughts? Put them in the chat. This is a good debate chat while we're waiting for the sentencing to start.
Here's a little mini courtroom trivia quiz. In the U.S. courtroom, what is the purpose of a voir dire? 1, to deliver opening statements, and you put the number in the chat. 2, to question potential jurors for bias. 3, to cross-examine witness, or 4, to determine admissibility of evidence. Again, the courtroom, what is the purpose of a voir dire process? 1, to deliver opening statements. 2, to question potential jurors for bias. 3, to cross-examine witness, or 4, to determine the admissibility. Yep, y'all are right. Number 4. Well, why can't I do more? Hold on. It froze. Give me a sec. It'll come back up. What is the primary role of a court reporter? To enforce courtroom rules, to record all spoken words during 1, to enforce rules. Hold on, Joe Schmo. I'll be right back.
Okay, to answer Music by Brian 2024, what we are doing with this gentleman here is he is actually having his sentencing hearing today. And we are waiting for the hearing to start. This gentleman is being sentenced for the red rooming of his wife, uh, Caitlin Mapzinger, the mother of his children, in February 29, 2024. He has been convicted of second-degree red room, I believe child endangerment, and triggering the Amber Alert because he red rummed the mother of the children and then took the children. Luckily, the children were found safe and unharmed. So he was found guilty of second-degree murder, reckless conduct with a deadly weapon, and child endangerment after several hours of deliberation.
Hey, June. Joe Schmo said yes.
Thank you, Joe.
Y'all, well, okay. But you both
Joe.
need to know he's on East Coast time. So in Central time, I need you to send me the times that you need him. We need to figure out that time. I told him it may be as early as 12 o'clock his time, which is 11 o'clock our time. And it may run till 2 his time, which is 1. I don't know. Whatever the time gap is, he needs to know. And then I'll send him a link and he'll hop in and he can take over while we're going. So tomorrow, guys, we have a guest host. I am out sick and traveling to graduation. My college is 2.5 hours away and it's got a lot of commitment on Friday afternoon and evening. And both of my mods have appointments. So we have a guest host tomorrow. It will be Joe Schmo. That hurt. Oh, Joe. You guys could see how much coffee I'm drinking just to keep talking. You would be amazed. So we love Joe Schmo. He's been a really good friend to this channel. And we look forward to him coming in and just kind of helping run everything tomorrow. So thank you very much, Joe. I don't know what's taking so long. What's the delay? We see movement.
Well, this could be a guess. Either they were waiting for people for their impact statements or they had to have breakfast.
Yeah. Well, just a little tidbit of info. This hearing, the judge decides the appropriate punishment considering, and this is kind of how a judge goes through the process. They consider the statutory guides. They also take into account the aggravating, mitigating factors. Then they'll take into account, they pretty much have it set in their mind what they're going to do, but judges have changed their minds based on the victim impact statements and also the pre-sentencing investigative reports. Now, the pre-sentencing investigative reports, or the PSI, the court often waits for the probation office to prepare a detailed report about the defendant's background, criminal history, circumstances, and any mitigating factors. Motions or objections, the defense or prosecution may file motions challenging the sentence enhancements. The witness testimony, sometimes experts or victims need to testify, which can push back the timeline. So that, oh, sorry, had to swallow. I have to drink a lot of coffee to keep the voice going. So, some people have asked, what does the judge actually have to take into account when forming the sentence? In some cases, the law is very clear that the minimum may be 20 years to life. Sometimes the law is clear, it's life without the possibility of parole or the life with the possibility of parole. But other than that, you cannot go any lesser. So the judge also has to take into account what the written law requires for the charges that have been found guilty. Hold on. So in this particular, who's the defense's witnesses, in which case Vanessa Joy, thank you so much for joining. We have new people joining. I am sick with COVID. This is what COVID sick looks like. Got a rash from head to toe. I am miserable. So you are hearing me speak, and I'm drinking a ton of coffee to keep the voice going. So in the Walshe case, there were 0 defense witnesses. He did not testify, and the only other person they could put on the stand in this case was the mother of Walshe, and that was not going to happen. So the charges that Duren was found guilty of was E-par in the first degree, 2 counts, Class B felony, 5 to 25 years per count. Sentencing may run consecutive or congruent depending on the judicial discretion. Endangering the welfare of a child, Class A misdemeanor, up to 1 year. And then the red room. Aggravated factors, the victim was 7 years old or younger, which makes it especially severe. Multiple incidents, 3 occasions of actual assault and battery. Okay, Angela, thank you. The judge can impose consecutive sentencing, meaning that Durham would face decades in prison if the counts are stacked. Consecutive means he has to serve. So if he gets 2 terms of 25 plus a term of 10 plus a term of 1, he would serve 25 years, then 25 years, then 10 years and 1. That's 61 years total. With good behavior, he could get out, 18, 8 and 8. I don't know. I don't know the mathematics, but also the alternative could run concurrently, which means 25, 25, 10, and 1 would run as 25. They run all at the same time. And then, anyway, June, can you give me what time you think you'll be back? I need the times you're gone and the times you'll be back. I'm sorry, I wasn't clear. Duren can appeal his conviction, but the appellate court usually upholds the judgments. because he's convicted of EPAR in the first degree, he will have to register as an ex-offender registration for life. Excuse me, I'm struggling. So in this case, he was indicted with 3 counts of EPAR in the first degree, 1 count of endangering the welfare of a child. Is this correct? Oh, no, it's not. Excuse me, it's the wrong case. I have 2 Durham. Forgive me. Forgive me. Someone should have said, Ada, wrong case. Yeah, I'm sick. That's why. I got the wrong case. I have a Justin and a Dustin Durham case. I have 2 Durham cases I followed.
Ada.
Okay, in the Dustin Durham case, the convicted or felony shooting of wife Catherine Nafzinger on what? Well, that was a good educational. Anyway, he was found guilty of second degree redrum of his wife, Class A felony, reckless conduct with deadly weapon, and child endangerment. Sorry about that, guys. This is a COVID brain right now. In the second degree redrum Class A felony, 20 years to life. Reckless conduct with deadly weapon and felony up to 7 years. Child endangerment 1 year. I don't understand why child endangerment only gets 1 year. It is a misdemeanor. They can bump it up to a felony depending on the mitigating factors. So the aggravating factors are the killing occurred during a domestic violence and while in the custody involving children. He abducted his children afterwards, which escalated the danger, so that is an aggravating factor. The judge can decide whether the sentencing is consecutive or concurrent. Caitlin's family and the children's welfare will weigh heavily on the judge. Durham is a Marine veteran, which may be raised as a mitigating factor, though courts often prioritize victim safety and child welfare. That is this case. I apologize, guys. I had the 2 names mixed up. They both involved endangerment of children. Oh, I mentioned this case a long time ago. Yes, Vanessa, Joy, and Nanku, they did not call a single witness. He did not go on the stand and testify himself. This case was supposed to take 2 to 3 weeks, and we are, 1 week and into this week and a half in. They anticipated having witnesses and everybody on the stand for 3 weeks before even going to jury deliberations. Today, right now, we are sitting in waiting for the Justin Durham trial, where he redrum his wife and kidnapped his own kids. You're right, Vanessa. I am very, very surprised. Did they even seek? I don't know. My memory serves me correct. They did not formally pursue the not guilty by reason of insanity in GRI, but his attorneys did raise the issue of mental health, PTSD, and muscle memory from military training, which pisses me off. PTSD, fine. But don't bring in muscle memory from military training. Justin Durham got in a dispute with his wife, unalived her, took the 2 kids, and ran. There was a huge Amber Alert put out for the children, hence called the Amber Alert trial. This is what happened. Durham describes the fatal shooting of his wife as a muscle memory in the Marine Corps training. He spoke about PTSD symptoms and custody fears, suggesting mental state influenced his behavior. His lawyers did not enter the NGRI, which would have required proving he was legally insane and at the time unable to understand the nature of his wrongful act. Instead, they leaned heavily on mental health context and argued diminished responsibility or lack of intent. The jury convicted him of second-degree red room, reckless conduct with a deadly weapon, and child endangerment. The mental health testimony did not prevent conviction, though it may influence the sentencing. Now, the NGRI, or not guilty by reason of insanity, shows several mental illnesses that made the defendant incapable of knowing right from wrong. Now, PTSD and stress, while seriously, rarely meets this threshold. So, military background, he's a Marine service, and PTSD were central to his testimony. I do believe, if I remember correctly, that PTSD was a component that he was dealing with prior to the Red Room. The custody conflicts. This shooting occurred during a dispute over his children, which added the emotional and legal complexity. Sentencing impacts. A judge will consider mental health evidence when deciding to impose maximum sentence. For those of you who were not with us during that time, we're going to do a quick case overview. February 29th of 24, shooting of the deaf wife, Caitlin Neffzinger, and for the endangering of their 2 children. He was found guilty of second-degree red room, reckless conduct, deadly weapon, and endangering children. The case drew national attention because the killing triggered an Amber Alert when Durham fled with his daughters before he was captured. Incident happened February 29th of 2024 in Berlin, New Hampshire. Durham fatally shot his wife, Caitlin Neffzinger, in domestic dispute. Then he fled with his 2 daughters, starting an Amber Alert, and he was arrested later that day in Keene, New Hampshire, with the children safely found. The second-degree red room is in killing of Caitlin. The firing of the gun in the way that endangered others is reckless conduct. And then, and then the child endangerment was doing it in the presence of the children. So that is a very vague rundown of this case. I'm sure you'll find more information as we move forward. I'm going to come back because I know that somebody said something.
Thank you. Please be seated.
I'm going to have to help the court. Give me a minute.
Morning, Council. Morning, Mr. Durham. Yes.
I'm not sure if their mics are on because their sound sucks. I don't remember there being a sound issue last time. Okay, while they're doing their little sidebar, I need to let y'all know that we are no longer popping up the court feed closed captioning because we have closed captioning now within our feed. If you want closed captioning, go and click on the little CC at the bottom of under our main feed screen. You'll see it. And you will have it. And then you can move it around on the screen where you want it, and you can size it the way you want it. Just FYI. If you cannot do so, let us know. We will pop it up again in the court feed. Okay, so we got a sidebar again. Let me zoom, get caught up. All right, so we are at a wonderful, wonderful sidebar. Y'all, we have a cute little sidebar thing. Here it is. I want to give a shout out to my mods. Thank you so very much again for all that you've done. I'm not going to last much longer, so they will have to take over shortly. I'm starting to fade again. I get these little spurts of ability time, and then they're gone. June, I'm going to leave it running, but I'm going to let you talk for the rest of the next 20, 30 minutes. I'm losing it.
Okay. It almost sounds like they just turned the mics on. So hopefully we are going to get started here very shortly. Thank you for all the questions and the chat interaction. And let's get this stuff on the show, on the go. So this has been a very interesting week for cases. And as I said, we will still be doing the Ian Mitcham case. We will pick it up after the sentencing hearing. So please stay tuned. We still have a fully loaded day of court watch, and we enjoy you all being here. And we hope you really like our channel. So if you have any more questions or any more debate, please pop it in the chat, and we will be more than happy to partake in the debate or answering of questions. And please remember, if you like our program, please hit the like and subscribe button, and please share it with your friends and on other social media platforms to help support and grow our channel. There is a pledge out there or a challenge out there that if we can get Ada to 4,000 subscribers by the end of December, that she is, as she person, she is a virgin to tattoos, and she will be getting a small tattoo. I just lost the name of the cow.
Highlander cow.
Which one?
Highlander.
Oh, the Highlander. So let's break this 4,000.
That cow. That cow.
Grow our channel. So please help us by supporting and subscribing. It doesn't cost you anything to subscribe, and that will help grow our channel.
Okay, Counsel, I'm going to.
True.
Counsel, I've been advised relative to that request, and I'm going to grant.
Thank you, Ari.
Take a brief recess in order to effectuate that, and we'll get started very soon. Thank you.
I don't understand why their sound is so crappy when I'm gained 100% across the board, and I'm even using a sound booster I don't remember their trial being that difficult. Do you?
No, but maybe that's one of the delays is they were having some technical issues. Let's see what happens when they actually get on the mics.
Hey, Joe Schmo, go check your text, please. I just gave you the times. If for some reason you can't do it the whole time, that's okay. We'll figure it out. But I just texted you the time. It is 12:15 your time to 3:45 ish your time. And so let me know, please.
They just took him back.
That's unusual. Very unusual, y'all. I love it when you're typing and you're not typing.
Okay, the plot thickens now. Suspicions are growing. Could they've had that long conference and come up with an agreement on his sentencing so they can avoid the impact statements?
Oh, and the courtroom is clearing.
Yes. The judge isn't on the bench. Okay, y'all, you just want to mess up.
Oh, whoa. Direct answer. Here. I got an answer. During Dustin's sentencing in New Hampshire, he was removed from the courtroom because of his disruptive behavior. Reports indicated he interrupted proceedings and acted in a way that forced the judge to have him escorted out of the sentencing could continue without disturbance.
Okay, but why are they emptying the court?
Don't know. And also, they could have had a threat. There could have been a threat. I would believe that. I didn't see him being acting in any way. It says disruptive behavior. He interrupted the judge and became combative. I'm going to rewind this.
Yeah, because I didn't see anything.
I didn't even see
the camera may not.
Wow. Oh, and
It
let
may
you
have
all
been.
know.
Here it is. Was that maybe from his other sentencing then? No, it said today in his sentencing. It's either that or they had a threat. And if they have a threat, they're going to remove him and remove everybody from the courtroom. Good morning, honey bun. I wasn't really watching him.
Well, I was kind of keeping an eye out of the corner of my eye, but I didn't see him do anything but what he's doing right now. That's what sounds like the sound. Well, while we're watching this and seeing what
Maybe he didn't like something that the attorney said to him. And the security people overheard the conversation and felt that it was escalating and they needed to calm it down. That's weird.
He's talking to the middle lawyer right now.
Counsel, I've been advised relative to that request, and I'm going to grant that request. The court will take a brief recess in order to effectuate that, and we'll get started very soon. Thank you.
Maybe it happened. Maybe it happened earlier. Yeah. Because it was a longer you got street clothes security that just stepped back because watch. See the guy walking, he has an earpiece. He's going to go see it hanging off his side of on his left ear. I think it's more of a security threat because that's plain clothes security. And this guy here is security and that guy there is security. Of course, this is sheriff department. So I wonder if there was a threat to the courtroom. And they're not saying. Because I don't see him behaving at all.
And
In an appropriate manner.
And if it was just him, why would they clear out the court?
Yeah, well, yeah. I suspect if you notice they're talking to the head. Oh, that's big security dude. Look at the badge on him.
Yeah.
Look at that right there. That big security. This is interesting. I think there may have been a security threat.
Because they're clearing out the court.
Okay, it says, again, from the reports available, there was no specific external security threat like weapons or outside danger during the Dustin Duren's sentencing. The courtroom was clear because of Duren's own disruptive behavior. He interrupted the judge and became combative. His conduct escalated, though the bailiff had to step in. We didn't see this.
I don't know, maybe the combativeness was between his and his lawyer, but didn't have really any body language.
Well, that's true. They can hear everything being said. We cannot. He could get 45 years to life is his potential sentencing. Okay, so we're just going to have to wait and see. This is interesting, y'all.
Yeah.
Okay, so they're back into court. Let's see. I like to see them bring them in to see the body language. Okay, they don't let us see them bring them in. Okay. That is very interesting, y'all. Very unusual. So it very well could have been something between him and his attorney and they felt was going to escalate. I'm going to leave up captioning because the sound is so horrible.
For the state.
Josh Spicer for the state.
Margaret Kettles representing Mr. Duren. McKenna Kinney representing Mr. Duren, and Mr. Duren's present.
Okay, good morning to all counsel, and good morning, Mr. Duren. Okay, anything further before we proceed, counsel? Okay. Counsel for the state.
Thank you, Your Honor. On October the 28th, a jury unanimously found the defendant guilty of second-degree murder, both knowing and reckless, of reckless conduct with a deadly weapon, and of endangering the welfare of a child. As indicated in our previously filed state sentencing memorandum, the state is seeking today what we believe is the only appropriate sentence. That is, the state's recommendation that Mr. Duren be sentenced to 45 years to life for knowingly murdering Caitlin Nafziger, and a consecutive but fully suspended sentence of 3.5 to 7 years for reckless conduct for placing their daughter Elowen in danger. That sentence under the state's recommendation would be suspended for a period of 10 years following the defendant's release on the murder charge. As to the charge of endangering the welfare of a child, the state would recommend a 1-year sentence, which would run concurrent to the murder charge. Along with that reckless conduct sentence, the state is requesting a no contact order. The no contact order would include no contact with Caitlin's family as named and no contact with the children. It is the state's understanding that there is a current mediation agreement concerning custody of the children between the Nafziger family and the defendant's parents, which calls for the defendant to have no contact with the children for the foreseeable future. The state is also requesting that this court include an order that the defendant not be allowed to profit in any manner from the death of Caitlin Nafziger or from this incident and his actions therein. The full text of that is included on the sentencing forms that the state provided. Further, the state is requesting that the court order restitution in the amount of $12,007.69 payable to the New Hampshire Victims' Compensation for lost wages and counseling that were incurred by the family as a result of the death of Caitlin. The sentencing forms filed by the state show that the defendant has 650 days of pretrial credit. Under the state's recommended sentence, the state would be eligible for a sentence reduction of up to 21 months under the statutory provisions of 651A22 for earned time credit. And he would be eligible to apply for further sentence reduction after completing 2/3 of his sentence pursuant to RSA 65120. Those are statutory provisions that the state has no power to change. Were the defendant to obtain all of these statutory reductions, he would potentially be eligible for parole on the murder charge in approximately 28 years, meaning that he would serve significant time for his actions in murdering Caitlin, an unarmed woman, the mother of his children, and for his conduct in endangering Elowin. Turning briefly to the defendant's requested sentence, the defendant is asking this court to sentence him to a mere 25 years to life for murder. The defendant argues that such a proposed sentence would lead to the defendant serving decades in prison, but that is not entirely accurate. Such a sentence would mean that if the defendant took advantage of available statutory reductions under 651A22 and 65120, he could be eligible for release from prison in just over 11 years. Those statutory provisions and reductions are never guaranteed, but they should be considered by this court in sentencing, as they are available and they do impact the truth in terms of sentencing here today. That truth is important to the victim's family, to the community, and to this court's final sentence as it relates to the goals of sentencing. Later this morning, or potentially this afternoon at this point, this court will have an opportunity to hear from Caitlin's family, to hear about her from people who loved her, instead of how the defendant portrayed her and what he presented about her during the trial. In these victim impact statements, the court will hear about Caitlin's life and about the impact of Caitlin's death on the people who loved her. The court will also hear about the impact of the defendant's actions on his and Caitlin's children. The family will ask this court to give the defendant the maximum possible sentence. One of their concerns is that the sentence given should ensure that both Elowin and Valen, the two minor children, are old enough to make decisions for themselves should the defendant be released from prison, old enough to decide how much involvement in their lives they are willing to allow the defendant to have and what that contact should be. As described in the state sentencing memorandum, the state sentence takes into account mitigating and aggravating factors, and it is in alignment with comparable cases throughout the state. This recommended sentence would instill confidence in the justice system that a domestic violence murder of an unarmed woman seated on a sofa, wrapped in blankets, is the kind of violent, wanton action that will be severely punished. The state's recommendation meets the defendant's actions in murdering Caitlin Nafziger with the serious response that he deserves. In contrast with the defendant's military service, which the defendant has cited as a mitigating factor, and which he uses to seek leniency from this court, the court should consider the multiple aggravating factors involved in the defendant's cruel and knowing murder of Caitlin Nafziger. First, the defendant's motive in killing Caitlin was not related to his military service or to his PTSD diagnosis, but rather to his own stated justification that she wouldn't leave his apartment and she wouldn't let go of their oldest daughter. 2, his use of a deadly weapon. As a trained marksman, the defendant used that weapon, his handgun, to execute Caitlin with a single shot that he aimed at her left temple, As he testified, he absolutely was aiming, and he knew where the bullet would go and what the result would be. 3, Caitlin's injury was to a vital organ. She suffered damage to the head and to her brain. What's more is that the autopsy report shows that she aspirated blood, evidence that she took at least a breath after the defendant shot her. The defendant's crime, 4th, took place in the privacy of his apartment. It was in front of children. There were no other potential for witnesses to observe the murder. He did not call for assistance or report what had happened, and he did not check to see if Caitlin had survived the injury she incurred. 5, he fled. He turned out the lights. He closed the door. He packed his car. He took clothing for multiple days, food, and his desktop computer that he used for work. 6, he initially attempted to conceal what he had done by essentially walking away with the couple's children. Only 5 hours later it was that he decided to call, not the police, but his parents, over 1,400 miles away. And still, he did not turn himself in. The defendant finally made several statements after the murder. He confessed to his parents. He confessed to the police. He told them all that Caitlin refused to leave and wouldn't let go of Elowen. But even in that confession, he spent more time talking about Caitlin's past wrongs against him and of his belief that he loved the children more than she did than he actually did talking about his murder of her. Essentially, the defendant's statements attempted to pass blame for the murder onto Caitlin herself. The state also asked this court to consider additional aggravating factors: the trauma that was suffered by the children in witnessing the crime, in hearing it, in dealing with the aftermath of the defendant's actions. Elowen was old enough to witness, to understand, and to explain to others what had happened. She is old enough to remember and to hold on to the last memory she has of her mother, left behind, dead, on the sofa. The state also asked this court to consider that the defendant has shown no remorse for his actions and continues to present them as justified. Your Honor, Caitlin was a petite, unarmed woman sitting on a sofa. She was wrapped in blankets. She had one foot on the coffee table. She wasn't wearing shoes. She wasn't familiar with the area, did not have a car, and had no other people that she knew within hours of the defendant's apartment. The defendant was larger, stronger, trained in hand-to-hand combat, and an expert marksman. He had a gun. He had access to knives. He stood between her and the doorways, and he had access to the only vehicle. He was in complete control, and he held every tactical advantage. He told detectives that he was calm, that he only yelled one time, that he performs well under stress, and now he has been found guilty of knowingly murdering Caitlin. The defendant's proposed sentence asked this court to treat him with leniency because he is a veteran, because he voluntarily served, essentially to discount his actions in killing Caitlin because of his military service. The defendant speaks in his pleading about that military service, and the state expects this court to hear about it today from his counsel. He speaks about his service-related PTSD. His pleading includes a letter of support from a veterans organization which asks for leniency based on his time, the defendant's time with the Marines. There's no indication that the person who wrote this letter ever met the defendant, but merely reviewed historical records and discusses the general experience of other service members. The person who wrote this letter also bases his opinions on the report of Dr. Pittman, which the court has also received from defense. This court is well aware of pretrial litigation concerning the reports and opinions of Dr. Pittman. This court is aware that Dr. Pittman accepted the word of the defendant for many of the facts in the report, and is further aware that Dr. Pittman has since amended and or changed some of his opinions. Yet those opinions remain included in the document that the defendant has submitted in support of his sentencing argument. While anyone who chooses to serve in the military should be lauded for their sacrifices, Such praise does not translate to preferential treatment when a person takes violent criminal action. It does not translate to leniency in sentencing for the murder of an unarmed woman, for execution of the mother of his children, or for subjecting their oldest daughter to witness all of it. Here, in this case, the defendant's military service does not entitle him to any degree of leniency. The defendant chose not to argue at trial that there was any link between his service or his PTSD and his actions. He cannot now claim and throw on the court that his service somehow warrants beneficial treatment. On the night that he murdered Caitlin Nafziger, the defendant was not a soldier, and neither was she. The apartment where he killed her was not a battlefield. If anything, the defendant's military service should have given him the discipline to recognize that Caitlin was an unarmed civilian, a woman sitting on a couch holding their child. The defendant's attempt to portray his criminal and murderous behavior as somehow related to his military service is a disservice to other veterans everywhere. In his sentencing filing, the defendant writes that his diagnosed PTSD is based on his witnessing the suicide of a fellow Marine and the impact that witnessing that death had on him and his fellow service members. This court should consider that. The defendant understands, therefore, exactly how his actions in murdering Caitlin Nafziger in full view of their 4-year-old daughter will impact that child for the rest of her life. Just as he remembers the suicide he encountered, she will forever remember that her father shot and killed her mother. She will forever have a memory of her father with his angry face and his black gun, of her mother dead on the gray couch, and of her mother's blood dripping onto her chest from the gunshot wound in her head. She will forever remember leaving her mother's dead body behind in the apartment as they fled. In his sentencing filing, the defendant speaks about how important his children are to him. The state anticipates that this court will view a slideshow showing him in loving moments with those children. The state doesn't doubt that he loves them, but the defendant is selfish. He is a loving father, does not murder the mother of his children. A loving father does not handle disputes over the custody and future of that child or those children with a gun. No matter how frustrated the defendant was with Caitlin, nothing gave him the right to settle the dispute with violence. The defendant's actions and his actions alone have irrevocably taken the life of Caitlin Nafziger and injured both of their children through the murder of Caitlin. A good father acts in the best interests of his children, even if it means compromising, dealing with frustration, swallowing his pride. A good father puts his children before himself. The defendant is not a good father. He is a murderer who selfishly put his own interests above those of his children. He wanted Caitlin out of the picture and the children to himself. And when she wouldn't go, wouldn't leave their daughters, he killed her. Actions speak louder than words, and no amount of words from the defendant or from his supporters about how much he loves his kids can conceal the fact that he chose to murder Caitlin so that he could get what he wanted at the expense of those children. He wanted a world in which he didn't have to deal with Caitlin, even though that meant his daughters would grow up without their mother. By shooting and killing Caitlin, by aiming and pulling that trigger, he got what he wanted. The statements that defense counsel has provided, written by the defendant's family, his cousins and uncles and friends, they talk about how much these children love him. They request that this court look to leniency to allow him to be part of those children's lives. There's little doubt that these young children love their father. He's their father. But also, they must be so confused about those feelings, so confused about his actions in killing their mother, and so lost knowing that their mother will never come back and that the defendant is to blame for that. And yet neither the defendant nor his family seem to recognize the damage that he caused, the injury to those children, the loss that they have suffered, and how it will impact their lives forever. The defendant murdered their mom. He shot and killed her in front of Elowen, and Valen had to hear the argument and the gunshot. The defendant subjected Elowen to the same kind of trauma that he now seeks to have this court recognize as a reason to treat him with leniency. He and he alone is responsible for the death of Caitlin and for the trauma of those two little girls. The state provided several comparable cases which show sentences within the range of the state's recommended sentence. We recognize that no two cases are ever factually the same, but the cases that the state has provided give the court information which shows that the sentence the state is requesting is both reasonable and within the range of sentences given to persons who commit similar crimes. In addition to the cases that the state provided, this court should also consider a sentence in State versus Emerson Figueredo, which is citation is 217-2019 CR 00726, a case out of Merrimack County. This was a domestic murder where the 43-year-old defendant stabbed and killed his wife during an argument. Their children were present. They witnessed it. In fact, they tried to stop it. He pled guilty to knowing second-degree murder, and he received a sentence of 45 years to life. So too has the defense presented cases that they argue to this court are comparable and which they believe give the court grounds to sentence the defendant to a lesser sentence. Those cases are not, in fact, comparable to this. Moving through them briefly, Your Honor. Dylan Sleeper, not a domestic incident. There was no relationship between the parties. The case involved a single stab wound during an argument. The defendant had scratches on his neck. He was convicted after a trial of only reckless second-degree murder, not of knowing second-degree murder. Tyrese Harris, not a domestic incident. It involved road rage, no relationship between the parties. The defendant argued that he was acting in self-defense and to protect his pregnant girlfriend. The defendant was inside of his own car when the victim approached the driver's side door and was shot. The defendant was crying and he actually demonstrated remorse when he confessed. Drew Morris, not domestic, no relationship between the parties. They had just met and were drinking. The defendant pled guilty to knowing second-degree murder. He shot and killed the victim, indicating that he, the victim, had reached for the defendant's gun just before the shooting occurred. John Hogarty, a 53-year-old defendant. This was domestic. Mr. Hogarty pled guilty to reckless second-degree murder. There was a child present during that case. That child was sleeping, and he was in a different room. After Mr. Hogarty killed his wife, he remained on scene. He wrote a confession. He called 911. He reported the incident. He even packed a bag for his child and turned that child over to the police and then made an oral statement confessing his crime. Caitlin Paquette. This was a plea to reckless second-degree murder in a child abuse case. She was bathing her child and pulled her down from a standing position to a sitting position, striking the child's head into the side of a cast iron tub. Jonathan Bejewel, not a domestic case, no relationship between the parties. The defendant was high on meth. He was described as delusional and paranoid. The incident arose out of a chance encounter with a stranger. Gary Marchand, a 54-year-old defendant, he pled to knowing second-degree murder. He did kill his wife. He raised an insanity defense and had been hospitalized for mental health issues about a month prior to the murder. Justin Belanger, not a domestic incident, no relationship. He pled to reckless second-degree murder. In that case, there was a female victim who was shot. That victim was unknown to Mr. Belanger. He was arguing with a man, and he shot at that man, striking the victim in the hip. Mr. Belanger was also only 19 years old at the time he committed his offense. Last, Peter Bartoloni. He pled guilty to reckless second-degree murder. That 70-year-old defendant was intoxicated and blackout drunk when he killed his roommate. In contrast, now 38-year-old Dustin Dern has been convicted after trial of knowing second-degree murder. The defendant's act of killing Caitlin was an unwarranted execution of an unarmed woman, someone he once loved. He had shot her in front of one of their children who has described this incident to investigators and to family members. A 4-year-old girl who was the victim of the defendant's reckless conduct and has lost her mother as a result of the defendant's action. There was no involvement of alcohol, no drugs. The defendant did not claim that his PTSD was triggered. He did not claim insanity. Caitlin never reached for the gun. She only asked him what he was going to do with it. Following the murder, the defendant initially fled. He told no one about what had occurred. He has done nothing to show a shred of remorse or regret for the life that he took. The state's recommended sentences meet the goals of sentencing. For all of the reasons discussed here today, documented in the state's sentencing memorandum and observed by this court at trial, the defendant's murder of Caitlin Nafziger is justly deserving of severe punishment. With regard to rehabilitation, there is no evidence before the court that links this defendant's acts of murder, knowing murder, to any psychological, intellectual, cognitive, or developmental condition or deficiency. The state's recommendation leaves in place statutory avenues for sentence relief under earned time credit and under the application for 65120 reduction that this defendant can work on his own to attain. In terms of deterrence, any length of imprisonment below the state's recommended sentences would do little to prevent similar violence. A lesser sentence would instead send a dangerous message to the community, would-be killers, and victims that a domestic violence homicide committed in the presence of a minor child is somehow not worthy of significant sentence. The defendant's actions in killing Caitlin Nafziger and recklessly endangering Elwyn were eminently harmful, have wide-ranging repercussions, and should be strongly discouraged in society. A domestic violence murder such as this is exactly the type of crime that requires a significant sentence to punish and to deter the defendant from similar action, to send a strong message of deterrence to the community, and in order to instill public confidence in the system of justice. As this court is likely only too aware, over 50% of the murders that occur annually in the state of New Hampshire are domestic related. As evidenced by case law and statutory protections, this state has a strong interest in deterring such domestic violence. The defendant killed Caitlin inside of his home in the presence of their children. His actions injured one of those children and caused her to witness the murder of her mother. The defendant shot Caitlin Nafziger from a distance of 3 feet or more while she was seated on that couch with her foot on the coffee table, wrapped in blankets, and while he blocked her access to any exit. For all of these reasons, the state asks that this court impose its recommended sentences in this matter. Your Honor, at this time, there are several persons who do wish to provide impact statements to this court. Some are present here in court today and others are appearing remotely over the WebEx. I may have a moment.
Yes.
Your Honor, the first person who is speaking is Lori Smith. This is Caitlin Nafziger's mother. I believe she'll be at the podium over here with the microphone closer to the television.
And Attorney Duran, I'll say this with respect to each individual who is going to be providing an impact statement. I would ask that that individual please identify themselves by their name and spell their last name for the record. Thank you very much.
Good morning, Your Honor. My name is Lori Smith. I am Caitlin's mother. Lori, Lori, Smith, Smith. As I said, my name is Lori Smith. Caitlin Ray Nafziger is my daughter. I don't say was because she will always be my daughter. It's really hard for me to talk about the impact to me until I talk about Caitlin. I was there for her beginning, her very first breath. I brought Caitlin into this world March 10th of 1992 at 10:32 a.m. She was 4 pounds, 6.5 ounces, and just 17 inches long. And Caitlin has a twin sister, Taylor, 6 pounds, 4.5 ounces, 19 inches long. She was just older by 6 minutes. Caitlin has an older brother, Bailey, older by 2.5 years. Caitlin had to stay at the hospital for 2 weeks in NICU. Caitlin significantly lost weight and then couldn't hold her body temperature outside of the incubator. I was torn apart back then, and I was terrified that she wouldn't make it. I cried before I left her behind for the very first time ever. I had to go home with Taylor and Bailey and leave Caitlin behind. We made daily trips to feed Caitlin and to deliver breast milk to the NICU. Grandma Barb and Aunt Corky took turns running breast milk to the hospital and staying for her evening feedings. Her loving family helped her to turn the corner fast, and the nurses said it was key. Once Caitlin came home, those beautiful girls were reunited. They cuddled up together in the bassinet right by my bed. At first, I woke Caitlin every 2 hours to feed her, but she quickly got in sync with Taylor, and Bailey was the best big brother. Other older half-siblings, Taria and TJ, were also part of her life at that time, and that was Caitlin's beginning. Caitlin's smile was lightning. Her laugh was so fun, it earned her the nickname Goose and others. Life and years went by, everyone growing up, and there are others who are going to fill in with their stories, and my kids like to hear stories. Caitlin was quiet, and she could make herself heard. She would talk to you if she trusted you. She wouldn't if she didn't. Caitlin loved music. She learned to play piano and violin. She messed around with the guitar. She loved books and movies in that order. Caitlin was an excellent student. She earned her Associate of Arts degree. She loved languages, Spanish, American Sign Language, Portuguese. Caitlin dreamed of traveling. She loved food. She loved to cook. She was hardworking, efficient, a valued employee in many different capacities: food service, cleaning, nannying, caregiver to multiple homes, a household manager, and a right hand to many others. Caitlin has two beautiful girls, Elowen, who just turned 6, Valen, who will soon be 3. Bailey is married to Heather. Heather and Bailey have 2 sons, Emmett, 4, and Grayson, 1. Taylor has her son Calvin, who's now 5. Caitlin has older half-siblings, Taria and TJ. Caitlin has step-parents, Rob and Sandy, and my husband, Tim. Caitlin has 2 living grandparents, Don and Barb, plus aunts and uncles and cousins. You will hear from some of them soon. Caitlin had so much family and so many friends. There are many people who have stories to tell about Caitlin and the life lived. So many people love Caitlin, and that love will never stop. On February 29th, 2024, at approximately 5:30 p.m., Caitlin was stolen from all of us. Her life here was cut short. She took her last breath, and I didn't know it for hours. That breaks my heart every day. But Dustin knew, and that monster told his parents, and I still didn't know. They knew for hours. They didn't care about Caitlin or anyone who did care about Caitlin. His parents said nothing to us for hours, and that makes me so angry, justifiably angry. At 3:18 a.m. Central Standard Time on March 1st of 2024, my phone alerted and it woke me up. I took a frantic phone call from my sister-in-law, Brenda. There was an Amber Alert in New Hampshire. Elowen and Valen were missing, along with Dustin Duran, considered armed and dangerous, and he was running with them in his white Subaru with veteran plates. Photos of the girls and the car were included with the veteran plate number V69023, which is embedded in Carolyn Campbell's memory. Life changed over the coming minutes and hours. Brenda had tried to reach Caitlin with no answer, then had spoken with the Berlin Police Department, and they wouldn't tell her anything. Brenda said I needed to call them. So I called the Berlin Police Department after trying to reach Caitlin with no answer. They asked me questions, but they wouldn't answer mine. Can I talk to her? I hope that Caitlin was with the police and that they had her phone. Is she with you? I asked. Is she hurt? I worried she was hurt and couldn't talk right now. I had the visual of her in a hospital bed, hurt. My mind was all over the place while I tried to remain calm. My husband got up for work while I remained on hold, and they were transferring me to the state police. Again, I was asked the same questions to determine who I was, and then I heard the devastating words, "I'm sorry to inform you that Caitlin is deceased." What? I told Tim twice that Caitlin is dead, and it's just impossible. I'm pretty sure I said to the trooper, Sergeant Mallory Littman, listen, we're a law enforcement family and I understand there are steps you need to take. I understand, but what happened? I just need to understand how this happened. He killed her, didn't he? And Tim took the phone for more words from new people. Bianca Monroe, victim witness advocate, became part of our lives. Then I had to call Bailey and Taylor. I woke each of them up to tell them over the phone. I felt sick having to tell them that way, but it couldn't wait. There was no way to say it that wouldn't be horrible. Taylor screamed. Bailey was stunned. We didn't know how, when, or why, or anything yet. And we began the absolute worst day of our lives. Tim called out of work immediately, and the law enforcement family had his back. We called out to our family members, and the shockwaves grew. I called my cousin. I can't come today. I had been working at the PCA for my aunt and uncle. Of course, they knew where I needed to be, and the shockwaves grew further. We were all in shock. There's a vacuum, a gaping hole. Everyone was coming to be together, waiting, terrified for the girls, fearing the worst for hours, and we were all struggling with it, all of us. Just after 10 Eastern, the girls are recovered safely. Thanks to the Amber Alert and Carolyn and Keene PD Officer Velez, Dustin is apprehended. The girls are with EMS and the hospital and DCYF. Now, Mark Duran calls my husband on my husband's cell phone. And it's not that they didn't have our phone numbers all along, both of our phones. I got word from Bianca about the girls' condition, their status, and what needed to happen to keep them together and with family. I wanted to fly out right then to be with them. Bianca told me that I needed to wait because they needed to be able to reach me as the next of kin to the girls and to Caitlin. I asked Brenda, Mark, and Shannon if they would take the steps to be with the girls until I can be there. We're coming soon. And they said yes. Brenda and Shannon went to the hospital and Mark went shopping for everything on the list. They prepared for all of us to take over their lives in space. They did it for the girls. And we're coming as soon as possible. The girls needed family. They held Elwyn and Valen and did their best. They sent us pictures when they were allowed so we could see the girls, still at the hospital, but with family waiting. And more hours go by before the girls could leave the hospital. We hear the manner of death. A single gunshot wound to the head. The manner is homicide. Caitlin died in seconds. Be prepared, the girls were present. Duran under arrest. The charges: second-degree murder, reckless behavior with a firearm, endangerment of a child. And we were all horrified. But now we're able to make our arrangements to leave. Taylor, Annie, and I, Grammy, flew from Minnesota to New Hampshire to the girls, to Caitlin, early March 2nd. We functioned in shock for days. We held Elwyn and Valen and did our best. And there was no time to grieve. It was impossible to describe the emotions, the high level of relief for the girls and concern for the girls, but we just did what we needed to do. I was told I would need to attend a hearing to be appointed as a temporary guardian for the girls, file online, submit it immediately, and that we should be able to take the girls home by the end of the week. We booked our flights for Saturday to go home. Taylor and I went to the funeral home after the medical examiner released Caitlin. Taylor and I made choices together about what Caitlin would have wanted. As her mom, I had to see Caitlin to accept that she was really gone. It couldn't be real. Taylor couldn't, but she waited close by for me. I wasn't allowed to touch Caitlin. I stood near her, looked at her face, crying and shaking, and I told her, goodbye, my girl. My heart was breaking again and I could barely breathe. Then I left her behind. This time she wasn't coming home. Taylor played her favorite music in the car as we drove away from Caitlin back to her girls. We cried and we drove and we told stories. Then we collected ourselves before we went to be with the girls. We held Elwyn and Valen and did our best for them for days, with no time to heal, no time to grieve, just working to go home to family. March 7th, 2024, the hearing for temporary guardianship, where we should be able to go home, some jerk attorney showed up to intervene on his parents' behalf. They weren't even there. Because of your parents and you, Dustin, did you even know? I was not going to leave the girls behind. I stayed. Caitlin missed her birthday. She would have been 32. Caitlin would have celebrated with Taylor. No time to heal. No time to grieve. We had birthday cupcakes, and Elwyn and Valen blew mommy's candles out for her. I was blessed with my attorney, who is now a friend, and we continued to fight to bring the girls home. Your parents calculated and lied to make themselves look more significant in the life of the girls while they stayed in Minnesota until they were allowed to clear out the crime scene. Then they attempted to insert themselves into the lives of the people who actually showed up without hesitation for Elwyn and Valen. As the weeks went by while we fought to go home, we held Elwyn and Valen and did our best for them as it became months before we could bring them home to settle and heal. Caitlin's family members took turns, flew to New Hampshire to help because it takes a village. May 6, 2024, we're finally free to go home. I had done what nobody else could do. I stayed. We loved them and would not let our girls be passed off to strangers. I was not alone, ever. I committed until we brought them back home. May 8th, 2024. Now I am finally home with my husband in a safe place to fall apart. And I did. We found therapy for Elwyn, then for ourselves. Caitlin's memorial service was June 21st, 2024. I couldn't even speak. It was surreal. Dustin, your parents sent a heartless and threatening message that very morning of her service. It was unforgivable and incredibly painful. We continued to deal with one legal attack after another, pieces of the criminal processes from what you had done, constantly reopening the wound. No time to heal or grieve. Still, we will never give up on the love for Caitlin and Elwyn and Valen. Caitlin had so much more to do, so much she was looking forward to. Elwyn has had 2 birthdays without her mommy. Taylor has had 2 birthdays without her sister. Valen will be celebrating another birthday without her mommy. Caitlin is missing Annie and Tyler's wedding and everything surrounding it. She had a brand new blank passport. Caitlin died without a single stamp. Dustin, you pulled her away from her village when you moved to Nevada. Then you broke promises and pulled the rug out from under her. Know this, every time she came back to her village, she came to see me. I knew things were not good, but she tried to work with you. She did her best. When she had enough, she came home to her village again. Now we'll talk about me personally. I received the shock of being notified about Caitlin's death. I felt it and I held myself together. Through most of that day, I held it all back, the responsible person, to be a strong mother for Caitlin, for Bailey, for Taylor. I stuffed my emotions until the end of the day. My sister Lisa finally got my first real release of grief. Why? Then I collected myself. I went home and packed. I cried and I packed books and toys for the girls, their favorite things from my home. I cried as we arrived at the airport because my husband Tim was going to hold down the fort at home. We should be home with the girls in a few days, but he knew I would see Caitlin and he wouldn't be with me for that. Then it turned into months before I could come home, where I could deal with the grief. We did our absolute best for the girls and we held each other up. We were strong women supporting those girls. Tim told us how proud he was of all of us on nightly phone calls from home, and I would talk to my sister each night. I would watch Elowen, afraid to go to bed, up every 10 minutes because she was scared to dream about the things you did. She wanted her mommy. I did too. She would toss and turn at night, cry in her sleep. She wouldn't look in the mirror because she didn't like that girl. We were terrified for her. She was not okay. Valen seemed physically okay, but her mommy is suddenly gone. She didn't understand except to seek someone to trust and to bond with, someone who won't leave her, won't go away, who loves her. I stayed. Valen remembered me. I had been with her a lot, and Taylor and Annie. And then when Alicia came, both girls attached to her, Alicia looked and felt like mommy to Valen. Elowen saw it too. This was crushing, and we needed to get home for stability. Instead, we were held hostage because of your parents' antics and actions. We should have been home where we all belonged. And this still makes me angry, justifiably angry. Delaying grief took a toll on me. Staying in fight or flight mode caused my inability to sleep, and trauma caused nightmares when I did sleep. I kept seeing what I imagined happened. Caitlin told me what happened. She visits me. Elowen told me what happened. I believed her. I still do. I always will. I have a therapist. Eventually, we reached the point that I needed to get medication to sleep, something to manage my anxiety and real complex PTSD, something to minimize my nightmares, then my blood pressure. I have never been on medication like I am now. I still struggle to go to sleep. Those images, my nightmares, it turns out I wasn't far off. Now I'm watching the real pictures, the evidence. Guilty, 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 guilty. Despite what you and your parents want to tell yourselves, Elowen will always love and miss her mommy. She will tell Valen what she remembers. We will believe Elowen. We always have. With my very last breath, I will share Caitlin's love of her girls with them. The toll has been paid from our side. It needs to be paid from yours now. Your selfish hatred led you to take an unjustified, violent, irreversible action in front of Elowen, endangering her, damaging Valen. You took Caitlin's life. Then you ran through the night, neglecting the well-being of the very children that you say that you love. Elowen, your everything, is terrified of the dark, now hates the woods. Now, Dustin Duran, you have a price to pay. I will have no problem watching you pay it. Thank you.
One strong woman, like I said, although I'm sure it's not the strength she would want to have.
Thank you.
I understand that. But it is not easy doing what they're doing, and I have the utmost respect for them. Thank you for joining us.
Good morning.
My name is Terria Prochel, TERRIAHPROECHEL. Can you hear me?
Yes.
Okay. My name is Terria Prochel. I'm Caitlin's older half-sister. I lost Caitlin not once, but now twice. Her death means that this time the loss is permanent. Everything I've learned about my half-sister will be through the perspective of others. Their stories, their experience with her, but not my experience. Not my experience as her sister. Not my experience of listening to Caitlin tell me who she is, what her life has been like. No one can give me the experience of dreaming with Caitlin about what her future held, or to support her in all of the dreams she was already brewing up that I was so excited for. Caitlin was taken from me twice. But this time, it's permanent. I was estranged from my half-siblings when I was young. I didn't even know I was going to have half-siblings. I was 8 years old, and I found out Bailey was in the hospital and his mom was healthy. I was shocked. Who is this mom? My dad has a wife, and she just had a baby? Somehow he completely forgot to tell us, and we had no idea. But a new family was emerging. My full brother TJ and I started weekend visits at my dad's house. At first, Bailey was just a little kid living around, and I didn't pay him much mind, but enjoyed having him around. And before long, the girls were born. But this was so different, and I was a little older. The birth of Caitlin and Taylor was one of the most important moments. I loved being a big sister. I wanted to teach them everything. I wanted to watch them develop, learn the small little things that toddlers learn. Make sure they were taken care of. I mastered the art of multiple bottles, diapers, napkins, and how to skillfully put down one twin without waking the other one up. I loved being with them and growing up, watching them grow up. But most importantly, I got to make sure they were okay. They were safe. Because to be honest, our house really wasn't that safe. Into my dad's having bad and gradually got much, much worse. My stepmom eventually separated. And we moved out with the kids. I did my best to keep coming on weekends to be with them, but it became difficult and eventually impossible, and the visit stopped permanently. But my desire to be with them never stopped. And for about 25 years, I thought about them all the time. I missed them. Being the oldest of 5 is so core to my identity. The experience as a young kid of taking care my identity. And it was taken from me. I spent years searching for the kids, see if I could find them. It was hard as they changed their names. And then when I did find them, I didn't know how to go about it or who to reach out to first. Do I call Lori? We're adults now. Do I call Bailey? So I sat on it for years, just anxious, but wanting to talk to them so badly. Finally, I reached out, and we made a plan. And in December of 2023, me, my brother TJ, Bailey, Taylor, and Caitlin, we all met in person. It was awkward. After so much time, it was so heartwarming. I felt full. I was learning about them. They were learning about me. We were able to compare stories about what we heard our family was. Learn a little bit more about who we are individually and as a family. It was exciting. Caitlin wanted to keep communicating with me, and she did. Started texting, we started spending time one-on-one. It started to turn into a normal sister relationship. It wasn't there yet, but it was budding. Text just for no reason, sharing funny things that happened during the day. As I got to know Caitlin as an adult, I realized that she's silly, playful, whimsical, amazing to be around, smart. In the few weeks I had with her, she taught me so much about how her brain works, how different it is from mine, how she relates to other people and the world. And it was amazing to have someone sitting right in front of me that was related to me, but fundamentally so different and so smart in so many different ways than I am. That's what I was getting from Caitlin, the opportunity to know her, a chance to play, to support each other, to share. And after we reunited, it felt like we were going to have a chance to create new memories and pick up where we are as sisters moving forward. But instead of building that relationship that was just starting to bud, within weeks, Caitlin was dead. And instead of getting to be close to her, I lost her just within weeks of getting her back. But this time it's forever. This family needs the opportunity to heal from this horrific trauma. Having just been anywhere in proximity to Caitlin's family, to me, creates the potential for an emotionally devastating result. So that we all have a chance to move forward, I request that this court give Justin the maximum sentence allowed. Thank you, Your Honor.
Thank you.
Your Honor, the next statement is from Caitlin's aunt and uncle, Lisa and Tim, and our advocate, Bianca Monroe, will be reading.
Honorable Judge Frizzell, I am writing this victim impact statement to share the profound effect of the murder of my beloved Caitlin and how it has had on me, my family, and our community. It is difficult to put into words the pain and loss we have endured, but I hope my words help convey the devastating impact of this tragedy. About my niece. Caitlin comes from a large Midwestern family that values children, faith, family, and community. Caitlin was vibrant, compassionate, and a loving young woman and mother to her daughters. She brought joy and laughter into our lives every day. Her kindness touched everyone she met, and her sense of humor could lighten any room. She had dreams and aspirations, and she worked hard to achieve them. Her absence has left a void that can never be filled. There is no consoling thought in the way Caitlin died. She had so many years ahead of her. The emotional toll. Since her passing, our family has struggled daily with the overwhelming grief. The shock and the pain of losing her so suddenly and violently has shattered our sense of security. Simple moments like family gatherings, holidays, and birthdays have become reminders of her absence. We constantly relive memories, both joyful and painful, knowing we will never create new ones with her. Personally, I have faced sleepless nights, anxiety, and deep sadness. Her future has been needlessly wasted. No one deserves this. It is impossible to move forward without feeling the weight of this loss every day. My family has also suffered because of this crime. They have been affected emotionally and financially, and their daily lives have been disrupted. My other family members, especially her parents and siblings, have been forever changed by the tragedy. The lasting impact. The effects of Caitlin's murder extend far beyond our immediate family. Family, neighbors, many of my coworkers and members of our community who knew her have expressed their sorrow and disbelief. Her absence has left everyone feeling less safe and more vulnerable. It is terrifying to me that you have such disregard for Caitlin's life. The mother of your children. The girls suffer the loss of Caitlin, their mommy, every day. The sense of injustice has been overwhelming. It has been difficult to find meaning or closure. There are so many questions that will never be answered, and the pain of losing someone so young and full of promise never truly fades. Our hope for justice. As this statement is read in court, I ask that Caitlin's precious life, her dreams, and the love she shared be remembered. We hope that justice will serve in handing down the maximum sentence for these crimes, not only to hold Dustin Duran responsible and accountable for taking Caitlin's life, but also to honor her memory and help our family begin the long process of healing. Nothing can bring Caitlin back, but we hope that by sharing our pain and loss, her life and value will be recognized and her voice will be heard. Conclusion. Thank you for the opportunity to express how deeply Caitlin's murder has affected us. We continue to cherish her memories and strive to find strength in each other as we move forward. We ask the court to consider the immeasurable impact of our loss when determining the sentence of this case.
Thank you. I apologize. The next statement is also to be read by Ms. Monroe, and it is of Caitlin's grandparents, Barb and Dom.
Honorable Judge Rizal, we want to share with you our deep, personal, and heartfelt statement reflecting on the profound impact Caitlin had on her family and the immense loss we feel without her. Caitlin grew up in Minnesota, surrounded by a loving family who cared for and depended on her. I am Barb Daly, her maternal grandmother, and I often needed Caitlin's help to do things I couldn't manage on my own. Caitlin had an uncanny ability to notice what needed to be done and would quickly take care of tasks before I even had the chance to ask. Her presence and assistance were invaluable to me. Dustin, if only you had allowed your family to return home to Minnesota safely. Our family misses Caitlin's interactions with our grandchildren and great-grandchildren immensely. We miss her charming smile, her warm hugs, as well as her helpful ways. She had a unique talent for loving and involving all the little ones, whether they were hers or others. Caitlin had the remarkable ability to keep everyone happy, including the adults watching her. She was an exceptional mother who knew how to create a joyful and harmonious environment. When Caitlin and her family moved to Nevada, we felt her absence deeply. However, we were overjoyed when she returned home to Minnesota. And then the unthinkable happened. Dustin, if only you had allowed your family to return home to Minnesota safely. We are in the last years of our life and are now left feeling sad and brokenhearted due to the actions of Dustin. He did not consider the devastating impact his actions would have on their little girls, leaving them frightened and heartbroken. Our family is forever changed by the loss of Caitlin, and we grieve for the love and light she brought into our lives. We don't know how we will ever recover from this horrible loss. There just is not enough time. Thank you for taking the time to read this statement. It is a small window into the profound sorrow and loss our family is experiencing. Respectfully.
Thank you.
Your Honor, the next impact statement will be on the WebEx. This is Caitlin's cousin, Annie Nasser.
You're on mute. Let me try that again. Can you hear me now?
Yes.
My name is Annie Nassiger. It's A-N-N-I-E. Nassiger, N-A-F-F-C-I-G-E-R. I'm writing the statement of my siblings, Madeline and Trenton. Your Honor, we beg that you sentence Dustin to the maximum possible sentence. Caitlin, or G, as most called her, was our cousin. She is deeply important to our family and will never be the same without her. Growing up, despite our age difference, we were all very close. One summer, both of our families, 4 adults, 6 children, all lived in one house. We played together daily. She, along with her siblings, taught us the importance of Lord of the Rings, told us scary stories of the witch who lived in the neighborhood, and she even taught me my first swear word. She taught my older sister, Madeline, how to drive a manual transmission when she was old enough. And we all stayed close into adulthood, bonding over holidays, trips to our family cabin, and with Chi, usually live music in our affairs. She first told me she was pregnant with Evelyn by coming to my house and bringing me a fairy wand, asking me to be her baby's godmother. I accepted with tears in my eyes and was able to hold Evelyn on the night she was born. Years later, when Caitlin was in labor with Balin, I massaged her neck and held her hand while Dustin played on his phone across the room. When our family first met the prosecutors on this case, they gave us a warning. They told us that the justice system is not built for the benefit of the victims and instead would be biased towards Dustin. It will silence G, but it will give him every opportunity to spew his lies. Though I would be happy to never have to speak about Dustin again, I think it's important that I be G's voice in this courtroom because he made sure that no one would ever be able to hear her again. I'd like to set the record straight on a few items. Though we spread countless lies in the courtroom, I'm only going to speak to the ones that I have personal knowledge of. Though there are many more that I won't address today, the jury proved that we can all use our common sense to dispel doubts. She never wanted Dustin to take Evelyn to New Hampshire. Dustin was only able to take her after events and manipulation, as he made her fear for her own safety as well as the safety of the girls if she were to try and stop him. She certainly didn't blindside him with a move to Minnesota from Nevada, as he was the one who ordered and paid for the pods that were sent to Minnesota. And I know this because she was not able to get her own items out of the pod in Minnesota since it was exclusively in his name. Any amount of money that she requested of Dustin was to pay her back for the minimum $20,000 that he had reached from her throughout the course of their relationship. Certainly not as any sort of ransom. Dustin Caitlin lured Chi to Las Vegas by claiming he'd work at the post office until he found something that aligned with his passion. What he did instead was quit without consulting her after a month or two. He refused to get another job for the 3 years they lived in Vegas. During that time, she worked at least 3 jobs at a time to support Elwood and keep a roof over their heads. Dustin did not bring in any income, yet he had no problem running up the bills, including refusing to sell his car, forcing Chi to make the payments, until she ultimately had to sell her own car to stay afloat. He also tried to stop her from using food stamps and government assistance, despite him being unwilling to get a job himself. He kept her in debt so that she had no choice but to stay. Dustin had laid his hands on Chi before, and though I can only wish she told us sooner, she told me after I had to help her file 2 separate police reports after Dustin refused to return the girls based on their agreed upon custody schedule in Minnesota. The reason he wouldn't let the girls leave with their mother was because she was afraid to tell him the address that she was living. She told Dustin's parents that day that she was scared of him, that he wasn't a safe person, and that he had guns. Dustin's dad, Mark, told her that that wasn't true, that she and the girls were safe around Dustin. This was only a few months before Dustin shot her in the head with the gun that his father gave him. Ellen was not okay, and certainly not happy after she both watched and felt her mom be murdered. Anyone who spent more than a few minutes with her could tell you that. She recounted her mother's murder to anyone who listened nearly every day for weeks following the crime. As this is a courtroom, I should be fair. To Dustin, I should tell you I do believe you on some items as well. I believe you that she refused to leave your house without her daughters. I believe that because she loved them fiercely, and leaving them with you would have been subjecting them to a life of abuse, control, and isolation. I believe you when you said your computer was your life. I believe you in this police interview when you said you knew what you did was wrong, but clearly no one could believe you when you said you were ready to accept any consequences. Despite all the trauma and heartbreak you caused, I'll rest easier after today. At the end of the day, I will leave you to carry all of my pain, all of my suffering, and I will get to leave today as free as a bird. I'll go and wrap my arms around my goddaughters Ella and Dalen and find solace knowing that neither they nor any other woman will ever be harmed by you again. Your Honor, thank you for the opportunity to offer our victim impact statement. The murder of our cousin continues to haunt us more all the time. We feel the loss of her in each passing holiday, where her small hands were always preparing our family's traditional meals, tidying up after an eventful game night, or joining in telling stories around the fire. With her humble demeanor and go-with-the-flow vibes, she always put others ahead of herself and would try to facilitate everybody else's good time. Our family portraits will always have an unfillable void where a small but mighty woman once stood. Chi's children will continue to grow older without her direct love, care, or guidance of the wonderful mother who made them. No penalty would be sufficient to remedy the loss of Caitlin, but we hope that Dustin's punishment is for life. There should never be a day where he feels he's paid his penance for taking Chi's life, as there will never be a day that our broken hearts will be whole again. Thank you.
Thank you.
Your Honor, the next statement comes from Brenda Clemente, Caitlin's aunt, who's in person.
Brenda Plamondon, Plamondon. Honorable Judge, thank you so much for allowing me to make a statement about how Caitlin's murder has impacted me emotionally, physically, and financially. I'm Brenda Plamondon. I'm Caitlin's aunt. Throughout the years, we have spent an unknowable amount of time together, including our whole family sharing a roof one summer. Caitlin coming to live with my family for a period of time after high school.
Oh, hold on, guys. Their feed is glitching. I'm going to reboot their feed.
The last non-incarcerated adults to see her alive.
That's still on them.
Emotionally, I want nothing more than to just go back to being normal again. And I have to live with this the rest of my life. That Shannon and I drove Caitlin and dropped her off to meet that monster. And I drove away and I left her there alone with a bag of wet clothes because my dryer had stopped working because of the flood. I have to question my judgment, and I wonder if my family secretly blames me. But I am thankful that Shannon and I are alive. I have no doubt. Had we entered that restaurant with Caitlin, we would all be dead. Shannon and I picked up the girls from the hospital after they witnessed Dustin murdering their mother. Within minutes of our arrival, Elwyn told me what had happened. Elwyn said to me, "My daddy had his pew-pew, and he pewed my mom, and there was blood. My ear hurt."
Oh
Elwyn's
my
story
God.
has never changed. She has even acted it out for me. The way her mommy's body wrapped around her went limp on the sofa. A few days after Caitlin's murder, Elwyn again recounted how her father had shot her mother and then told me, "My daddy didn't like my mommy anymore." What could be worse than that? The haunting sentence that followed: "Did my daddy like you?" Even a 4-year-old child was able to surmise that if her dad didn't like you, he may kill you. Physically, I feel exhausted. I have bags under my eyes from not being able to sleep. Even though I know Dustin is in jail, I have dreams that he's coming for me, and I certainly believe that he would kill me if he were ever allowed out of prison. Talking about it, I have a constant knot in my throat, and I feel physical pain and numbness in my head. Prior to their mom's murder, Elwyn and Valen were never New Hampshire residents. Mark and Deborah Duran were quick to take this opportunity of Caitlin's murder by their son to continue their fight to gain custody of Elwyn. By default, they included Valen. The custody dispute was the reason the courts in New Hampshire mandated the girls stay in New Hampshire while they determined jurisdiction for an entire group of people who were not New Hampshire residents. I believe the Durans, Mark, Deborah, and Dustin, began this custody battle while Caitlin was still alive in Minnesota, and that was their chance. A different state, different rules, and a dead mother. Deborah and Mark Duran hired a New Hampshire custody attorney and sat back comfortably at home in Minnesota, and like their son Dustin, continued to let Caitlin's family do the heavy lifting. The resulting financial impact was enormous. Tens of thousands of dollars were spent on airfare, housing, vehicles, and basic necessities, while the parade of Caitlin's loving friends and family dropped their lives to care for these children. My husband Mark and I tried to lessen the family's financial blow by providing housing and transportation for more than 3 months for Elwyn and Valen and their steady stream of caretakers. For their benefit and use, we gave 2 vehicles and one of our properties, and this meant foregoing the rental income that we would have been received. Though we would have gladly housed them in our primary home, we were victims of the 100-year floods in Hampton just the week before. Never once was there a display of sympathy, empathy, or financial support offered by Deborah, Mark, or Dustin Duran. They are not good people. Caitlin was quiet, bold and full of unbothered happiness. I could still hear the way that Caitlin would say Elwyn's name. It's like she had all the time in the world and didn't want to rush the letters out of her mouth. She'd start with a slight L, cheerful and optimistic for what was coming, and then a deeper pitch and exaggerated O, with her mouth rounded like she was trying to hide a smile. Then the yin was soft, feminine, almost like she was singing it, Elwyn. Ellen. Caitlin was always up for an adventure. She was part of a group, part of our family. And the absence left by her not being here cannot be explained. The last Thanksmas that Caitlin attended, she was pregnant with Valen. Dustin again didn't allow her to bring Elowen. Mark and Deborah Duran also began helping Dustin withhold Elowen from her mother. Thankfully, Dustin, Mark, and Deborah don't have much interest in Valen. But Elowen is just a little girl, and she's being treated like an emotional support animal for Dustin, Deborah, and Mark Duran. For all these reasons, I beg your honor for the maximum allowed sentence
Wow!
with no possibility of parole. Nobody in my family, including Elowen and Valen.
Okay, I gotta go back. That was a blow.
Thankfully, Dustin, Mark, and Deborah don't have much interest in Valen. But Elowen is just a little girl, and she's being treated like an emotional support animal for Dustin, Deborah, and Mark Duran. For all these reasons, I beg your honor for the maximum allowed sentence with no possibility of parole. Nobody in my family, including Elowen and Valen, will be safe if he is ever allowed back into society. Dustin, I was glad to hear that you're reconnecting with your faith. You are going to need that relationship with God to get through the tough times you have ahead of you. The first step in your spiritual journey is to stop lying. I have a couple of Bible verses for you. John 8:44. You are of your father, the devil, and you want to do the desires of your father. He was a murderer from the beginning and does not stand in truth, because there is no truth in him. When he lies, he speaks from his own nature, for he is a liar and the father of lies. I share this verse with hopes that you understand the consequences of lying. It's spiritual death. But I want to encourage you, of course, there's hope in Christ. This is your life now. I recommend that you focus on being truthful and helping others from where you are in prison. 3 short verses of encouragement for you, Dustin. Ephesians 4:25. Therefore, each of you must put off falsehood and speak truthfully to your neighbor, for we all are members of one body. Colossians 3:9. Do not lie to each other, since you have taken off your old selves with its practices. Proverbs 12:22. Lying lips are an abomination to the Lord, but those who act faithfully are his delight. And Lord, in your word, you promise rest for all those who cast their burdens upon you. So here in this courtroom, I lay down my fear, my anxiety, and sorrow, and trust in your true judgment and justice. In Jesus' name, amen. Thank you all for your time and consideration.
Thank you.
Your Honor, the next person with a statement is Shannon Spurgeon. She appears in person.
Wow, y'all.
Your Honor, thank you for allowing me to speak today. My name is Shannon Spurgeon, Spurgeon, and I was one of the last people to see Caitlin alive before she was murdered. Nothing can prepare you for the heartbreak of losing someone like Caitlin. Losing her in such a violent and senseless way shattered everyone who loves her. In the days that followed, I faced moments that will stay with me forever. Walking into the hospital with Brenda to pick up Caitlin's little girls was one of the heaviest moments of my life. Elowen had witnessed the murder. She told Brenda. She told me. She told everyone. She saw it. She felt it. And she will carry those images for the rest of her life. No child should ever have to live with that level of terror or confusion. I changed Valen's diapers. I held her when she cried. I tried to create moments of calm when nothing about their lives made sense. What haunts me the most is the time leading up to Caitlin's murder. The day before and the drive up to bring her to meet him. Had moments of laughter, but none of it felt carefree. All of us had been through domestic violence in our own lives. We understood the danger. We feared for her. We told her to leave anything she valued behind. We created a safe word. When she stepped out of that car, she looked so small, yet so determined. Brenda and I cried as we drove away. We will never emotionally recover from that moment. I even made a thoughtless comment that everything felt so wrong and chaotic that we might end up on the news. I also truly believe that if Brenda and I had walked into the restaurant with her that day, we would be dead too. I fear for my safety and for hers even now. That fear stays with me every single day. My life and the lives of everyone around her changed drastically the day she was murdered. Caitlin wasn't just my friend. She was a part of my family. She was kind, funny, strong, whimsical, and full of life. She loved her children fiercely. I feel deeply connected to her girls. I feel a responsibility to protect them. And witnessing their pain and confusion has changed me in a way I will carry forever. Because of one person's choice, her daughters must grow up without their mother. They will have birthdays, school plays, graduations, and weddings she will never see or be a part of because of Dustin Duran and his family. Nothing fixes this. But the only small sense of peace comes from knowing he will finally be held accountable and that he will never again have the chance to destroy another family. Caitlin deserved to live. Her children deserved safety. They deserved their mother. They deserved a childhood without nightmares. And all of us deserved a future where this never happened. Instead, we are left in the middle of a tragedy that we will never forget. We will never stop missing her, and we'll never stop carrying the weight of what he did. Thank you, Your Honor, for allowing me to speak for Caitlin and for all of those whose lives will never be the same without her.
Thank you.
Your Honor, the next person presenting a statement is Sarah Heil, and she is, and I apologize if I said that last name incorrectly, she's appearing via WebEx.
Y'all, do you see all those documents that woman has? Those are all impact statements. Oh my God, is she reading all those? We're going to be here all afternoon, y'all. And also, please, thank you, Court TV, for the feed. If you are struggling with this, as if this is getting a little too difficult for you, it is acceptable, and we encourage you to step away and come back. Your mental health is priority to us, so please take care of yourself.
Hello, Sarah Heil, S-A-R-A-H, last name H-E-I-L. My name is Sarah, and my best friend is Murder. Never in my life is this a statement I thought would be my truth, and now I painfully live with that fact and hardships in my life, but never thought I would have to learn to cope with an unjustified, violent, intentional murder of my best friend who I lived with. I find it nearly impossible to put into words what Caitlin has meant to me. No, her murder has impacted me, my life, without writing it into your book. Caitlin had an indescribable magic energy about her that brought me a sense of belonging and purpose. Caitlin called me her light, but in truth, she was mine. I don't quite know how to exist without her, nor would I ever choose to willingly. Caitlin wasn't proficient with expressing herself through words, but through long conversations sitting on the couch, dancing, and simply living life together, Caitlin was able to verbalize some things with me that she hadn't been able to previously. I am the one person who she shared everything with. I was her confidant, and it is now that it would be an honor to speak for her since she cannot. There's not enough space on these pages to list the inconsistencies, delusions, and straight up lies that were told and inferred by Dustin and his attorneys during the trial. Instead of listing what I know to be true from text messages and phone conversations with Caitlin, listening to conversations between Dustin and Caitlin, and my own attentive observations, will focus the broader scope of the impact Dustin's actions and attempt to speak on behalf of my best friend, the dearly departed Caitlin. Caitlin was scared of Dustin and felt trapped. There were several instances during their time in Nevada that Dustin became aggressive with Caitlin during arguments, and even as a toddler, Ellen tried intervening. When Caitlin and Dustin decided it was time to leave Nevada due to finances and lack of family and friend support, Caitlin and the girls moved in with me in Minnesota. Caitlin did not want Dustin's parents to be alone with the girls and did not want Dustin to know the location of her safe haven with me. Caitlin shared with several of her closest loved ones in recent months before her death that if anything were to happen to her, she wanted the girls to be raised by her brother Bailey, her cousin Annie, or me, and in that order, as she said. We were all supporting each other to manage our separate households and the children at the time, so it seemed as though she knew the danger she was in and what Dustin was capable of. Dustin's behaviors of control, delusions and paranoia, threats, and physical violence prior to his choice to kill the mother of his children are worth mentioning. As far as I understand family law, Dustin had no legal rights to the children as they were only residents of Minnesota and Nevada, in which unmarried mothers automatically assumed parental custody, and Dustin never filed for custody with the court. Yet he claims Caitlin was holding Ellen hostage and that she was trying to kidnap them. Dustin's delusion that Caitlin was going to take the kids and never let him see them seems to be the motivating factor in all of these unjust experiences. Caitlin had no intention and didn't even suggest that she would ever try to keep the girls from Dustin. In reality, Dustin actually physically kept the girls from Caitlin on countless occasions and became aggressive or violent when she tried to reason with him. Caitlin reported one of these moments to local Minnesota police where Dustin was staying with his parents and the police did nothing. Dustin also bruised Caitlin's back with a physical assault in front of his father when she asked Dustin for financial support. Yet defensive Dustin's actions continue. During confrontations in Nevada, Ellen would stand between Dustin and Caitlin and scream at her dad. Ellen has since shared with me that she wasn't strong enough to protect her mom. Ellen's own thoughts and observations of why her dad killed her mom is that he wanted the girls all to himself and he wanted mom gone. Dustin ruined his children's lives and Caitlin died protecting them. During the defense trial, Dustin showed no signs of remorse, regret, or compassion for killing the mother of his children, or how Caitlin's loved ones, including his own children, have been affected by it. His long-winded defense proves that he still believes he was justified in committing murder. Unfortunately, my best friend's life ended as a perfect example of the importance of the support needed for mothers and women living with domestic violence. believed that the murder of my best friend was an inevitable fate. Dustin was determined to control the situation, even if that meant she had to die. Dustin has not and will not learn to be a lawful human. He was determined to have the children to himself regardless of things like moral decency or the law. He should never be allowed to live in a civilized society or have any rights to be active in his children's lives after the terror he has placed on all of us. It is impossible to state how the murder of my best friend has impacted my life because it has taken control of everything and continues to take control at any given moment. None of Caitlin's adult loved ones have even had a chance to focus on ourselves and deal with our own loss and grief or how it has impacted us fully, because we all have been focusing on the effect it's had on the girls and trying to ensure they are safe and cared for. The aggressive nature of Dustin's defense and his family's non-compassionate actions and words, even after an entire jury found Dustin guilty on all charges, continues to impact all of our lives. For me personally, there was the initial and immediate trauma effects of finding out what happened, trying to figure out what to do with myself and how to continue to exist. Everyone I lived with was suddenly gone and never coming back. I could not return to my home for weeks after the murder. My entire daily life was instantly changed, and I'm reminded of this every day with the silence and ghosts in my home. I immediately started attending weekly trauma-focused therapy sessions. About 6 months after speaking with investigators and the initial trauma started wearing off, I began experiencing frequent ocular migraines that caused me to have temporary blindness. I've gone to the emergency room at least 4 times through panic attacks since the murder. And now I'm forced to diligently work on managing the post-traumatic effects of the event. I took honored responsibility for Caitlin's and the girls' belongings after she was killed because they lived in my home. Due to the girls not being able to return to Minnesota for months after Caitlin was killed, I focused on sorting, packing, and distributing her treasured belongings. During these months, I spent long hours seeking information for the criminal case that only I might have. This is all I could do. As soon as the girls returned to Minnesota, I realized the new reality that my life was forced into. I could be there for them and start to help them have some familiarity, comfort, and a sense of their mom after the horrific events that they were forced to experience. Dustin's previous and continued actions have given me a new sense of fear and rage that didn't exist prior to the murder. I now have to live with and manage daily, regardless of the results of this sentencing. I've missed countless days of work due to the trauma of the murder. The mental, emotional, and physical impact Caitlin's murder has had on myself has also affected all of my other relationships, my work, and every aspect of my life. Dustin's actions have absolutely impacted me financially as well, but money is the least important in the wave of his destruction. When Dustin chose to end Caitlin's life, he became not only a murderer, but also a thief. He stole dreams, futures, hope, joy, and love from everyone who loved Caitlin. Caitlin and I had a dream of a future shared home and life that I now have to live without. Dustin stole loving attachment and healthy development from his children. He replaced trust and love with terror and despair. Dustin not only ended Caitlin's life, he ended my life, his children's lives, and Caitlin's friends and family's lives. Anyone who loved Caitlin and saw a future with her was also killed when Dustin pulled that trigger. We are now forced to live lives and plan for futures that we did not choose. Our free will was murdered along with our dearly loved Caitlin. There's no justice in any of this. Regardless of the sentencing, we all have to live a life we didn't choose. Instead, Dustin chose it for us. Caitlin will always be my soul sister and best friend, alive or dead. Caitlin and I decided that we would be each other's platonic life partners, and now I have to live without that. I ask that the court sentence Dustin the maximum amount possible for each individual charge. Even this maximum sentence will not accurately punish Dustin for his unlawful, whether charged or not charged, action. Nor will it give us our lives and beloved Caitlin back, and may help us to find a new sense of hope for moral and just humanity in the future here in Walshe Trial. Thank you.
Thank you.
Your Honor, the next impact statement is also remote and is from Heather Nafziger on behalf of herself, Caitlin's sister-in-law, and her brother.
Hello, Heather, H-E-A-T-H-E-R, Nafziger, N-A-F-F-Z-I-G-E-R. My name is Heather, and I'm writing this statement jointly with my husband, Bailey. Caitlin Nafziger was our sister and sister-in-law. We, along with many others, called her Goose. Goose was our light. She became the sister I never had and had always wanted. We enjoyed cooking together, and Goose would often come over to our house with the kids or by herself. Our home was her home. When she lived in Las Vegas, we would FaceTime with her and the kids often. We have always been a part of her and her girls' lives. I was there for the birth of Elowen and would help her often when she wasn't living out of state. Her dream was to live on a commune or within a co-housing system with her closest family and friends. She had so much love to give. All she wanted was for everyone to be together. They say with death that time can lessen the pain, or at least the initial shock. But the amount of pain we have endured is unfathomable. Even now, nearly 2 years since she's been gone, we remain devastated. We will never forget the exact moment we got that call at about 4 a.m. and that she had been killed. Bailey answered the phone, and I will never forget the gut-wrenching feeling I had. No, I couldn't hear anything except for Bailey's mom's hysteria. The phone call was short. He hung up and aggressively threw his phone across the room and screamed, "He fucking killed her!" The level of panic and rage on his face, and now mine, was like nothing we've ever experienced before. Nothing made sense. She was just at our house for dinner a few days before, telling us she was going to visit Elowen with Dalen. After that horrific phone call, we called all of our family members to come over to be with us. For weeks, we had every person in our lives come to our house to mourn the murder of our small, mighty Goose. That day will haunt us for the rest of our lives while we raise the girls. Dustin, we can speak for many when we say a big part of us all died that day. Since Dustin unremorsefully murdered our sister, we immediately started weekly individual therapy and eventually coupled therapy. We found one of the top trauma therapists to see Elowen almost immediately after the event. Since day one, she has talked about the events of that day. She has replayed the rage on Dustin's face. And she would sometimes have hour-long episodes of uncontrollable rage and panic because she wasn't strong enough to protect her mom. She would pace the therapy office sounding like a wounded and dying animal. She even said to Goose's best friend Sarah that her dad just wanted them all to himself and wanted mom gone. There were and still are days when the panic and shock consumes us all. I had panic attacks often. I went on walks alone and cried until I was numb. I would sometimes fall to my knees, pinching catching myself wondering when this might ever end. It got so bad that I needed depression medication. There aren't words to describe what Bailey feels every day. Just like Goose always did, we find solace in music, and I can't help but draw parallels to the song Growing Sideways by Noah Kahan. Bailey continues to move forward, though he has been running on empty ever since she was taken from us. In the time leading up to the trial and during the trial, we felt deep uncertainty about both the present and the future. In addition to our grief, we had new fears of our personal safety and for the safety of the girls. The public nature of the trial put us in a constant state of hypervigilance. Nothing could make me feel protected. Time will never heal our broken hearts. Our broken hearts, along with the broken hearts of our son, Emmett, and Caitlin's daughters, Evelyn and Dalen, will always be clinging to the memory of Caitlin or Goose. She loved fiercely, and her presence was always felt by those lucky enough to know her. She would come over to our house weekly to have family nights. Her company dancing would always bring a smile to our faces. Emmett would burst into happiness when he saw her, never wanted her to leave. Not even 2 weeks after she was murdered, we found out we were pregnant with our second child. In fact, we found out when we flew to New Hampshire to be with the girls. Though our son Grayson has never met Goose, he will always know of his aunt, and he will see her in the girls as they all grow up together. Our family members always said Bailey was Goose's favorite and her hero. We did everything because we could to support her. At times, she would ask for money as she was working at least 3 jobs and barely scraping by to provide for the girls, all the while Dustin was not working. She had said that if anything were to happen to us, she would want Bailey and me to care for her 2 girls. It was mentioned on several occasions to her closest loved ones that should anything happen to her, she would want 3 people to raise her girls in this order: her brother Bailey, her cousin Annie, her best friend Sarah. Those of us she shared this with immediately took action after Dustin decided to take her life and started discussing options for the girls to honor Caitlin's wishes. Being her first choice, Bailey and I have honored his sister's wishes, and we are raising the girls on her behalf. We will cherish and take care of her girls as they were our own. This all became exponentially impactful as now our entire focus was on making sure the girls were okay, and we had to set our own needs aside of healing and grieving. A big part of us died with Caitlin that day, but that has only strengthened our commitment to grant her wish for us to raise her girls. We love you, Goose. And now we will take that love and compassion with us to parent your girls for the rest of our lives. Whatever Dustin is sentenced to will never compare to the loss we all feel or bring Goose back to us. Your Honor, we believe he should serve the maximum potential time. He showed no remorse or capability of it. Allowing him any leniency would only give him another opportunity to harm Elowen, Valen, and our family. Additionally, Elowen's therapist has requested that the child endangerment charges not be served concurrently with his other charges. As a 4-year-old, there is nothing I could do to stop the terrifying situation she was forced into. Perhaps when she is an adult and understands her family framework fairly, authority, her therapist hopes she may feel that some justice was served for what was done to her personally. We ask that you please give special consideration to this request. Thank you.
Thank you.
And finally, Caitlin's stepfather, Tim Smith, is here in person and would like to speak.
Honorable Judge Jonathan Frizzell, my name is Tim Smith, T-I-M-S-M-I-T-H. Judge Frizzell, Caitlin is my stepdaughter. She was taken from us, her family, by the defendant, Dustin Dern, on February 29th, 2024, Leap Day. I echo all the sentiments already voiced by family and friends, and thank you in advance for your consideration in this matter. When I think of Caitlin, the first thought that crosses my mind is, where would she be today, now? Caitlin was just starting to get her life figured out and set her course. She would have no doubt impressed us all with all her unique journey in her life, which was cut short and ended by the defendant, Dustin Dern, executing her. I'm going to be respectful of your time, Judge Frizzell, and let's get right to the matter at hand. The sentencing of Dustin Dern, who has been found guilty by a jury of his peers of the crime of murder and other aggravating, despicable crimes. Due to the heinous nature of the crime of murder that Dustin Dern has been convicted of committing, I implore you, sir, to impose the maximum possible sentence and that you make an upward departure in this sentence due to the following factors. Dustin has shown no remorse and lacks any sense of empathy for anybody impacted by his actions other than himself, including his children, which speaks to his narcissism. Dustin stole the innocence of childhood from the very people he professed to love and cherish. He and Caitlin's children, Elwyn and Valen. He murdered their mother in their presence. Dustin made a conscious and deliberate choice to execute Caitlin while she held their daughter, Elwyn. Elwyn will never forget what she witnessed, the murder of her mother at the tender age of 4 years old. Dustin adamantly believes that he is justified to murder when he doesn't get his way. The murder of Caitlin culminated years of classic textbook domestic violence. Isolate from family and established support systems. Move to Las Vegas and New Hampshire. Dominate, intimidate, control. When the control that Dustin imposed on Caitlin, which was facilitated by using their children as pawns, was lost, he knew he had lost control because Caitlin told him so. Like so many abusers, Dustin resorted to murder in a vicious attempt to maintain that control at all costs. I don't give my opinion on this matter, sir. I speak from 30 plus years of law enforcement experience in which I have and continue to serve in a maximum security facility and deal with all varieties of offenders on a daily basis. It's a violent, hostile environment, and I have witnessed numerous suicides. It hasn't made me a murderer. In closing, I would like to take this opportunity to thank the members of the jury for their service and all the good people in New Hampshire. Numerous citizens of this fine state have shown love, support, and compassion to my wife, my grandchildren, and our entire family, and we are forever grateful and appreciative for the support. And may God bless them all, including you, Your Honor, and all the law enforcement personnel that did their jobs. Dustin, there are laws, spiritual laws. I had to do the hardest thing in my life. When I found out that you had executed my stepdaughter, Caitlin, I immediately forgave you, had to. Hardest thing I ever did for selfish reasons, because the Lord says, if you don't forgive, you will not be forgiven. But I do, sir, truly forgive you. Criminal law, you committed murder. You must pay a severe penalty. One law does not negate the other. And in doing so, I hope you do that with honor. Serve your sentence, whatever is handed down today. Do it with honor, because It's shown through, any of your therapists can tell you, if a parent would commit suicide, their children are apt to do the same. Don't put that on your children. Restore your honor, serve your sentence, help others. May justice be served, and I will thank you in advance, Judge Frizzell, for ensuring that justice is, in fact, served. Thank you, sir, and thank the people of New Hampshire. May God bless you.
Thank you.
Your Honor, the state has nothing further that's needed.
I find it interesting he talked about Dustin self-harming himself. That was an interesting comment. I was surprised to hear that.
Okay, it is now 12:53. I will, 1:30, is that sufficient under the circumstances?
Okay, Miss June. Do you want me to go to the Walshe thing? I think I shall.
Yeah, you already have it keyed up, right?
Well, I did, but I'll get it. It'll key up in about 2 seconds. Let me get my 1 or 2. There we go. Court TV.
Yeah, we could be your voice. You could be your fingers.
Walshe. Oh gosh, my head is swimming. Okay, here we go. There's some fiery, interesting exchange in the last part of the day where they're going through and setting up for closing arguments. And there's some interesting banter back and forth that I thought we might want to see. Here we go.
Have a little bit more tomorrow. All right. So, my approach to charge conferences is pretty informal. And so, what I'll ask for each of you to each side is, based on your initial review of the draft, where's the first page that you wish to either bring something to my attention because you either don't want it in there or you want it in a different way. So an edit or an extraction or an addition. What's the first page for the Commonwealth?
Your Honor, I'd say page 15 going into 16, the impeachment by prior conviction.
All right, stop right there. And does the defense have anything before page 15?
Number 1.
Page 1?
I think it is. She just took it.
Are you joking?
No, it's, I'm sorry. Premeditation. I'm sorry, I have it 1 here, but I meant what my notes are saying. It's paragraph 1.
I said page 1 is the index. Actually, it's not really page 1.
No, we'd be here forever if we were starting with page.
All right, so what page?
Page 6, and I'm just lodging my objection, Judge, to otherwise the instruction complies, in my opinion, with the model jury. I'm renewing my request for my modification that I filed on behalf of defendant's request for jury instructions concerning consciousness of guilt, emotional evidence, and bad acts. Paragraph 1, I am asking that the section B regarding the timing of premeditation be removed for the reasons I stated in the motion.
All right, I read your motion. Denying your request to make the change. As you know, if I agreed with you, I guess the underlying premise that I thought there was something wrong with that instruction, I agree with you. These are just model instructions. Now, they're model instructions that people have spent, I don't know, countless hours assessing the propriety of, but I don't think that that instruction is improper in any way. I think it's a proper instruction, and it's one that ought to be given in this case. So I won't modify the model SJC instruction with regard to the request, but it's been fully preserved for the appeals court if they decide to change the instruction.
Thank you, Judge.
So,
Polite way of saying, yeah, no.
15 on to 16. Anything from the defense before page 15, other than what you just mentioned?
Page 9,
Yes, counsel.
the instruction, parentheses B,
Yes.
use of a dangerous weapon.
Okay.
I think that's in the context and circumstances of this case, that instruction is very prejudicial and misleading. There is no evidence of, no direct evidence or circumstantial evidence that there was a weapon used that caused the death of Anna Walshe. And so what the jury is being allowed to do.
What about the breadcrumbs that the Commonwealth put down?
Here we go.
What, the breadcrumbs?
Well, why don't you argue, then I'll let them make, I don't want to make their argument for them. That would be, but I want to get to the right answer. So go ahead and you argue, and then they'll argue, and you'll have an opportunity to rebut.
I understand the admission of the exhibits, and I understand the admission of the hacksaw, but to suggest to the jury that they can just pick and choose whatever, quote, weapon, even if you can define it that, and just speculate as to, well, this was used, this wasn't used, that is requiring the jury to speculate that a weapon was in fact, in the first instance, that a weapon was in fact used when there's no evidence of that. And secondly, to speculate that some of the evidence that was introduced might have been a weapon that was used without any evidence that in fact it was. And given the state of this evidence, this instruction invites the jury to speculate without sufficient evidence to reach its conclusion, and I would ask that it be removed because all it does, well, I'm repeating myself. I'll leave it at that.
All right, Commonwealth.
Your Honor, it suggests from the evidence it's a reasonable inference based on the safari history and the searches regarding getting DNA off of a knife, using a dishwasher to remove DNA. One can infer that an object was used, a dangerous weapon was used to murder Anna Walshe. There's also the evidence of the defendant's trip to the Vin and Liquors dumpster when the liquor store was closed. I believe the manager of the liquor store identified it as the defendant throwing that bag in the dumpster. That's prior to the trip to Lowe's or any of the stores where he purchased the materials. I would suggest it's a reasonable inference that a dangerous weapon was used here, and would ask that the court keep that instruction in.
I might have misheard, but I thought I heard Ms. Cusick say DNA on the knife.
No, she didn't say that because there is no DNA on the knife, right?
That's correct, Your Honor.
So, but I did hear you say knife, didn't I?
Knife. I didn't hear her say knife just now.
There was
I did.
There is the knife above the.
There is a knife, but there is also a search in the web history in the defendant's.
I remember that. And then
regarding.
It was, the search was specific as I recall it, and remind me if my memory is wrong. Is the search with regard to the dishwasher specific to a knife?
Your Honor, may I? I believe that I can answer this question. There is a slate.com article
right.
that the defendant went to that was regarding getting, can DNA be removed from a knife?
Yes.
Then the dishwasher is
following that, right?
It follows that, and it's can the dishwasher, and I'm just trying to find the exact words.
Give me the page number on the, I think it's exhibit 79, is that right?
It's exhibit 79.
All right.
And then page number 4, the DNA off of a knife.
Yes.
Is page 578.
Let me get there.
Okay.
Defense lost that one.
I'm there.
Okay. Then if you go to page 670.
Hold on, I just want to look at these.
Sure, I apologize.
How long does DNA last? Is it possible for DNA to take DNA, clean DNA off of a knife? And that's done on 1/1/23 at 9:34 a.m.
Yes, Your Honor.
Okay, and just putting all this evidence together. When was the Vinton's Liquor is also on the 1st. It's at night because I remember it being a little dark. What time is that?
It's dark at the at Vinton Liquors.
5:30, 4:30, something like that?
5 p.m., Your Honor.
All right. Okay.
And so if you were to go to page 670,
Yeah, let me get there. Yes.
and if you were to go to record 2430,
Does the dishwasher clean blood?
yes, Your Honor.
That's at 1/1 at 152, also before the,
Been in liquors.
right.
And then on page 671, there is record 2433. Is it possible that a knife that
Which had blood on it remains contaminated with HIV after it's been washed with hot water and dishwasher soap.
Yes, Your Honor.
Mm-hmm.
And so,
And above it, does the dishwasher clean blood?
yes, Your Honor.
She's going to let it in.
Mm-hmm.
How much you want to bet
So,
she lets it
I
in?
think earlier you referred to breadcrumbs.
That's what I said.
And so our position would be it's a reasonable inference based on the searches, the behavior of going to Vin and Liquors, and then this is all before the Lowe's trip where the other articles are bought for the purposes of the dismemberment. And if you look into the searches on the second, it's instructions on how to dismember. So there I see the way, what our argument is that those searches show the reasonable inference that a weapon was used.
Yeah, I agree.
All right. There are the breadcrumbs. Attorney Tipton, back to you.
Guys, this is my thought on this, and I know it doesn't mean a lot, but my humble opinion, he's correct. Why would you search the internet in that manner if you did not use that kind of weapon? If you would have used a chainsaw, you would have searched differently than if you would have used a knife. In my humble opinion, I think she's going to allow it in.
Not going to repeat what I said. I understand
What do
the
you think?
breadcrumbs argument. However, I would ask then, I think I see the writing on the wall, that the instruction will remain, but I would ask then, to be fair and balanced, that a sentence be added, that you are not to speculate about whether a knife was used, or words to that effect to help guide the jury to avoid speculating about any and all of the tools and weapons, so-called weapons. I just think the jury's going to think, oh, I can cherry pick whatever I want to and call it a weapon and use it to find the defendant guilty of first-degree murder. And I'm trying to make sure that the jury does not get such a broad instruction that allows them to speculate. So I'll leave it at that.
Well, I'll give some more thought about whether I add some language in there with regard to speculation. And if you wish, you can provide me with some recommended language. But as you know, the whole issue with speculation is handled quite completely in other parts of the instruction. But I'll think about it.
I will send the court, if it's okay, I'll send an email to the court today with suggested language.
All right. As of this time, the instruction is going in and subject to any additional edits. But I think there's enough there that the Commonwealth has presented, as I said, the breadcrumbs. Which, you know, this case is what it is. It's been a circumstantial case from the beginning. And so those breadcrumbs are important for the Commonwealth's case. And I think they've properly established it to a sufficient degree to get this instruction about use of a dangerous weapon. But I'm also mindful of what you say. I'll go back and look at the section about the prohibition against any speculation or guesswork and see if I feel like it accurately and completely addresses those concerns.
And I'll be open to seeing whether there's something else that needs to be added to make it more easy for the jury to digest this aspect. That's all I can say right now. All right. We're still at the defense. Anything else before page 15?
No.
All right, so now we'll move to the other side. What is your, I'm moving to page 15. Did you say 15 into 16?
The impeachment by prior conviction.
Yes.
And
I guess I lifted part of this language from the defense's request.
Your Honor, this appears to have language suggesting a testifying person being impeached.
That's probably because when the defense I lifted it from your instructions, and at a time when I think that was the expectation, but let me go back. Well, that first sentence, they have heard evidence through a stipulation, right? Is it later than that I only read the first sentence so far. You've heard evidence they have through stipulation, right?
Yes, Your Honor, that
sentence is okay.
It's on the next page only for the limited purpose, and I suggested limited purpose.
I see. So does the whole thing come out?
Your Honor, I note in Commonwealth's motion in limine number 12, paper 198, the Commonwealth laid out the purpose for which it was seeking to bring in the evidence of the federal charge. Perhaps that language from that could be substituted, as you may only consider this evidence to understand the relationship between the defendant and the victim, or something of that nature, to understand the complete circumstances of the situation in the home at the time of the events at issue here.
Well, I don't like that.
I think, Your Honor, the model instructions all do seem to include, you may only use this for the limited purpose of, and I suggest they should be given a purpose. And
well, but it's not impeachment. I mean, I did put that in there last night based on the information I had at that time. But that prior felony conviction is no longer impeaching Mr. Walsh. So it just seems to me like it should be out.
We think it should be out.
Maybe it should be out.
I'm sure you do.
I mean, it's no longer impeaching him, and the relevance of the prior federal conviction goes to motive intent, it seems to me, right?
Your Honor, I suggest there were reasons it was introduced to understand the relationship in the home as way of a shorthand. So, but I agree, it is not impeachment evidence.
All right. My present ruling is that's whole section's coming out now. The reason the impeachment by prior inconsistent statement is now in.
That means they're not going to be able to bring in his federal charges of art fraud.
Italics is, I'm sure that happened with some witness. But I'm not 100% sure.
I don't think it did, at least.
They're talking about the statement being said during opening arguments and the instructions concerning a knife, but he made searches on the internet about a knife being put in a dishwasher and being cleaned for blood. I'm paraphrasing, but that's what I gather. So that's what she's going to be considering.
Anybody?
I want to speak.
Your Honor, I think some witnesses may have testified a little bit differently than they had previously and were shown documents. I don't know that it rose to the level of impeachment, but there was some questioning of some witnesses about something they had said previously.
Yeah, I just don't think that we ever got to a statement. I don't remember anybody grabbing a grand jury transcript and cross-examining. The closest we got to it, I think, was Jem yesterday. Mr. Mutlu yesterday, and that wasn't with a prior statement. It was his prior statement, but he just said, I don't remember. So is that enough to warrant the instruction?
Certainly, if the defense wants it out, we agree we should take that out.
I don't need to give them more instructions that they're wondering, what the heck is she talking about? So I'm inclined to take it out.
And we have no objections.
All right, that's why it was in italics before.
Your Honor, then the impeachment by defendant's prior bad act.
Yes.
With this, I would suggest that the lying and the conveying of the body are part and parcel of the murder at this point. It's the disposal of the evidence of the crime and the lying about what he had done. I would suggest it's not a prior bad act. It's part of the evidence of the case.
It's an interesting question.
There's many interesting questions in this case, Your Honor, no doubt.
It's an interesting question whether, where are you drawing the line of a prior bad act occurring? Can you have a prior bad act that's part and parcel? Is it prior to this time? Is it prior to the crime that was charged?
It's arguably subsequent, Your Honor, but.
Right.
I mean, it's arguably.
What about the lying to his federal probation officer?
That would appear to be a bad act, arguably a subsequent bad act, but.
Yes.
I don't want to interrupt. I tried to address what I believe are prior and subsequent bad acts in our pleading at page 6. And I took it from the Massachusetts Jury Trial Bench Book, and I modified it only to accommodate what I believe is relevant and pertinent. And the gist of that model instruction is to make sure that the jury, if they hear what they consider to be bad, and I frame our instruction as prior and subsequent bad acts, that he's not charged with those, and that they have to, just like the model instruction says, if they deem those to be bad or subsequent bad acts, they can only use them for a limited purpose. And I think that this jury will probably be asking themselves, I don't know who in the world wouldn't ask themselves, that's a bad thing to do, if they believe that the body was dismembered, and if they believe that the body was disposed of in bags, anybody's going to think that's a bad act. And they need to be instructed that they can't, he was not charged with anything, and therefore they can only use that evidence in a limited basis. And I don't much care for the specific language of motive or anything, but it is the model instruction. And I think I would try to parse.
So I'm looking at your instruction right now, and that really deals with the art fraud, right? Are we on the same page,
Yes,
Attorney
we are.
Tipton? But are you suggesting, I just want to make sure I understand what the respective positions are. Are you suggesting then that you want to expand that, so you want an instruction to the jury that includes the language that I have in there, which is lying to the police and disposing of the body of Anna Walshe?
Well.
And the lying to the probate. So that's not what's in here, but are you saying do what you did, Judge, in the instruction, but add what I want in instruction 6? Is that what you're telling me?
Yes.
Okay.
But
do you want that to be included, so in the proposed instruction, and just so the record's sort of clear, I'm talking about the defendant's request for jury instructions concerning consciousness of guilt, emotional evidence, and bad acts. I don't know what the docket number is, but I got that. It was filed yesterday, December 10th. And I'm looking in particular at your request number for prior and subsequent bad acts. That's what you were referring to, Attorney Shipton. Okay, and so in that, as you initially drafted it yesterday, it was about the art fraud, but you're now suggesting that that would be an appropriate instruction also for the other bad acts that I've identified in my draft on page 17 under impeachment.
Yes, Your Honor. I had included, I was anticipating there to be a proposed other instruction like you had, but yes,
Okay.
I would ask then that.
So I think I understand what the ask is now.
Right.
And so now I'll go to the Commonwealth.
Your Honor, I think I understand it better as well. It also says in the instruction about the middle of it, if you credit the statement, I don't know that we're specifically talking about a statement here. And maybe that could be expanded if the court is inclined to keep that instruction in.
Well, I think the language comes in that defendant hasn't been charged with committing any other crimes other than murder. I'm just pausing there because if I move the federal art conviction in, somebody could wordsmith that and says, oh, yes, he was. He pled guilty to a federal crime. Maybe the better way to say it is the only charge you need to consider is the present charge of murder. You looking at the first sentence?
Yes.
Let me take a minute. All right, so if I say something along the lines of, the only charge the defendant is now facing is the charge of murder. You've heard mention of other acts allegedly done by the defendant, namely, and I wrote a few things in there, and it would seem to me what the defense is asking is that I add, the language that you have in your request was including acts involving a federal case concerning art fraud that he was charged with in 2018 and sentenced in 2024, comma, I'll just put them in date orders, right? Lying to the police and or disposing of the body of Anna Walshe and or lying to his federal probation officer. So all four things would go into that parenthetical. Okay, and then I would pick up with what the defense has. You may not take the defendant's prior acts as substitute proof for that they committed the crime charged, nor may you consider them as proof the defendant has a criminal personality or bad character. And then the rest of that, you see that all there. All right, what do you think about that, Kamala?
Will the court be removing the, but if you credit the statement sentence?
Yeah, no, what I would do is, I'd make the change that the only charge the defendant is now facing is the charge of murder. You've heard mention of other acts allegedly done by the defendant, namely, and then I would go to the defense's suggestion, namely, acts involving a federal case concerning art fraud and that he was charged with in 2018 and sentenced in 2024, semicolon, lying to the police, semicolon, and or disposing of the body of Anna Walsh, semicolon, and or lying to his federal probation officer, end parentheses. Then pick up with the defense's request and follow that through the end. You may not take blah, 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 right through to, it would be extremely unfair to consider this evidence for those purposes. That's where I think I'll end it.
So you're not,
Then I go back, I don't think that's appropriate to add the for one thing.
the last two sentences?
That's right.
I will just say, Judge, that those sentences are contained in the model instruction at page 343.
I'll take a look at it, but it seems to me then if I put that thing in there, then I've got to, I don't know what I do about the other things. Because you can see the issue that that raises.
Your Honor, there's also the possibility that maybe this instruction should be given around the same time as the consciousness of guilt, because it almost seems, I don't have them both right in front of me, but it almost seems like we might be telling the jury different things about how they can handle the evidence of lying to police and the conveying of the body of Anna Walsh.
Well, that consciousness of guilt is before here, isn't it? Maybe?
I believe it's on page 27.
Oh. Hmm. Well, I had this all in this section because I thought I'll put the 3 impeachment things, but now 2 of them are gone. So it doesn't make any sense, I suppose, standing alone. Maybe we just go straight from witness credibility to experts, which makes more sense, and move this impeachment paragraph later in the instruction. What do we think about putting it either around the vicinity of the consciousness of guilt instruction?
Well, my comment would be I'm objecting to the consciousness of guilt, so
I know you are. I know you are. It seems to make more sense in that area. So I'm going to move it probably before or after the consciousness of guilt instruction, somewhere in that vicinity. And if you have any strong preferences, you let me know when we get down to page 27. Recognizing you don't want it at all. But I'll edit the impeachment to include a substantial portion of what the defense has requested and add in specifically the federal case. That's all I can tell you for now. We can to be continued on tomorrow if we need to discuss it more.
and I understand the court's not going to include the last 2 sentences, so I'll just lodge my objection.
Okay. So lodged. What's the next edit that the Commonwealth has?
Commonwealth has page 27.
What's the next edit the defense has?
27.
Nobody likes 27 and 27. What did I do on that page? Let us see. Okay, that's COG. Who wants to go first with what I got wrong?
Cognizance of guilt.
Your Honor, I would suggest here in the italicized language,
Yes.
in the course of the trial, there was some evidence suggesting that the defendant may have intentionally made certain false statements before his arrest, and that he may have taken steps to conceal the disposal of Anna Walsh's body. I would just suggest that that should be tried to conceal the disposal of Anna Walsh's body. And in the...
Well, the fact that it was unsuccessful is something you can argue. I mean, there is some evidence that he may have taken steps, right? That's not inaccurate.
Correct, Your Honor, that's accurate.
What do you want me to add?
I was thinking you could subtract some words and perhaps make it more concise, but that is certainly
All right,
accurate.
so what do you want me to subtract?
I like
rather
this,
than saying taking
Judge.
steps to conceal the disposal of Anna Walsh's body, it's
I like this judge. In one hand, she's saying, bitch, please. In the other hand, she's challenging her. I love it. This judge's personality fits me well.
tried to conceal Anna Walsh's body. It's not so much that he was concealing the disposal of it, he was concealing the body itself.
He was doing both. He did both.
So you want me to taking steps to conceal Anna Walsh's body after death?
Yes, Your Honor, because it's the body itself. It's not so much the concealment of the body, but it's the steps to
conceal the
disposal
body,
of it.
not the
Yes.
disposal of the body.
Yes, Your Honor.
All right, that's probably more accurate.
And she's
So
always
under
willing
the
to,
Commonwealth's request, I would delete the 3 words.
and she would concede when need to be so. I might put her up as Judge of the Year.
The disposal of.
Will you add the word try?
What do you want me to add?
Try. I thought I heard the Commonwealth asking for try.
Commonwealth's content with how the court articulated the.
Well, attempted to take steps might be consistent with the evidence, but then that puts my thumb on it a little bit because it presumes that that was evidence of her body.
All I was responding to was the Commonwealth suggested the word tried. I think that is more consistent with what the evidence shows. I'm just talking about tried, not waiving any argument to the conscience.
All right, I'm going to leave it like it is with the removal of the disposal of. I don't like the tried part.
In the next paragraph, Your Honor, in the italicized, defendant did attempt to provide false information. I believe it would be did provide false information.
And there I got the language right in the second attempt in terms of what you just pointed out in the
Yes,
earlier paragraph. Even a blind squirrel finds a nut every once in a while. All right. Any other
Love
edits to
her
that consciousness of
personality.
guilt instruction?
Love her personality.
Recognizing the defendant doesn't want it, and that objection is noted and lodged.
Are you done?
I think she's done.
So, once again, I refer to our prior pleading. And on page 4,
Yes.
I'm asking that be included. And I modeled that, trying to find the citation. I modeled that after what I believe to be the gist of a supplemental instruction 9:22, and it's a district court. And the heading for that supplemental instruction that's included refers to where evidence is where such evidence is of another crime. It goes on to say, I caution you in considering such evidence that the defendant is not on trial for, then it has a blank.
Right.
And that's what I do.
But now that I'm moving down the other section that we just discussed, which far more in a more detailed fashion addresses that.
You mean in the
Yes, because now that's going to sit right on top of this one.
Well, but I think that the reason I'm pressing this, notwithstanding those other instructions, because I think just the title alone draws attention to the jury, where they're hearing a different instruction entitled consciousness of guilt. And I don't know that jury will take some language from a prior instruction and import it into this one. And it's important for them, my opinion, in our opinion, to have context for how they use so-called consciousness of guilt evidence. And the other thing is, when you talk about consciousness of guilt evidence, the case law is clear and the instruction says they can't rely on consciousness of guilt
But there's some in the
evidence
washer, but you need
alone.
to add a little more.
And I think
It's not, I poured a
since we don't
whole
want the
thing in
instruction
there.
the first instance, at least
Go
it
ahead and
gives
pull
them
it out.
better context for how to apply what they may deem to be consciousness of guilt evidence, especially where you hear all of these other acts. And yes, they will get the prior bad acts if you juxtapose it before this instruction.
I actually think it's better right after it, as I'm thinking about it, because it leaves them with it puts them in that moment, and then
Lost that
you may
one.
not use it for this purpose. As you were arguing, I'm like, that's not going before, it should go after. Because
I'm just pressing this supplement. It's primarily based on this Model 9.
I'll go back and look at it, and I'm going to see how it feels once I've moved things around and how it reads. All right. And of course, you know this is coming, so you will, I am sure, as you all I know you will. You're going to take those parts of my instructions that you want to highlight to the jury and put them in part of your closing arguments. And so you'll know where it is and you can point directly to it so that you highlight. I'm going to tell them, take all my instructions as a whole. You're going to drill them into the ones that you think best suit your client's argument, including this one. But anyway.
I may, but.
Or not.
Having said that, I guess I just want to ask a question.
Yes.
Does the court intend to supply written instructions as well?
So what I do is I don't give them a written instruction during the actual charge. And there's a very simple, I'm a very practical person. I've been sitting on the bench now since 2017. And not once, and I'm not proud of this. There are other judges that do a better job at this. There's not once, no matter how many times I read this, no matter how many times you read it, there's always a wayward S that sticks in there, charges instead of charge, or some other less than perfect product as I read it. And I edit those on the fly, and I tell them, typically, it's my oral instructions, not what you put in the writing. I've never had something that's been a huge guffaw, but it could happen. I don't think it's going to happen in this case, but I don't finalize those instructions until after I've read it to them, made those edits. I sort of a running game I have with myself. When are you going to get it right? Exactly right. Hasn't happened yet. I don't know that it's going to happen on this case. There's always some little niggling little mistake. So I don't give it to them in writing when I'm reading it. I give them copies of the charge when the exhibits go back. And my practice has sort of varied over the years. I used to just send in one because I want them around the table talking about the instructions, doing it all together. That became cumbersome. So I've now changed it to I usually send in 5 or 6 copies of the charge. If they want more, they can have more. I usually tell them that. But I won't give them, they won't be sitting in the box reading the charge with me. That's not how I do it. And that's the practical reason why I don't do it. I don't want to be backpedaling. I want to give them the best product, both orally and in writing that I can give them. So if that answers your question, that's how we'll do it. Now you'll obviously have the draft so you can read along. And I encourage you to point out my errors despite my best efforts. You'll see me up there marking it up as I always do. Maybe tomorrow will be the case that I get it all right. Still trying. All right, what's the next page?
Your Honor, for the Commonwealth, not so much a page, but circumstantial evidence. I know the court has direct and indirect evidence in there at 23. Would the court consider also including circumstantial evidence in that?
What page you on?
Page 23.
Oh, this is the plain language version of the circumstantial evidence.
Yes, Your Honor.
I don't have strong feelings about it. If there's some language you want to propose, I have used other language that refers to things as sort of the more old-fashioned language. This is direct evidence. The mailbox postman thing, I've delivered that a number of times. I think this is the more modern version of that. But if you want to propose some language, I'm not adverse to explaining it.
I'm just objecting to any additional language, and I'll wait and see what they propose. But
all right.
I think this is sufficient.
It just talks about it in terms of direct evidence and indirect as opposed to circumstantial. I mean, it could be as simple as adding in sometimes called circumstantial.
Yes, Your Honor. With permission of the court, could the Commonwealth submit something later today?
Sure, that'd be helpful.
And if they do, which it sounds like, excuse me, I'm going to then add.
Okay, ladies and gentlemen, we are now back in the sentencing phase. They have started court. We will come back to this in a minute. This is the Dustin Duran sentencing. The judge is about ready to render verdict. Here we go.
Thank you. Please be seated.
Punishment.
Thank you, Clerk Kovalenko. Before lunch, the state had concluded its remarks. Attorney Duran, am I correct?
That is correct, Your Honor.
Okay,
Judge, before the defense begins, may we approach?
certainly.
No. Why do you need to do this now? Really? Seriously. Oy vey. Earlier, Duran was accused of being disruptive and was removed from the courtroom, although we watched the video and didn't see any disruption. So that was interesting. After the sentencing, I'm going to hand this back over to June. I've got to go pick up meds, and I'm fading. To those of you who are watching, we haven't seen in a while. I'm sick. We will be back over at the Walshe's trial in just a few minutes. I'm going to go back over until we actually get to the court feed. I mean, they actually get to court. What happened to my share screen? That's unusual. Okay, there we go.
You would ask.
How about if I just say that is indirect evidence, sometimes called circumstantial evidence, and then you don't have to do anything this weekend. I mean, not this weekend. It feels like this weekend. Then you don't have to do anything tonight.
Snap.
I'm going to suggest that, but you can do what you want.
Love her attitude. Snap.
All right. Anything else on the instructions?
Not from the
Forever
Commonwealth.
hold your peace.
All right. I really didn't mean to set off well, there's a word that comes to mind, but it wouldn't be judicial, so I won't use it.
Shit show.
When I made my comments this morning about closing arguments. So let me just
Here we go.
say, I'm always trying to stay a step ahead of you. It's not easy. And so I did start looking at this issue a couple of days ago. And I'm going to tell you what the cases I came up across and sort of where my preliminary thinking is with regard to this. And maybe there isn't an issue. Maybe there is. But let me just tell you, we all know what I'm talking about, right?
Yes.
All right. So I'm going to give you some cites to some cases, and I'm going to tell you preliminarily where I think the line drawing is. And it's really preliminary because I looked at these like 4 days ago. Oh, Tuesday, December 9th. So I guess it was just yesterday. Well, no, that's not exactly when I looked at them. I think I looked at them this week and I sent them to my law clerk on Tuesday, December 9th, or vice versa. So anyway, here are the cases that I want you to take a look at. 2019, Commonwealth versus Ahern, 96 Mass App Court, 197. And that cites to Commonwealth versus Nelson, 468 Mass 1, a 2014 case from the SJC. And I also want you looking at Commonwealth versus Tavares, 27 Mass Appellate Court, 637. And in those cases, the SJC and or the appeals court is really talking about this issue of improper burden shifting and avoiding that in closing arguments. And really, it seems to me the one that's the closest to this is a combination of Ahern and Nelson.
Okay, here we go. Closing statements to the judge by the defense.
Please.
And then verdict.
This is a tragic case, and no sentence that the court can impose will undo this tragic situation or make Ms. Nafsker's family whole. The court has a difficult task in imposing sentence and in balancing the aims of sentencing. As the court undertakes that difficult task, we ask the court to consider Mr. Duran's history and background, his service to our country, and how that service forever changed him. And we also ask that the court consider the particular circumstances and context of this case. Mr. Duran is respectfully requesting that the court impose a sentence of 25 years to life at the New Hampshire State Prison on one count of second-degree murder, with additional suspended time on the reckless conduct and endangering counts. We ask that the court authorize that Mr. Duren can receive earned time reductions for completion of programming at the prison. And we further ask that Mr. Duren be ordered to comply with any Minnesota family court orders regarding contact with his daughters. As we discuss why the court should adopt our proposed sentence, I'm going to try not to rehash what's in our sentencing memorandum. We'll start by first talking about the aims of sentencing. We'll then talk a little bit about Mr. Duren as a person. I'll address some of the points made in the state's sentencing memo and in its argument today. Several of Mr. Duren's friends and family will address the court, and Attorney Kinney will read statements from some friends and family who are not here. We'll conclude by talking a little bit about the United States Supreme Court case, Porter versus McCullough. Starting first with the aims of sentencing. The defense's proposal balances the aims of sentencing: punishment, deterrence, and rehabilitation. 25 years in prison is punishment. It is decades of incarceration, decades without freedom or autonomy. It is a serious punishment for a serious crime. If the court imposes Mr. Duren's requested sentence, he will first be eligible for parole right around his 62nd birthday.
Oh.
He will miss his daughter's entire childhoods.
Oh.
He will miss their high school graduations, their college graduations, and their first jobs. He will not be present for many of the major milestones of their lives. He will not have the opportunity to spend time with his parents in their retirement, and he will miss the childhoods of his nieces and nephews. 25 years in prison will punish Mr. Duren for the crime for which he has been convicted, and it will forever change his life, but it will allow for a possibility of redemption, for a possibility of parole.
No.
If the court imposed the state's recommended sentence, Mr. Duren would not be eligible for parole until he was about 82 years old. This is a de facto life sentence. The Social Security Administration publishes actuarial life tables, which provide statistical analysis of the average remaining number of years expected prior to death for a person. According to the Social Security's actuarial life tables, if the state's recommended sentence is imposed, we should expect that Mr. Duren will die in prison.
Yep.
The state's proposal is a de facto life sentence.
Yep.
And if the legislature was of the opinion that all murder cases should result in life imprisonment, it would dictate mandatory life sentences for second-degree murder like it has for first-degree murder. The
Nice
legislature
try.
has not imposed such a sentencing structure for second-degree murder cases, and there is no requirement that this court impose a sentence that functions as a life sentence, and this court should not impose a sentence that functions as a life sentence. I understand that the state attempted to do some different calculations related to parole dates, but I think that those dates that the state provided obfuscate the reality. The reality is that Mr. Duren will not be eligible to earn the maximum amount of time off at the prison, because many of the ways that you earn time off at the prison are for getting a GED, getting an associate's degree, getting certain certificates in education. And Mr. Duren already has those certificates. He's graduated from high school. He's a decorated military veteran. He has an associate's degree and other certificates in his field. And so he won't be eligible to earn that amount of time off.
Well, he shouldn't have killed
I
somebody.
also think the state's reliance on 65120 to argue about the length of sentence, the sentence that Mr. Duren would serve, is not reliable. 65120 is extraordinarily unlikely, extraordinarily rare, especially in a case of this type, and the state is not offering to not object to any such reduction in sentence. We have advised Mr. Duren, and Mr. Duren can expect, and this court can expect, that these numbers mean what they say, that 25 years is 25 years, that 45 years is dying in prison. And 25 years.
Not true. She's not adding in the factor of good behavior and all of that. And even though he has some education, he has an associate's degree, he can go and get a bachelor's, a master's, and even a PhD and get credit for doing that. So she's not telling the full truth.
Judge, as the sentencing comparisons show, allow the aim of sentencing to be, of punishment to be met. Turning next to deterrence. By ensuring that Mr. Duren has an additional suspended prison sentence hanging over his head, and that if he is paroled, he will be on parole for the rest of his life. This sentence will deter Mr. Duren from committing crimes in the future. He will know that if he commits a crime, he will be in prison longer or go back to prison. And this sentence will also act as a general deterrent for society at large. The message that Mr. Duren's proposed sentence sends is that if you are convicted of murder, you will spend decades in prison. That's general deterrence. In terms of rehabilitation, as I've said, the state's sentence calls for Mr. Duren to die in prison. That is not a sentence that allows for or supports rehabilitation. It is not a sentence that allows Mr. Duren to engage meaningfully with the rehabilitative programming that the prison has to offer with the aim of rehabilitating himself for his release. In contrast, the defense's proposed sentence furthers the goals of rehabilitation in two major ways. First, it allows him to earn some small amount of time off of his sentence by engaging in programming at the prison and by working to rehabilitate himself at the prison. And second, it furthers the aims of rehabilitation by allowing him hope. Hope that he will have some period of his life outside of the prison. Hope that he will be able to be reunited with his family outside the prison walls. Hope that if he works hard to rehabilitate himself, that hard work and that rehabilitation will pay off, and that he ought to take the time at the prison seriously because there's a chance for him to experience life afterwards. The defense's proposed sentence meets the aims of sentencing in this particular case. Turning now to Mr. Duren himself. The court heard from Mr. Duren at trial and had the opportunity to review our sentencing memo and its attachments, including statements from some of Mr. Duren's loved ones. And what I hope those materials make clear is that Mr. Duren loves his children more than anything. His friends and family all reference, and I think both his initial statements to police and his testimony at trial both demonstrate that he is an incredibly loving father, that his children mean everything to him, and that his life forever changed and he gained purpose when he became a father. I'm going to play for the court a piece of music that Mr. Duren composed that reflects his unyielding love for his children. Mr. Duren is a musician, a composer, and an audio engineer. And for most of his life, Mr. Duren has felt that words have failed him, and he's preferred to express himself through music. He feels that music is the language of the soul, and he wrote a piece of orchestral music in 2021 about his feelings during Miss Nafziger's pregnancy, the birth of their first child, and the first year of Elwyn's life. This piece of music, which is entitled First Morning, is a tribute to the love that he feels for his family. It's Exhibit A in case lines, Judge.
Excuse me, Attorney Kettles, before you begin, my understanding is that with respect to Defense Exhibit A and B, to the extent that those exhibits, which I will consider as part of sentencing, but to the extent that those exhibits contain photographs or images of others besides Mr. Duren, my understanding is that the state would object to that. And my understanding is that there will be no streaming of those pictorial representations.
Yes.
Am I correct?
Yes, Judge, I believe that the concern of the state is that they not be streamed, and we share that concern. And it's my understanding that the clerk of court has instructed the media not to provide coverage of these images. They're only going to be on the screens in front of the court, the monitor, and then at council table, which I'm saying out loud to allow the media to comply.
And thank you. And part of the reason for my saying that was to make sure that there's an understanding as to what's about to happen for those who aren't privy to what the court has ordered. And on case lines, are you presenting, Attorney Kettles?
Hopefully shortly, Your Honor.
Okay.
Can the court see my screen? I haven't pressed.
Y'all, this will be interesting.
Reloading to follow presenter.
I clicked on start presentation. I'm pressing play. I'm going to pause that for a moment to confirm.
Your name has populated on my screen, and I am now clicking on it so that I can follow your presentation.
Judge, I'm receiving a network error causing the video download to fail partway. It's instructing me to check my network connection or try again later.
You should have tried this during break. I have no patience when they do not test things during break. You should not wait to test it when you're live in court.
And if it assists counsel, I can initiate it on my end if I'm not following you, but I'll do it however you request.
It looks like it's now started. I pressed pause immediately. Will the court be able to hear the audio on its computer?
Let's try it.
I have my computer muted so that we don't have multiple. Right. Yeah. Can the court see the image?
I have an image.
I'll press play now, Judge.
Okay.
Oh my God, no. Okay, they're not going to let us hear it. It is going to be kept in the privacy of the court, which probably will be better because it will just, I'm sure, infuriate me. I don't care how good of a composer he is. He freaking killed a person. Y'all. Y'all, I'm sorry, we're not going to get to hear the music. Oh. And I can't zoom. I don't really like her closing argument. I mean, not a closing argument. Her presentation to the judge on his behalf. There should be talking about family members who support him, and people, how he's loved. He served his country, what good things he did prior to doing what he did. All of that stuff is what should be talked about, not about the jail system and the time. Yeah, he's not going to get, I mean, it is true. You get a little bit more time off and consideration on the parole board when you do things such as get your GED if you don't have a high school education or associate's degree or yada, 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 yada. All of that is true. I don't disagree with that. But at the same time, he can continue on and get his bachelor's, his master's, whatever he chooses to do, and is paid for by the government. He doesn't have to pay for it, which I think is bull crap.
Reflect, I'm still following Attorney Kettles, and Exhibit B is now up on my screen.
I think the state should only allow him to be, I don't think they should get a free education in college, masters, bachelor's, masters, even doctorals when you're in prison. I don't think that's fair. You got young people out there, older people out there who've worked their butts off and doing everything they can to go to college to better themselves. And people sit there and commit heinous crimes, get a free education. I think getting your GED or high school equivalency or high school degree in prison is definitely should be paid for by the state because it's already free to begin with. But paying for them to go to college to me pisses me off. There's so many of us out there who can't go to college because we can't afford it, but those who truly don't care about it but use it to get time off in a prison situation after unaliving people should not get a free education, in my humble opinion. You can agree to disagree with me, and that's fine, but I'm all about bettering yourself, and you can take courses and stuff, but you got to find a way to pay for it or your family.
First, we're showing the court some photographs of Mr. Duren in uniform. We've attached a mitigation report that details Mr. Duren's military service and why it calls for leniency in sentencing. We've also submitted a report from Dr. Pittman that offers an opinion on the way that Mr. Duren's service-connected PTSD impacted his actions and his decision-making on February 29th of 2024. When the court imposes sentence, we ask the court to keep in mind that Mr. Duren, at a very young age, stood up and volunteered to serve his country.
And so did a million others.
Honor and distinction, including service in Iraq, and that he will forever bear the psychological scars that his military service caused.
So have 100,000 of others.
Administration has found that Mr. Duren has an 80% disability rating, meaning that he was 80% disabled as a result of his military service.
And so have many others.
Total of which is from his service-connected PTSD. And I won't go into too much more detail about his military service because it is covered in the military mitigation report that we submitted.
And you know what? So have hundreds of thousands of others, and they don't sit there and kill their wives. I don't put that. No. It's not like 4th of July, fireworks were going off. He went in a PTSD state. He grabbed his rifle. The wife walks in the room. He thinks that she's the enemy, and he shoots her in a PTSD state. That I can wrap my head around. This, absolutely not. He got pissed off, and he red room her into discussion.
The next slide that I'm showing to the court,
in my humble opinion,
photographs of Mr. Duren at various stages in his life with a number of friends and colleagues. Several of these photos show Mr. Duren at the Hollywood American Legion, where he worked as an events technician and an audio engineer.
So,
while employed there, Mr. Duren hosted a charity event for Battle Buddies, one of just numerous ways in which he was connected with veterans service organizations after his discharge from the Marines. Other photos on this slide show Mr. Duren performing, and the group photo at the bottom left is from Merging Vets and Players, a nonprofit veteran support organization with which Mr. Duren was extensively involved. The next couple of slides, Judge, show Mr. Duren in the role that he loves most, his role as a father. And this exhibit ends with a photo of Mr. Duren. We are all more than the worst thing that we have ever done. We are all more than one day and one action. And in imposing a sentence, we ask the court to consider Mr. Duren as a whole person, a person who is capable of redemption and rehabilitation. Turning to the state's sentencing memorandum and sentencing comparisons. The state attempted to characterize the events in this case in a certain way in its sentencing memorandum, to insist that Mr. Duren acted out of anger or control. We don't agree with the state's interpretation of why this happened. The court heard Mr. Duren's testimony, that Mr. Duren reacted when he heard his child scream, and the court should credit that testimony. We acknowledge that the jury found that Mr. Duren's actions were not justified under the law, but that does not mean that the state's assertions about Mr. Duren's motives or mental state are true. They are not. We ask that the court consider the context of this case, the context that led to the court instructing the jury on defense of others when imposing sentence. We also ask that the court consider the connection between Mr. Duren's PTSD and the events of this case. The state said in its memo that there is no connection between Mr. Duren's PTSD and this case. And I think they said in their argument that he didn't rely on PTSD at trial, and so the court can't rely on it now. But that statement is incorrect and it's wrong. And I think, again, it doesn't cover the reality of why and how we ended up presenting the evidence that we did at trial. There was extensive pretrial litigation that the state initiated focused on the admissibility of Dr. Pittman's testimony at trial. And the rulings that the court made have an impact on how someone chooses to go forward. I think the state's argument that because we didn't rely on or explain the connection between PTSD and the events of this case at trial is legally incorrect. It's burden shifting. It's punishing Mr. Duren for exercising his constitutional rights. And the state fought hard to prevent us from presenting Dr. Pittman's testimony. And so it cannot and should not use the fact that we were unable to present Dr. Pittman's full testimony against Mr. Duren now. The court can and should consider Dr. Pittman's testimony, I apologize, his expert report when determining what sentence to impose. That report has been submitted with our sentencing memorandum. There's an opinion from an expert, a highly trained and qualified doctor, himself a veteran, who works at Harvard Medical Center and Mass General, that outlines the links between Mr. Duren's PTSD and this case. And the court can and should consider this as extensive mitigation information when imposing sentence. Finally, the state claims that Mr. Duren has shown no remorse and has not demonstrated responsibility for his actions. And we would contest that claim as well. A decision to exercise one's constitutional right to go to trial is not a lack of remorse or responsibility, and a person should not be punished for exercising their constitutional rights, including their right to go to trial and to hold the state to its burden of proof. And contrary to the state's assertions, Mr. Duren is deeply remorseful that Caitlin is dead. He testified about how horrible he felt at trial, and you will hear from witnesses who discuss Mr. Duren's devastation that this has occurred. Mr. Duren has never denied that he killed Miss Nafziger. He called his parents and told them, knowing that they would call the police. He waived his Miranda rights and told the police what had happened. He testified at trial about what had happened. He has never denied what has happened. He is devastated and horrified. Turning to sentence comparisons, as both sides have acknowledged, every case is different. Every person is different. Both sides can point to cases where the sentences imposed were similar to the sentences that they were requesting in this case, or try to distinguish this case from sentencing comparisons that were provided. With those caveats, I'm not going to go through the state's sentencing comparisons one by one and explain how they're different. I think you can see that in the state sentencing memorandum. But I do just want to note for the court that there are some reasons that the sentence that Jesse Sullivan received is not an appropriate sentence for the court to consider. And Attorney Kinney and I have ethical obligations that prevent us from saying more, but Attorney Durand represented the state on the case and is aware of the irregularity in that case and how that particular sentence was reached. I'd also like to highlight two of the cases in our memo, Tyrese Harris and Dylan Sleeper. Both are cases in which the jury was instructed on both self-defense and manslaughter, but ultimately the defendant was convicted of second-degree murder. Neither of those defendants was a veteran with service-connected PTSD. Service-connected PTSD that an expert has opined played a role in the events of that evening. Mr. Sleeper had a prior criminal record, unlike Mr. Duran, who has no criminal record. And both the Harris and Sleeper cases are cases in which the defendant was sentenced to 25 years to life after trial. The sentences that those defendants received are the same as the sentence we asked the court to impose, and they demonstrate that the sentence the defense is requesting is a proportionate sentence in a case of this type. Judge, we'd like to give the opportunity for some of Dustin's friends and family the opportunity to speak. We submitted multiple letters along with our sentencing memo, and there are additional letters we've received since submitting our sentencing memo that have been uploaded to case lines. Attorney Kinney will read those letters, but I'd also ask that the court accept as exhibits all of the documents and materials that have been filed in case lines for this hearing, just for the purposes of making sure we have a complete and accurate record.
Certainly.
Okay, y'all, we got a sidebar. I agree with you, Joe. I think you're right. And I have really been struggling. The more I learn about criminal justice and law, I really struggle with some of these lessers and all this. And my whole thing is the lessers included and all of that. When they go to verdict, either you properly charge the crime or you don't. I don't understand why that you can be given a charge of first degree murder with a charge of second degree as a lesser second degree lesser manslaughter. It puts a lot on the jury, number one, but number two, if you as the district attorney's office are doing your job and appropriately charging people, then you wouldn't have to have all the lessers, in my humble opinion, unless I'm misunderstanding why they're there. I don't understand it. I don't think it's right to put the responsibility on the jury to do the job of the ADA. If you're going to charge somebody a first degree murder, you shouldn't have manslaughter as a lesser. Unless somebody wants to educate me, and I'll gladly take the education. Just like with this, I'm really struggling with some of these arguments. I have PTS. Lessers are included when the crime can for both lesser or higher charges. I get that to a point. To a point, I get that. But what I don't get is now everybody's using it in every trial. It shouldn't be that way. Now, some crimes I understand fit that mold, but I just don't like it. I don't, unless they can really give me a good reason why it should be used as much as it's being used. I don't think there's really been a trial this year that I can think of that didn't have lesser includeds. Not every trial should have lesser includeds, in my humblest of opinions. And with this guy here, I've got PTS. Well, some call it D. I call it PTS. And I've been disabled. And I have understand it. There was a time I couldn't leave my own home for years. Okay, without being with somebody. I get it. But that does not mean if I go out there and commit a crime and have PTSD, that I automatically should be let go and get the minimum, either not be found guilty, or if I am, then get a lesser conviction and sentencing because I have PTSD. I'm sorry, but I'm not sorry. This guy was not in a post-traumatic state when he committed this crime. Now, there are people like when I was working at the state hospital, this guy had severe PTSD. He'd been in 2 wars. He got dementia. He and his wife were elderly. The daughter didn't like the fact that he was taking medication. She was a naturalist, holistic person. She got medical power of attorney over her dad, and she cold turkey cut him off of all of his psych meds. If you know anything about psych meds, you don't cut people off of psych meds. So the 2 days after she cut her dad completely off of all psych meds and cold turkey, not titrate, but cold turkey, he went into a very bad psychotic state, thought he was back in the war, and shot his wife. He was found not guilty by the reason of insanity. That's where PTSD comes in. That kind of scenario I can totally get behind. But this crap, the fact that every veteran who commits a crime starts screaming post-traumatic stress disorder, I don't get behind.
And not to lose track, recognizing my ruling, other than that, any further objection relative to the admission of those exhibits, Attorney Duran?
Your Honor, the state would just indicate for the record that the state just received it.
Like I said, I get it on some cases, Ari, but it's every freaking trial.
It was about 15 minutes before the hearing started and actually hasn't had a chance to review them. But other than that, we won't object.
Okay, all right. So the court will, the Attorney Kettles' request relative to the exhibits that are being proffered relative to sentencing, the court shall admit them as full exhibits. Attorney
Thank you,
Kennedy?
Judge.
Yep.
My name is Susan Chin, and I.
Okay, last comment on this, and then we'll move forward. I don't disagree with you, Ari, at all. I understand. I think it's like to include to have it a higher chance of conviction. I get that to a point. The jury doesn't agree with the higher charge since we have laws against double jeopardy. I don't disagree with you, but I still feel it's an easy way out. And I'm going to play devil's advocate here. I think the defense, the prosecution doesn't have to fight as hard for it because there's lessers. I know there's a lot of gray and a lot of stuff, but I'm just saying I feel like they're using it too much, and I feel like it's a cop-out, and I feel like that, at this point in this day and age with the technology and everything we have, we should be zeroing down on stuff, not getting broader. And that's my humble opinion, and everybody can disagree with me. That's okay. The more I study, the more I learn, the more frustrated I get. Maybe I shouldn't be doing this, but I am anyway. So here we go. When it comes to this particular case, I don't think there should be lessers. I think there's straight across the board, but that's my humble opinion. And I understand your concept. I understand, Ari, what you're saying. I don't disagree with you. I'm playing devil's advocate here, but on the same hand, I just think it's just made things too complacent and too easy for the prosecution to do that. It makes it to where they don't have to fight so hard to convict.
I am Dustin Duran's
Devil's edge of the coin.
cousin. I have known Dustin my entire life, that being 37 years. I would consider Dustin to be one of my closest cousins. Dustin and I grew up camping together with our families, attending holiday events together, and as adults, meeting up whenever I was in Las Vegas so our children could play together and we could catch up. I am aware of the crime that Dustin has committed. Dustin was raised to be a very well-rounded and respectful person. Dustin is extremely intelligent, a very kind and loving person, a hard worker who followed his dreams, and over everything is an amazing, loving, and caring father. Dustin followed his dreams out to Las Vegas. Once Dustin became a father, being a father was absolutely everything he wanted and needed in his life. Dustin was someone you could call whenever you needed advice, to be picked up, cheered up, or just a little motivation. Dustin did everything in his life to provide the absolute best life for his daughters. Dustin's sentencing would greatly impact his relationship with his daughters and also our family dynamic. We cannot fathom living the rest of our lives not being able to see him be the amazing father that he has been to those girls. It would also devastate our family to not be able to spend holidays with him or vacations with him ever again. It would be detrimental to our family if he was sentenced harshly. We pray that you can sympathize with Dustin and his family during this extremely difficult time. We are asking for leniency, so someday Dustin and his beautiful daughters will be reunited, and he will be granted another chance to be their everything. To be able to give Dustin the opportunity to see his girls graduate high school, go to prom, graduate college, get married, and hopefully one day be a grandfather to their babies would be the ultimate blessing for not only Dustin, but our entire family. We all want nothing more than to see that happen. I appreciate your time reading this, and I am willing to give you more information about my relationship with Dustin or his character. Please feel free to reach out to me at any time with any questions. Thank you so much.
Thank you.
Dear Honorable Judge Frizzell, I am writing this letter for leniency regarding Dustin Duran. My name is Devin Gomez, and I served with Dustin in the United States Marine Corps from 2005 to 2009. Upon hearing what a heinous crime he had committed, I could scarcely believe the charges. Second-degree murder of his significant other, Caitlin Nafziger. What a horrible shame, I thought. This hardly seems becoming of the honorable, humble, humorous, and happy Marine Iraqi war veteran that I knew and so proudly served with. To my dismay and disbelief through watching the trial, I sunk to find that the unfathomable news was in fact confirmed. This troubles me deeply because Duran was an exemplary figure to look up to and work with while serving. Always great with mentoring, first to lend a hand and lead by example, talented with a gift for music that he would often demonstrate at gatherings that would uplift his comrades. He continued living an honorable life, clean record, loving family, till he was nearly 40. Then one inexcusable and dreadful moment will lead to the ruin of an otherwise distinguished and well-to-do man. I believe if this dreadful occurrence could happen to Dustin, then it could happen to anybody. It pains me that this one moment of darkness and mental deterioration will lead to a long, if not life imprisonment for my good friend and otherwise good man. Yet I know that to take a life is truly the most evil and justifiably punishable crimes, even though in the Marines, command encouraged us to be ready killers should the need to defend our country and those we love should arise. Punishment should be handed to anyone who recklessly takes the life of another. But is justice an eye for an eye? Does it require to take his life through imprisonment to justify the life he took? This takes somebody of high regard and honorable motives such as yourself to decide upon sentencing. I personally believe that to rot in prison is a far worse punishment than death. I also believe that given the chance and hope that there will be time to reconcile after punishment, Dustin would be able to spend much remaining time helping and inspiring those around him as he did in his first 38 years of life. I hope that there is a small chance of a lighter sentence for Dustin Duran. Writing this letter is the least I could do for my brother in arms. I certainly wish I could do more because I know he would do all in his power for me. One irrevocable moment in life should not condemn us to the worst punishment. Dustin is not a violent man with a murderous intent. He was a shining example of patriotism, voluntarily standing proud to protect Americans' freedom in a time of war. until one disastrous moment fueled by his confirmed wartime-related PTSD caused him to do the unthinkable and lose his freedom. Thank you very much for your time, Your Honor. I wish you the best in life and decisions that weigh heavily on your shoulders. Respectfully, Devin R. Gomez.
Thank you.
Dear Judge Frizzell, thank you for taking the time to read this letter. My name is Timothy Duran, and I am the uncle of Dustin Duran, who is before you for sentencing. I write with full respect for this court and full awareness of the gravity of the offense. I am not attempting to diminish the seriousness of what occurred. Instead, I hope to provide insight into Dustin as a person beyond this tragic situation and to respectfully ask the court to consider some measure of leniency. I have known Dustin his entire life. Despite the circumstances that bring him before you, I have always known him to be someone capable of kindness, loyalty, and responsibility. What has stood out most throughout his difficult time is the deep remorse he has expressed. From every conversation, it is clear that he carries profound regret for his actions and the impact they have had on everyone involved. Since his arrest, Dustin has taken meaningful steps to address his behavior and rebuild himself in a healthier direction. He has engaged in counseling and has shown a genuine desire to understand the root of his actions and to take accountability for them. I believe these efforts reflect a sincere commitment to change. One of the most important parts of Dustin's life has always been his children. He loves them deeply and has remained dedicated to them even through this difficult period. I know that being separated from them has weighed heavily on him and has motivated him to better himself so that he can one day be the father they deserve. His children are young and still need their father's presence, guidance, and support in whatever capacity the court ultimately allows. Your Honor, I respectfully ask that you consider a sentence that recognizes Dustin's ability and his desire to continue the hard work of rehabilitation. I am not asking the court to overlook the seriousness of the offense, only to take into account his remorse, his efforts towards self-improvement, and the important role he still hopes to play in his children's lives. Thank you again for your time, your consideration, and your service to justice. Respectfully, Timothy Duran.
Thank you.
We're now going to ask a few of Dustin's friends and family who are in the courtroom to address the court. We'll start with Dustin's pastor.
Certainly, and again, and I would just remind all those who will be speaking to please state your name and spell your name for the record. Thank you so much. Good afternoon,
Your Honor, we'd ask that the witness take the stand.
Certainly.
Okay, we have a sidebar. My voice is starting to go again. June, are you there? What's your humble opinion? Angela, what's yours? I want to thank everybody for joining. This is Ada K. I've been sick with COVID, so you are not seeing me, you are hearing me. I am on the downslide, but still quite under the weather. Thank you so much for joining. Thank you so much for listening, and we appreciate each and every one of you.
Thank you. Yes, please. And before you seated, sir, if I can have you raise your right hand, you swear that any testimony you give will be the truth, the whole truth, and nothing but the truth under the pains and penalties of perjury.
I do, sir.
Thank you. Please be seated.
Yes, sir. Please proceed. Yes, sir. My name is Justin Weberg, W-E-B-E-R-G. I'm in my 20th year of pastoring Community Baptist Church in Colebrook, New Hampshire.
Oh, here we go.
And for about 15 of those years, I've had the privilege of volunteering at the Coos County Jail, holding Bible studies and offering biblical counseling to inmates as requested. I first met Dustin on May 30th of 2024. Due to the nature of his physical and emotional state, the jail contacted me and requested a visit on his behalf. The jail has allowed me to visit Dustin twice a week and has permitted about 2 hours per visit. Over the 200 plus hours that I have spent with Dustin, he has been respectful, honest, and teachable in every area that we have discussed. As I listened to his story and what he chose to share with me, I sought to engage him where he was at while bringing a perspective based on and oriented to God's word. He has been most open and transparent with me and has demonstrated himself to be forthright, even when the truth or his thoughts would cast him in a negative light. He has not been afraid to disagree with me or to push back when his views differed from mine, but has always done so in a respectful manner. He is quick to listen and slow to speak. He is consistently pensive and thoughtful in his communication and is not one to respond with haste or void of due consideration. Dustin consistently listens without interruption, receives instruction well, and accepts correction with grace and humility. In our very first meeting, Dustin shared with me the tragic details that occurred on the evening of February 29th, 2024. What he shared in private was consistent with what he testified on the stand in this courtroom. Because the trial was conducted to determine whether or not his actions met the criteria for murder in the second degree, it would be easy to presume that Dustin was seeking to avoid taking responsibility for his actions and
here we
to
go.
escape any consequences that would follow if convicted. Such is not the case. I have spoken at great length with Dustin about his actions and responses and have witnessed him wrestle through the process of dealing with guilt and repentance. I have observed his grief and heard him articulate his regret and desire to relive those tragic moments. I have heard him express his concern for Caitlin's family and accept with understanding why they would feel profound anger toward him. I have listened as he empathized indirectly with them and was pleased when he stated that he prays for Caitlin's family. This leads me to the heart of who Dustin is and has become. Contrary to what many may think or feel about Dustin, he is not a monster. He is a broken and sinful human being who needs God's saving grace, unconditional love, undeserved forgiveness, and compassionate healing, just like the rest of us. Dustin has
God forgives, but you still face the consequences of your willful choice to commit redrum.
found each of these things and more in the person of Jesus Christ. When we met, he was an agnostic, one who does not know if God exists, or if he does, is not sure that God can be known. He was not a quick convert and did not turn to Christ lightly. His pursuit of God was not a selfish or desperate attempt to bargain, bribe, or manipulate God to act favorably towards him in order to get him out of this crisis. While Dustin has maintained that he did not shoot Caitlin out of anger, rage, control, or other selfish reasons, he has articulated that he feels guilty nonetheless for taking her life. His brain told him that there was a threat to Elowen's well-being and safety, yet he has consistently acknowledged that it was an exaggerated response and honestly believes that it was generated by his unhealthy, emotional interdependence upon Elowen and carried out in automatic reflex fashion due to his military training. Dustin regrets this. He feels guilty for not recognizing and handling the situation differently. This guilt and his inability to care for his daughters is what overwhelmed Dustin, causing the staff at the jail to contact me. After over a year of meeting with Dustin twice a week, I can confidently say that he has not turned to Christ to escape his guilt and to avoid any consequences for his choices or responses. In reality, the opposite is true. Dustin came to Christ to face his guilt. He has dealt with it before God and desires to do right by his Savior, his girls, his family, and yes, even Caitlin's family. Dustin's greatest desire is to raise his girls to know and fear God. He longs to help guide and shape their character and to be able to help them avoid some of the mistakes he's made and experienced. He desires to equip them to think biblically and to conduct themselves wisely, to love and serve without regret. He has surrendered to God and is committed to serve him in whatever way he believes God wants him to serve. My final thought is this: God is a God of righteousness and justice. He commands kings, rulers, judges, and even the common man to act justly. Yet he is a God of mercy and multiple chances. In fact, Jesus stated that God loves mercy rather than sacrifice. While God desires that justice be served, he desires that it be meted out with mercy and compassion. His heart is always towards reconciliation and restoration. Is this not the theme and story of the Bible? Jesus went to the cross to offer mankind mercy instead of God's justice that we all deserve. We see God himself rendering justice fully while providing reconciliation through his generous mercy. While Jesus is the ultimate provision of God's mercy, we see three examples of where God applied his mercy to individuals where many would have cried for justice. Three of the greatest leaders recorded in the Bible had taken a life. Moses, heralded even today as Israel's greatest leader, killed an Egyptian. Yet God chose to use him to lead and deliver the Israelites out of Egypt. God met with him on Mount Sinai and gave to him the very laws that influenced and shaped our Constitution.
Objection, Your Honor. Approach.
I am not liking the way this is going. I, as a minister, chaplain, done prison ministry, do not appreciate some of what he's saying here. You cannot sit there as a chaplain and say all this and not say that even though we are forgiven, even though God can forgive us, if you believe in God and you believe in forgiveness, does not mean that you are not to face the consequences of your behavior and your actions. They're forgiven, but consequences are going to happen. If that means life in prison, so be it. Forgiveness and paying consequences for your actions are two separate things. I believe in mercy, but I believe mercy is given in certain situations, not across the board. And I don't know if unaliving this woman in front of her children deserves any mercy. Maybe the mercy is he's not getting the DP and he's serving life. But I'm not liking the way this chaplain is up here preaching. What are your thoughts? Yeah, that true. I want to hear from him. If he's truly repented and become a man of God and done all that and is a Christian, which I'm not judging, he may have, then he needs to be up speaking for himself. So I hope he speaks for himself. I hope to hear from him repent. If you are truly a repentant person, you have no problem sharing that repentance publicly in this situation, in my humblest of opinion. I'm just wishing this will hurry up because this chick needs to get in bed. I'm starting to really crash. Long sidebar.
Thank you. King David killed a man to cover up his affair with a man's wife, yet God forgave David and allowed him to continue on as king. The Apostle Paul, before turning to Christ, was responsible for the suffering and putting to death of those whom he deemed traitors to God, yet God forgave him and radically changed him. Paul became the greatest missionary recorded in Scripture. These men certainly made some tragic choices, yet those choices did not define their lives. God was not done writing their stories. He confronted them, transformed them, and then used them as they submitted to him. Dustin was confronted by God, and I can personally testify of the transformation that has taken place and is still taking place in Dustin's life. I am confident that God is not done writing Dustin's story. He will use Dustin as he continues to walk with God and submit to his ways. I am not petitioning you to ignore justice, Your Honor. I am only seeking to provide biblical context and divine precedence in meting out justice in a merciful fashion. May God grant you wisdom in doing so, sir. Thank you. Thank you.
One question.
Judge, may we approach?
Yes.
The prosecution did not like that at all. We'll zoom.
The fact that he took her life doesn't.
Okay, here we go. Question.
Good afternoon, sir.
Good afternoon.
You just told us that you, I believe, don't believe that one choice should define the defendant's life. You agree with me that the defendant's choice is one choice defined Caitlin Nafziger's life?
My perspective would be that Caitlin's actions defined her own life. The fact that he took her life doesn't define her life.
It ended it, didn't it?
I disagree with you.
Yes, ma'am. Thank you. Thank you.
Dude, who made you God? That was not an answer I can accept. If he would have said that's not for me to decide, I would have respected you on that, dude. But I believe the fact that this man took her life in the manner he took her life, leaving her children in the state he left her children in, is a definition of the end of her life. Let me know if I'm wrong, guys. I'll accept your disagreements. Oh, that made me sick. I do not appreciate that as a clergy myself, dude. Nice try. How much did they pay you? Justin's sister.
If you raise your hand, please. You swear that testimony you give will be the truth, the whole truth, nothing but the truth, under the penalties of perjury.
I-
Thank you. Please be seated. I'd like to ask you to please state your name for the court.
Yep. My name is Heather Schlichter, SCHLICHTER.
Thank
Your Honor, my name is Heather Schlichter. I am Dustin Dern's sister. I'm here to share my perspective of who my brother is and give the court a fuller picture of the man I have known since he was born. My brother has always been loving, funny, honest, and so smart. He was my first sibling to be born and made me a big sister for the first time. Even though we have different moms, it never mattered to me. My siblings were my siblings. I remember being so excited. I always wanted to read to him when he was little, hold him. I couldn't wait to see him next. As he grew up, he loved Teenage Mutant Ninja Turtles, and I have so many memories of playing with all of his action figures with him. I think he had every single one. I would bring out my Barbies to play alongside them. As he got older, he joined the ROTC in high school and then left for military after high school. After he came back, he moved to LA. He would come home and visit, and we would get together whenever we could. He lived out of state for much of our lives, and while we didn't see each other much, I knew when we picked up the phone, we would talk for hours. I remember when he told me him and Caitlin were having a baby. I was also pregnant with my second child. We would have been, the girls are 6 weeks apart, Elowen and my daughter Mira. I told him how, I remember Dustin being nervous to become a father, just like most new parents. And I told him how the love is like nothing in this life, and you can never really explain it until you experience it. I remember him calling me afterwards and telling me how, after Ellen was born, how it was the most amazing thing he'd ever experienced. The morning I found out after this tragedy occurred, my dad had called me and told me what happened, and I didn't understand how this could have happened. Nothing made sense. This wasn't the person that I knew. That I knew like there had to be something. My brother struggled with some of his mental health, with severe depression and PTSD, and I knew that it had to be related to that because it didn't make sense. He was not, I'd never known him to be a violent or uncaring person at this. He'd served his country, but his military service left him with significant PTSD, which was, he was receiving disability support. Over the years, I watched him struggle quietly with the effects of trauma he never fully understood how to cope with, despite trying to get help. During the trial, Dustin tells the story of that first Christmas with Elowen, and I think that never really, no one can really tell how important that story really is. One thing he didn't tell in the stand is that during that time, the demons were back. It was telling him how he was worthless. He didn't deserve this life. He didn't deserve his daughter. And that first Christmas, that smile from Elowen saved his life. He finally found his real purpose. And that smile destroyed those demons. He was Elowen's protector, but really, she was his. I fully acknowledge the seriousness of the case and the pain and suffering. Nothing I'm saying is meant to minimize the loss or impact on Caitlin's life or family. This has devastated all of our lives. Caitlin's family, my family, all of us. I simply hope to help the court see the part of my brother that existed outside of this terrible moment. A man that battled invisible wounds and who loved his children more than anything in his life. The mental health crisis in our nation is real, and I know it has affected everyone in this courtroom outside of even this moment. I believe people deserve second chances. I believe that my brother is still that person I knew before this happened, and I know he has remorse, as he would do anything to change the past if he could. I have talked to him since he was incarcerated 2 to 4 times a month. I sat as he would just weep, knowing that he's lost everything in his remorse. And, losing his daughters is a punishment worse than death. I respectfully ask that you consider his mental health history, his lifelong character, and his potential for rehabilitation when determining his sentence. I hope he gets the opportunity to receive treatment and to someday feel the warmth of the sun and a breath of fresh air outside of prison walls. Thank you.
Thank you. No questions. Okay, thank you. Yes, be stepped down. Thank you.
Dustin's father would also like to address the court.
Certainly. Good afternoon. Good afternoon. Raise your right hand, sir. You swear that any testimony you give will be the truth, the whole truth, and nothing but the truth under the penalty of piece of perjury? I do. Thank you.
Afternoon, Your Honor.
And Mr. Dern, if I could have you state your name for the record, please.
I'm the father of Dustin Mark Duren, D-U-R-E-N.
Thank you.
During Dustin's lifetime, he has always been nothing but a good man. As a child, he was easy to raise. We had zero behavior issues with him throughout his childhood and even his teen years. He always excelled at academics. a straight A student through middle school and high school. An honor roll student in high school. A social studies student of the year. He attended math competitions. He was a self-taught musician, even at a young age, accomplished in guitar, percussions, keyboards. He joined the Marine Corps Reserves right out of high school. He then went and attended St. Thomas College, and he played with their touring jazz band. Unhappy with his reserve experience, Dustin decided to go active duty. While stationed in Okinawa, Japan, he enjoyed the country, the culture. He played in a rock band and took up scuba diving. But then his orders came down. He was being deployed to Iraq as part of Iraqi freedom. Dustin excelled at marksmanship training. The Marine Corps took notice and made him a marksmanship coach. Dustin helped train hundreds of Marines in that capacity. While in Iraq, Dustin witnessed a tragic event which had a profound effect on him. I too, in my lifetime and my career, have experienced profound things. It affects all of us differently. After Iraq, he was again stationed in Okinawa, Japan. In 2011, he was honorably discharged and went back to Minnesota. He then moved to California and attended the Musicians Institute. He graduated with a degree in audio engineering. Also, while in LA, he interned with Velvet Hammer, a large music management company. He played guitar for the Rooftop Revolutionaries, playing at premier venues around LA. He obtained a part-time job with Fox Sports as a post-production audio engineer. After a few years and no full-time positions available at Fox Sports, he could no longer afford to live there. He had to make the decision and move back home. Preferring a warmer climate and determined to find work in the entertainment or music industry, he decided Las Vegas would be a good option to look for work. He packed everything he owned and drove to Las Vegas. Once there, exhausted, he got a hotel room. The following morning, he discovered his car had been broken into. I remember that day well. Everything of value to him had been stolen. His expensive guitars, his audio equipment, his personal items were all gone. He was devastated. Eventually, he came back home again. That is when he met Caitlin. Soon after dating, she became pregnant with Ellen. We invited Caitlin into our home to live with us and made her part of our family. When Ellen was 7 months old, they decided to move to Las Vegas and make a life there. We visited often as flights were cheap. We even traveled there in the winter and spent extended stays with them. We spent considerable amount of time with Caitlin and Dustin and Ellen. During all those times, we never even heard them raise their voices to each other. There was one incident in our house prior to them, Dustin moving to New Hampshire, where they got into a heated argument. Dustin told her to leave and started to push her out the door. She pushed right back. She pushed him right back into the house. That's when I interjected and separated them both. Prior to moving to Las Vegas, Dustin had secured a job with the post office. After experiencing very long days, Dustin quit this job. Little did we know at the time, he had PTSD, which we found makes it difficult for a person to hold a job that they had no interest in. Not long after that, hard times came upon them. Caitlin worked several part-time jobs. Dustin worked occasionally when he could, but it wasn't enough. Dustin became depressed. He was failing his family and couldn't land that dream job that he always wanted. He was seriously considering suicide when Ellen came into the room and gave him one of her great big smiles. It affected him deeply. He knew at that moment just how important Ellen was to him. And he needed to find a way to provide for her. He went to the VA and he asked for help. After extensive testing, they found Dustin had severe PTSD. He had hidden it well for years. He was getting a VA disability, which provided a monthly check. This helped them to get back on their feet. The point to all of this is that until that terrible night in New Hampshire, Dustin was an accomplished, well-mannered man who endured great trials. Never in his life had he been in any kind of trouble, not even a traffic ticket. He did not drink. He did not use any type of drugs. His children were everything to him. He wanted to work things out with Caitlin so that they could stay involved in the girls' lives. I want to make it clear that Deb and I have never condoned what happened that night. What has been important to us is to find out how and why things could go so horribly wrong that night. How could a man this good commit an act so shocking? Finally, and just recently, we were able to read a portion of Dr. Pittman's 16-page report. A renowned PTSD expert from Harvard University. Dr. Pittman sheds a great deal of light on how PTSD played a major role that night. He made it clear that it was not Dustin who acted out. He had completely disassociated with himself. Upon researching disassociation in the psychiatric manual DSM-5, it means someone became someone else, not someone anything like themselves. Under extreme stress, he went into an altered state. He thought he had to protect Ellen from harm, and his ingrained Marine training kicked in. After he took the girls from the house, he stated he was overwhelmed with grief and didn't understand what had happened. As he stated to his mother that night and to the court during the trial, he was not trying to run away with the children. He did simply want to spend a little time with them before he turned himself in. We believe all of that to be true. He did not try and run from the police. He gave himself up cooperatively and peacefully. He told the police to be careful that there were kids in the car and told them where his weapon was. He gave a full confession to the police and hoped that they would understand and help him to make sense of things. That did not happen. A life was lost, and a family understandably demands justice. We only ask that you consider the man he was. A man who has never been in any kind of trouble his entire life. A man who joined the military and went to war for his country. A man who came back from that war wounded. He has fought depression and horrible dreams ever since. A man who would do anything for his children. A man who grieves every day over what he had done to Caitlin, to his girls, to Caitlin's family, as well as ours. Some people don't show grief and emotion as others do. Dustin is very internal. He keeps his emotions inside. But he is also a man who now daily asks God for forgiveness. Because of all of this, we ask that you consider leniency in your sentencing. May God be with us all today. Thank you, Judge.
Thank you. Thank you.
Mr. Jordan will now address the court.
I've always been horrified by what has happened. I've always been devastated by the fact my children no longer have a mother. I have pushed back from the very beginning with my frustrations about the why and against the misinformation about myself, Caitlin, our lives, and my families. I've always acknowledged, first and foremost, I took a life. And just as I said in my testimony, that life was important to me, important to our children, important to our family, important to everyone here. When I started crying, that was not planned or expected. Margaret even changed her direct because of it. That was genuine. I could not fathom that this had happened. I wept uncontrollably almost every waking minute for months after this tragedy. That led to me writing a death note and attempting to kill myself. By what can only be described as divine intervention, I am still here. And that is what led me to Pastor Justin and me coming to truly know Jesus Christ. I've poured my heart and soul out to him. I've spoken truthfully and with honor. Although I still wrestle with him in some areas, I'm at peace. When I talked to Caitlin asking if she wanted to stay at my home while she was here, she said no. She referenced trauma from her childhood and not wanting to feel trapped in an unknown place. She said, no one benefits from me being debilitatingly anxious. I knew that. I knew her struggles. God knows I have plenty of them myself. We tried to work through them together. I tried asking others for help, but the ultimate responsibility lies with me. Even though we were never married, our children created a bond, a forever bond between us, a sacred bond. I had a responsibility to her, and my choices made long before that night led to this. I had obligations to her that I did not meet. I failed. My pastor mentioned how I've been praying for Caitlin's family, and that was true even before I met him. Specifically for you, Lori, I have empathy for you. What I've witnessed from you is that of a loving mother and grandmother, someone who, even when pushed away, never gave up. I still vividly remember us all trick-or-treating around your house just 2 years ago. I remember all of us together on Christmas Eve, not even 2 years ago. I know this to be true. There is no greater pain in this world than that of losing a child. I grieve for you. I grieve with you. I'm sorry. To also point out, Tim, your last words, I can imagine the difficulty you had. It is no small thing, and I thank you. Your words are inspirational, and I do honestly mean that. I will not let Caitlin be forgotten. I never spoke ill of Caitlin to our daughters. I always wanted Caitlin involved in our children's lives. I have so many incredible memories with her. When she was pregnant with Elwin, I took her to my favorite place, Yosemite. My fondest moment was waking up to our campsite surrounded by deer, watching us and grazing before slowly trotting away. Then a few months later, Caitlin took me to Chicago, including visiting the beautiful botanical gardens and Six Flags, where Elwin got to ride a little roller coaster before she was even born. In Nevada, there was a beautiful oasis a few miles from our house with man-made lakes, horses, and dozens of peacocks freely roaming. We went there regularly and was a family routine I wish never ended. That was also where Elwin and Valen got to pet and ride their first horse. And Elwin and Valen, my life, my purpose, my everything. I envisioned great things for both of you, and I still do. Know that my love for both of you is infinite. Above all else, stick together, protect and love each other unconditionally. I will be there for you no matter what. Even when separated by distance, we're never separated by heart. To all my friends and family who have supported me and continue to do so, from the bottom of my heart, thank you. I'm truly blessed, and to each one of you, you'll never be forgotten. I ask, Your Honor, that you minimize my limitations as much as you are able, alongside allowing me to cultivate a life with my daughters and be the strong, positive influence I was always meant to be. I do not ask this for selfish reasons, but so that I may humbly serve God, country, family in full. Thank you.
Judge, as we conclude, I'd like to mention one United States Supreme Court case that highlights that the court ought to afford Mr. Duran's military service and his service-connected PTSD great weight when considering sentence. It's a 2009 case, Porter versus McCollum, 558 U.S. 30. In that case, the defendant, who was charged with multiple counts of murder and was facing the death penalty, was a military veteran who served in Korea and who struggled to regain normality upon his return from war. Likewise, in this case, Mr. Duran is a military veteran who served in Iraq and who bears the wounds of that service and who struggled to regain normality upon his return from war. The court in Porter found that Mr. Porter's defense counsel was ineffective in failing to present mitigation evidence related to his military service and the effects that his service had on him, because that mitigation evidence would have and should have made a difference in imposing sentence. The United States Supreme Court explained, and I quote, "Our nation has a long tradition of according leniency to veterans in recognition of their service, especially for those who fought on the front lines, as Porter did. Moreover, the relevance of Porter's extensive combat experience is not only that he served honorably under extreme hardship and gruesome conditions, but also that the jury might find mitigating the intense stress and mental and emotional toll that combat took on Porter. And this court ought to uphold our nation's long tradition of according leniency to veterans in recognition of their service when imposing a sentence in this case. The court should also find mitigating the intense stress and emotional toll that Mr. Duran's service took on him, as documented by his VA disability rating, the attached reports, and what you've heard and read today. In consideration of all the facts and circumstances of this case, in recognition of Mr. Duran's service and the permanent toll that his service took on him, we ask that the court adopt our sentencing recommendation and impose a sentence of 25 years to life in the state prison.
Thank you. Anything further from the state at this point? Okay, all right. Thank you. The council have given me a lot to think about, and I've been thinking about it nonstop the entire day, including before today. I will take a few moments, take a few brief recess, review my notes, review a few things that I want to check, and I'll be back to issue sentence and a few comments before I issue sentence. Thank you.
All right. Okay, folks, right now we're going to go ahead. Let's pray my gremlins have died. Go ahead back to the outside the jury's presence and the finishing up of the Walsh jury sentence, and we will be watching for the court to come back with their decision on his sentence.
Your Honor, I'd say page 15 going into 16, the impeachment by prior conviction.
All right. You've heard mention of other acts allegedly done by the defendant, namely, and I wrote a few things in there, recognizing the defendant doesn't want it, and that objection is noted and lodged.
Are you done?
I think she's done.
So, once again, I refer to our prior pleading. And on page 4,
Yes.
I'm asking that
And I encourage you to point out my errors despite my best efforts.
Here we go.
You'll see me up there marking it up as I always do. Maybe tomorrow will be the case that I get it all right. Still trying. All right, what's the next page?
Your Honor, for the Commonwealth, not so much a page, but circumstantial evidence. I know the court has direct and indirect evidence in there at 23. Would the court consider also including circumstantial evidence in that?
What page you on?
Page 23?
Oh, this is the plain language version of the circumstantial evidence.
Yes, Your Honor.
I don't have strong feelings about it. If there's some language you want to propose. I have used other language that refers to things as sort of the more old-fashioned language. This is direct evidence. The mailbox postman thing, I've delivered that a number of times. I think this is the more modern version of that. But if you want to propose some language, I'm not adverse to.
I want to welcome some very new members that I believe may be their first time here. I'd like to welcome True After Dark, Mark Plam Adon. I hope I didn't mess that up too badly. Gay or White Sen, Justin Hawley G1, 3RIN, Rachel Probably, Tark 59, Cynthia Tenson. Welcome to Hebs 86. Welcome to the Ada K show. I am June. I am the head mod. Ada is down right now. She is sick. And I just want to stop to say welcome to our channel. We hope you enjoy it and come back.
Explaining.
I'm just objecting to any additional language, and I'll wait and see what they propose.
All right.
I think this is sufficient.
It just talks about it in terms of direct evidence and indirect as opposed to circumstantial. I mean, it could be as simple as adding in sometimes called circumstantial.
Yes, Your Honor. With permission of the court, could the Commonwealth submit something later today?
Sure, that'd be helpful.
And if they do, which it sounds like, I'm going to then add, just to let the court know, an additional language as for inference that hopefully will counter what they're trying to do. But I'm just giving you for the heads up. I don't want to send you something and you would ask.
How about if I just say that is indirect evidence, sometimes called circumstantial evidence, and then you don't have to do anything this weekend. I mean, not this weekend. It feels like this weekend. Then you don't have to do anything tonight. I'm going to suggest that, but you can do what you want. All right. Anything else on the instructions?
Not from the Commonwealth.
All right. I really didn't mean to set off well, there's a word that comes to mind, but it wouldn't be judicial, so I won't use it. When I made my comments this morning about closing arguments. So let me just say, I'm always trying to stay a step ahead of you. It's not easy. And so I did start looking at this issue a couple of days ago. And I'm going to tell you what the cases I came across and sort of where my preliminary thinking is with regard to this. And maybe there isn't an issue. Maybe there is. But let me just tell you, we all know what I'm talking about, right?
Yes.
All right. So I'm going to give you some cites to some cases, and I'm going to tell you preliminarily where I think the line drawing is. And it's really preliminary because I looked at these like 4 days ago. Oh, Tuesday, December 9th. So I guess it was just yesterday. Well, no, that's not exactly when I looked at them. I think I looked at them this week and I sent them to my law clerk on Tuesday, December 9th, or vice versa. So anyway, here are the cases that I want you to take a look at. 2019, Commonwealth versus Ahern, 96 Mass Ave Court, 197. And that cites to Commonwealth versus Nelson, 468 Mass 1, a 2014 case from the SJC. And I also want you looking at Commonwealth versus Tavares, 27 Mass Appellate Court, 637. And in those cases, the SJC and or the appeals court is really talking about this issue of improper burden shifting and avoiding that in closing arguments. And really, it seems to me the one that's the closest to this is a combination of Ahern and Nelson. And look at those cases. I'm not going to get into a detailed description of what I think the similarities are to those cases. You're going to see it when you read those cases. But it seems to me preliminarily that while the Commonwealth should not comment that the defendant didn't testify, that would be improper. It seems to me that they could point out that there's no evidence that Anna died of any natural causes. I read the pleadings that just came through. And if that is where the line is drawn, you don't have to respond to this right now. I'm not, and frankly, the pleadings that just came through, I mean literally the ones that came through before the defense filed right before I went on the bench. I'm not sure or the allegations of reneging on a promise are impacted. But I'll qualify that by saying I read the pleading quickly and thought to myself, well, I didn't mean to start that. Back to how I opened this discussion. So that's where I think the line is drawn by those cases. And knowing that's where I sort of am drawing the line, take a look at those cases, and we'll discuss it again before the before the closing arguments.
Thank you, Your Honor.
Just to be clear, I think and we'll read the cases. What the court's saying is that you would think the Commonwealth could comment that something about
That there is no evidence that Anna Walshe died of natural causes.
And of course the defendant can make I just want to be clear about this because I think we might reach some common ground here.
That's what I'm trying to achieve.
and I'm responding to something that the Commonwealth represented. I'm not going to go into right now. So let's just stick to this if we may. So the government's allowed to say
what I just said.
And of course the defendant can argue there's no evidence that there was any homicide or any.
I expect you're going to.
I certainly, or I shouldn't be here, I suppose. But I can, once again, recite the evidence of sudden that came into evidence.
That's a little complicated because there's absolutely none of that ties it to Anna Walshe. There's no testimony before this jury that ties sudden, unexpected death to Anna Walshe, is there?
Judge, when the court asked me that, my response is the government's case is, using that phrase like defense attorneys like to use, it's built on a house of cards suggesting that a homicide occurred without any direct evidence of a homicide. And so another causation of death should be fair game.
Thank you.
To argue because it's equally consistent. And if, citing the Eremos and Cobb, if you have two equally inconsistent propositions, neither have been proved by reasonable.
Okay, folks, they are coming back, and I am getting ready to switch us over. Please just give me a moment.
Thank you. First of all, I would like to commend all counsel in this proceeding. I know it has been a difficult and lengthy one. I'd like to thank the family members, witnesses, and media for your patience. Any delays that occurred at any point during these proceedings have been to protect and safeguard the rights of all involved in these proceedings. Mr. Duran, as we know, 12 qualified and impartial jurors, all citizens of Coos County, have unanimously found that you have committed the crimes as charged by the prosecutor, and the jurors returned verdicts of guilty on those charges. Accordingly, it is my sworn, please be seated. Thank you. I will, thank you. Accordingly, it is my sworn duty under the state and federal constitutions to impose sentences upon you for those crimes. The sentences I impose will be in accordance with the sentencing laws as established by the New Hampshire legislature and within the protections afforded to you and on your behalf by those same state and federal constitutions.
The sentencing remarks that I make here today are based upon the guilty verdicts as returned by the jury. In deciding upon the appropriate sentences, I have considered all relevant factors in mitigation and aggravation. I've also considered all of the goals of sentencing as I am required to do, which include punishment, rehabilitation, specific deterrence, and general deterrence. Matters that I've considered include the state's sentencing memorandum, which is 23 pages long. In it, it concludes a listing of comparable sentences. And for those of you who are not, who thankfully are not familiar with this process, it is typical for both the state and the defense to provide comparable cases for them to argue, to indicate that a sentence should be more similar to this case or more similar to this other case. As we all know, and as both parties have acknowledged, no two cases are identical, especially in any murder case. Every murder case is unique. As I said, it is standard practice for the attorneys to argue by analogy relative to comparable sentences, and that is what has been done in this case by competent and experienced counsel on both sides. I've also reviewed completely every word the sentencing a detailed report from a military expert, Captain Art Cody, the report from a psychiatrist expert, Dr. Roger Pittman, 7 letters of support that were appended at the time, and 3 more letters of support received today and read into the record. I've also considered the impact statements from Mr. John King, Ms. Lisa Schmidt, hope I'm pronouncing that correctly, all others who spoke today in support of Caitlin, all of the family members who spoke today in support of her. I've considered Mr. Duren's military service. I've considered the impact of Mr. Duren's actions and my sentence on all families who have been so affected by this tragedy. I've also considered Mr. Duren's lack of a criminal record. I've considered all of the remarks from both the prosecutors and the defense counsel today. Certain matters that I've not considered include the following. Any allegations of criminal conduct that are not specifically before this court. Any other allegations of domestic abuse which were not before this court. However, I will point out that I have considered Ms. Nafzinger's stated fear of the defendant, which is demonstrated by virtue of the evidence proffered at trial, including by the defense relative to the existence of a plan. So I have been asked to not consider any other allegations of domestic abuse, and I am not doing so. However, I am considering Ms. Nafzinger's stated fear as it was indicated, as can be inferred and as indicated based upon testimony which was introduced during trial. I am not considering the status of any custody disputes or remarks made about guardianship or family law proceedings which are not part of this proceeding here today. Nor am I considering the impact of any financial disputes that may have occurred between the families after the events which are the subject of these proceedings. And finally, I am not considering, as requested by the defense, I'm not considering as part of my sentencing, there is no trial penalty, so to speak, which is I'm not holding against Mr. Duren his right under our constitutions to demand a trial and to hold the state to its burden of proof. I have thought a lot about this case before, during, and after the trial. I listened very carefully to the testimony of all witnesses during the trial and considered their credibility and demeanor, as did the jury. I know that they did. With respect to the goal of sentencing being specific deterrence, a lengthy incarceration does mean, with respect to Mr. Duren, that he has less opportunity to commit any further crime. Further, a suspended sentence with respect to the reckless conduct charge does assist the overall goal of having specific deterrence under the circumstances. With respect to punishment, Mr. Duren, you took a life. You argued at trial that it was justified, but the jury found differently. And the taking of a life necessitates a lengthy sentence. With respect to punishment, the court is not motivated by vengeance. There shall not be an eye for an eye, because an eye for an eye leaves everyone blind, as we know. And further, there must be some prospect, even if slim, but there must be some prospect for redemption and/or salvation. With respect to rehabilitation, for those of you who are not familiar, the New Hampshire Constitution does provide that the true design of all punishments is to reform and not to exterminate mankind. I would note that both proposals from the state and the defense do include the possibility of Mr. Duran earning time reductions for completion of programming. I understand the defense argument to indicate that those are not quite as substantive or substantial as the prosecution would have us believe, but I do note that those components are included in both proposals relative to rehabilitation. With respect to general deterrence, another factor which the court is entitled and must consider under these circumstances. The message that the taking of another life carries with it in this state and in this county is that the prospect of a severe punishment as a general, there must be a prospect of a severe punishment as a general consideration to reduce crime. Also, with respect to general deterrence, there is a domestic violence component to this case, which has been discussed and cannot be ignored. I would point to evidence that included during the trial, Mr. Duran, that you called your attorney about your options. And then almost directly after that, based upon my recall of the evidence, you did call the Berlin Police Department. What I would describe based upon as a proactive tactical choice with respect to the circumstances that were presented to you at the time. And by that, it indicates that you knew that you had the option of calling the Berlin Police Department when confronted with the circumstances on February 29th. You could have called the Berlin Police in response to the actions that were confronting you at that time, which you had done previously. But on that night, you chose not to. I also need to make a few comments about deadly force as a justification for homicide. I hope and I pray that everyone in this courtroom and all those in the sound of my voice never find themselves needing to use deadly force to defend themselves or others. However, if that does happen and deadly force is used, if the user chooses to use it to defend others or to stand his or her ground, the message must be sent that the user must also stand their ground to take the consequences of their action, to take responsibility for the use of deadly force, and not to flee the scene. I've considered all factors relative to specific deterrence, rehabilitation, punishment, general deterrence, as I've said. Further, there has been much presented of the challenges that you have faced, Mr. Duran. I recognize and sympathize with the impact of those challenges. I would also like to state that I have not heard quite as much about the gifts that you have received. You were born an American citizen. You have two loving parents and others who surround you who love you. You had natural traits that allowed you to excel at an early age, as has been indicated by the evidence I've received. You've been blessed with not one, but two healthy children, which so many others would envy you for. You were gifted a pistol by your father as an heirloom, and you had the right to keep and bear that pistol as a right under our Constitution. Despite all these gifts that have been bestowed upon you, nothing changes the fact that based upon all of the evidence, you shot the unarmed mother of your two young children in the head. I'm going to repeat that. You shot the unarmed mother of your 2 young children in the head. The citizens of New Hampshire and society at large demand, and the law that I must enforce clearly supports, a lengthy sentence under all of the circumstances that have been presented. So if I could have you please stand, Mr. Duran. By virtue of all of the considerations that I have described, and after considering all of the evidence during trial and during these sentencing proceedings, I am adopting the requested sentences from the state of New Hampshire with respect to each of the sentences. With respect to charge ID 223-7508C for a crime of second-degree murder knowing occurring on February 29th, 2024, you are hereby sentenced to the New Hampshire State Prison for not more than 45 years, nor less than life. There is added to the minimum sentence a disciplinary period equal to 150 days for each year of the minimum term of the defendant's sentence, to be prorated for any part of the year. Pretrial confinement credit of 650 days. This sentence is to be served as follows. Stand committed. With respect to restitution, you shall pay restitution of $12,007.69 to victim's compensation. Restitution shall be paid through the correctional facility or Department of Corrections as directed by the probation/parole officer. A 17% administrative fee is assessed for the collection of restitution. The defendant is to participate meaningfully in and complete any counseling, treatment, and educational programs as directed by the correctional authority or probation/parole officer. Subject to the provisions of RSA 651-A:22-a, the Department of Corrections shall have the authority to award you earned time reductions against the minimum and maximum sentences for successful completion of programming while incarcerated. Law enforcement agencies may destroy the evidence or return evidence to its rightful owner. You are ordered to be of good behavior and comply with all terms of this sentence. Further, you shall not profit in any manner for your role in committing these offenses, nor may you assign your rights to any monetary profit or financial benefit to any other person. Specifically, you may not accept any payment, enter into any contract, or sell rights regarding any book, film, television show, radio show, website, podcast, or any other writing, recording, broadcast, or internet posting relating to the murder of Caitlin Nafziger or to the defendant's actions therein. With respect to charge ID 221-7223C, I'm sorry, I skipped one. I'm going to go back. With respect to 221-7222C, which is a guilty verdict for reckless conduct with a deadly weapon, you are hereby sentenced to the New Hampshire State Prison for not more than 3.5 years, nor less than 7 years. There is added to the minimum sentence a disciplinary period equal to 150 days for each year of the minimum term of the defendant's sentence, to be prorated for any part of the year. Pretrial confinement credit of 0 days. This sentence is to be served as follows. 3.5 years of the minimum and 7 years of the maximum is suspended. Suspensions are conditioned upon good behavior and compliance with all the terms of this order. Any suspended sentence may be imposed after a hearing at the request of the state. The suspended sentence begins today and ends 10 years from release on charge ID 223-7508C. This sentence is consecutive to case number and charge ID 223-7508C. You are to participate meaningfully in and complete any counseling, treatment, and educational programs as directed by the correctional authority or probation/parole officer. Law enforcement agencies may destroy the evidence and return the evidence to its rightful owner. You are ordered to be of good behavior and comply with all terms of the sentence. Further, consistent with the state's request, you shall have no contact with the family of Caitlin Nafziger, which includes Lori Smith, Bailey Nafziger, Heather Nafziger, and Brenda Plamondon. The defendant shall have no contact, either directly or indirectly, including but not limited to contact in person, by mail, phone, email, text message, social messaging sites, or through third parties with ED and or VD, unless such contact is solicited by ED and or VD of their own volition, and such contact is in accordance with any applicable related agreements or court orders governing such contact. Further, the defendant must comply with any court orders concerning contact with ED and VD issued by any court having jurisdiction, including any orders issued by the Minnesota courts related to custody proceedings. Further, you shall not profit in any manner for your role in committing these offenses, nor may you assign your rights to any monetary profit or financial benefit to any other person. Specifically, you may not accept any payment, enter into any contract, or sell rights regarding any book, film, television show, radio show, website, podcast, or any other writing, recording, broadcast, or internet posting relating to the murder of Caitlin Nafziger or for your actions therein. Finally, with respect to charge ID 2217223C for a guilty verdict of endangering the welfare of a child, this conviction is for a misdemeanor. It does not include as an element of the offense the use or attempted use of physical force or the threatened use of a deadly weapon. The defendant is sentenced to the House of Corrections for a period of 1 year. Pretrial confinement is 0 days. This sentence is concurrent with case number and charge ID 2237508C. You are ordered to have no contact with the individuals set forth in 2217222C, either directly or indirectly, including but not limited to contact in person, by mail, phone, email, text message, social networking sites, and/or third parties. Law enforcement agencies may destroy the evidence or return the evidence to its rightful owner. You are ordered to be of good behavior and comply with all terms of the sentence. And further, you shall not profit in any manner for your role in committing these offenses, nor may you assign your rights to any monetary profit or financial benefit to any other person. Specifically, you may not accept any payment, enter into any contract, or sell rights regarding any book, film, television show, radio show, website, podcast, or any other writing, recording, broadcast, or internet posting relating to the murder of Caitlin Nafziger or to the defendant's actions herein. Finally, out of administrative completeness, with respect to charge ID ending in 2217721C, the guilty, which is the reckless second-degree murder charge, the finding of guilty will be maintained, but no sentence is assigned with respect to that charge, it being duplicative to the other charge of second-degree murder knowing. Again, by virtue of all of the factors I have considered today, I am adopting the sentencing recommendations from the state of New Hampshire. Attorney Durand, anything further at this time?
Nothing.
Attorney Kells.
Review of the sentence may result in a decrease or an increase of the minimum or maximum term within the limits fixed by law, but there may be no change in the sentence. Form for making application, if you wish to do so, is set forth below. Judge, I'll just ask the record reflect that I'm going to hand Mr. Durand's attorneys a copy of this form, and the state puts a similar application if they choose to apply.
Thank you, Clerk Kovalenko. To avoid any confusion, Attorney Kettles, again, I'll request again, any question or ambiguity relative to the sentences that are imposed for purposes of clarity. Okay. Okay. Anything further on behalf of the state? Anything further on behalf of the defendant? Okay. Mr. Durand, good luck to you, sir. It is my duty to remand you to the Coos County Sheriff's Department for further processing. The court will be in recess.
All right.
But there's evidence in the record before this jury that
I don't want to interrupt folks' thought process, but there was no objection whatsoever to the entire cross-examination of Dr. Atkinson. So all of that testimony is before the jury. It's not like we represented that, we made some representation that we will present evidence later, and so we made it.
so you can make an argument based on circumstantial evidence. That's what they're going to do in their case. I presume, I don't know what the Commonwealth's going to argue. I presume that they are going to draw a line between some of the evidence that was retrieved from the bags as being circumstantial evidence of things that happened before the dismemberment.
I agree.
So, for example, the slipper, the blood in the hair. I presume their argument is going to be that that happened before. That's circumstantial evidence, because once the foot covers are purchased, presumably they were purchased, there's a reasonable inference to be drawn, they were purchased to be used. That's evidence of something that happened before.
I think that's an argument.
I think that's an argument to be made based on the circumstantial evidence that's presented. But so I'm turning to you and saying, if you want to argue to the jury that there was circumstantial evidence that Anna Walshe died of some natural causes, I'm just asking, what's the circumstantial evidence upon which you base that argument?
That our argument fundamentally would be that all of the evidence that the government suggests was evidence that was created in the context of a homicide. There is no evidence that was not created after a death. And so since the jury heard all about not only just the possibility, but the probability that there is sudden unexpected death, then the jury needs to decide for themselves, could it have been sudden unexpected death? And all of that evidence that the government is arguing is evidence of a homicide could be only evidence of an attempt to conceal evidence that a person, using the language and conscience of guilt, a person is acting in a way not out of conscience of guilt, but out of fear or fright or anything of the sort. So why is it that, given the state of this evidence, we can argue our inferences that we believe the jury is allowed to make if they so choose, and if they decide that that evidence of concealment was evidence of a man reacting innocently and not with a guilty conscience, then how did Anna Walshe die? Maybe she died a sudden, unexpected death, and he tried to conceal it out of fear or fright, as is contained in the language of the Constitution. And so the jury gets to decide. And it certainly, the thrust of that argument is it brings me to you. And that's the evidence the jury heard.
Your Honor?
Listen, they may not want, I'm not precluding you from making that argument right now. And in fact, they probably want you to make that argument. I'll hear from the Commonwealth.
Sorry for interrupting, Your Honor. Your Honor, this started out with a motion that the Commonwealth not make any reference in closing to representations by counsel in opening statement. The Commonwealth does not intend to burden shift. The Commonwealth does not intend to refer to matters not in evidence. There certainly was testimony from the medical examiner talking about different ways people can die. The Commonwealth is certainly entitled to comment on that testimony, which is in evidence, but the Commonwealth is not going to comment on The opening statement.
All right.
That's why I was thinking we might find common ground.
Sounds like we have. Sounds like we have.
So as long as we're able to argue the possible manner of death and sudden unexpected death, I understand that the government's going to. All right. And we're going to say homicide, nonsense. Have we found common ground?
I think we have.
I think we're close.
Just keep talking. I don't need to be part of this conversation. I've directed you to the cases why I think they could say something short of commenting on your opening statement. And I've told you what I think they could say. And just be talking to one another.
Thank you.
Okay, do you want to pause this, June? Do we want to end this live and create a whole new live? I can do it real quick. I'll take about 5 minutes.
Yes, I got it queued up. Okay, well, Ada is getting ready to have us switch over to another trial. I'm going to give you a little bit of a rundown on it. The trial that's going to be coming up is and we're not getting into the political side. We're into the red rum side. It is Tyler James Robinson. He is currently being charged for the assassination of Charlie Kirk. The event happened on September 10th, 2025 at the Utah Valley University. He was arrested and charged with aggravated red rum and several related offenses, including discharging of a firearm, obstructing of justice, and witness tampering. Robinson has yet entered a plea and is currently awaiting trial in Utah. Right now, we're making an appearance in this case for one of the motion trials. Let me get it up here real quick. Um, um, the wrong way. Okay. So the hearing. Okay, here we go. I lost the screen for a second. I'm sorry, folks. Cook pushes for further limited media access in the case, and a coalition of national and local news organizations say an open court foster public confidence in court proceedings. So it appears that the defendant is trying to limit the media from streaming or covering this trial for other reasons that other than I don't know. I think he doesn't want. I think they're talking about not being able to get an impartial jury, the normal stuff like in other cases that we have seen and what we know about. So give us just a few minutes. We're going to be doing another live. Um, and Angela, do we want to go ahead and start it now while Ada's doing the setup on the next live? If so, we can go ahead and share it.
Um, Probably just wait and then we can get it started from beginning to end.
Okay. So what do you all think about the uh, sentencing on the last trial, on the last case we just watched? Do you agree with it? Do you not
It,
agree with it? Do you,
it's going to take me about another 5 minutes, y'all. 5 minutes.
okay. Honey, I do not know if we're going to be able to do teleportation because I know I don't, and I'm not sure, but I don't believe Angela knows how to teleport. So that would be totally in Ada's hands.
Yes, I'll set it up. I'll set it up. Just
Okay.
give me 5 minutes. I'll set it up.
Okay. So
Working
you're
on it as
actually getting,
fast as I can, y'all. I'm having to create everything from scratch. So just give me 5 minutes. If you want to keep running what we've been running, if you want to keep running everything for like we were, just keep it running. And then when I'm ready, I'll let you know.
okay. Well, that one was done pretty much. They're just within seconds, but I can bring up a little bit of the Ian Mitcham one to get started and fill in his time. So give me just a moment, folks, and I will be up with that. And I'm sorry I had an open mic earlier. I'm used to not having my mic um, unmuted, so I do apologize for the rudeness.
Okay.
Minutes ordered admitting 459, 467, and 469 through our back in the presence of Rick. Good morning to all of you. Welcome back this morning. And as we talked about yesterday, we'll continue on today with Ms. Marie Davis. She is on the stand. She continues to be under oath. And the state will continue.
Okay, the music that you're hearing in this clip is actually the station's hearing. It will go away.
Monday, we were talking about some of the photographs from the house. You had kind of gone through your role that first
You can mute that, June.
hours, but I hadn't quite finished discussing some of the photos that were taken that evening. So I'm going to go back to the beginning.
Evidence marker R, which was a red stain on the couch, which has now been cut out of the couch.
And I'm going to go to 469. What is that?
So this is after Allison has been placed in the body bag. This is called the medical examiner.
Y'all, this is going to be really thrown together. I will fix more later, but this is just something to get it up. I'm almost done. And we're going to teleport, hopefully. If I can get my mouse to freaking cooperate with me.
Now we're kind of moving to different areas of the home, but do you recognize this picture, 470?
Yes, it is the security box, the screen. I believe it was like a little tablet.
And as we move through some of these additional
June, I'm going to schedule this for 3:15, but you can go in as soon as you see it up on, okay? I'll tell you when you can go in.
Okay, so I'll stop this stream and go to the next stream, right?
Okay.
was it your job to then kind of look at the information that was coming from this tablet?
Are you kidding me?
Analyze it as
Sorry, guys, give me another second. Now all of it. Wait, June, don't do it. Yeah, don't do it yet. It's not accepting my thumbnail. It's saying that it is too big. And I've got to put a new thumbnail in. So just give me, let me change the thumbnail.
this information coming from this tablet is. But my question to you is, you weren't tasked with kind of compiling
And it shouldn't be. It's the same size as everything else.
as it related to the investigation.
No, I was not.
That might be a better question for a different witness.
Yes.
Okay. That was 470, so I'm moving now to
Seriously.
471. So this is that same tablet?
Yes, it
How can it?
And now what are we looking at?
So on this tablet, when you look
Give me a sec. Why does this stuff always happen when you need to go live?
all of the conditions of the doors throughout the house that have monitors on them.
And are you the best person to tell us which of these descriptions correspond?
Give me a second. I apologize. I want to thank June and my mods for taking care of everything. Y'all are so freaking awesome. Let's see if this works.
Okay, I'm gonna go ahead and stop the sharing right now. We'll talk a little bit while Ada is finishing up with the teleport. If we do not teleport, just please go into the other live, click on it, and join us.
Okay, it worked, June. Just give me a second and let me, no, wait.
I ain't doing nothing.
You're a go, June. You're a go.
Okay, let me get things set here. I'm gonna go ahead and end this live. If you do not teleport, please come and join us on our
A delay, I'm sorry, between you and me. You are now a go to teleport.
Teleporting. Any stream now.
Thanks for watching. Please comment, like, share, and most importantly, subscribe. I hope you have an awesome day. Till next time, take care.